Number 96 of the House of Commons Standing Committee on Transport, Infrastructure and Communities. Pursuant to the order of reference of Tuesday, September 26, 2023, the committee is meeting to resume consideration of clause by clause on Bill C-33, an act to amend the Customs Act, the Railway Safety Act, the Transportation of Dangerous Goods Act of 1992, the Marine Transportation Act, the Canada Transportation Act, and the Canada Marine Act, and of course to make a consequential amendment to another act. Today's meeting is taking place in a hybrid format pursuant to the standing orders, and members are attending in person in the room and remotely using the Zoom application. We left off at clause number 22 of Bill C-33, and to help us with clause by clause consideration, we have joining us once again representatives from the Department of Transport as well as our legislative clerks. So, to address clause 122, I open the floor. Mr. Muse.
So we'll pick up where we left off on that. So a question for the witnesses, because one of the things that we heard quite frequently from numerous witnesses on this bill going back to the end of September was the concern about the expansion of ministerial powers under this bill that many viewed as unwarranted and concerning. And so, would the addition of this clause after line 22 or 28 on page 78 help, would that in fact, in your view, put a limitation on ministerial powers?
Sorry, and you're referring to the BQ amendment, is that it? Okay, thank you. The proposed amendment wouldn't change the threshold with respect to what the minister would have to determine prior to making an order. And ultimately, given that it's a ministerial order, it would not change the views of the court on whether that threshold had been met. So ultimately, the one line itself does not significantly affect the use or potential for the minister to exercise the power.
So what you're saying then, in your opinion, is that this does not address those concerns that were raised?
I would say that the removal of that particular line, or the line itself, does not change the use of the power. The standard of review, which is proposed in the amendment, whether that is required to be reasonableness or correctness, the standard in Canadian judicial review courts is that ministerial orders are typically reviewed on a standard of reasonableness, looking at whether the minister's decision to exercise the power, given the facts known at the time, the evidence and the thresholds in the law, as well as the powers set out in the law, was reasonable or was one of the reasonable decisions that could be made under the circumstances.
So does the language in this particular edition, is that consistent with language in other Transport Canada acts?
The language in the proposed amendment would not be consistent with other Transport Canada acts. The ministerial order power proposed in Bill C-33 is generally consistent with other ministerial order powers found in other legislation.
Other legislation in other federal departments?
No, within Transport Canada.
Within Transport Canada. Sorry, repeat what you said previous. It's not consistent with?
The language in the bill is consistent with other ministerial order powers. The proposed amendment would result in a provision that is different than what is found in other transport legislation.
Okay. So is that a concern from your perspective?
I don't think I'm in a position to take a view on that.
Okay, so there's an inconsistency then. All right. Is there anything in the language here that should be modified or amended to make that clearer or make that consistent?
With respect to the amendment for the ministerial order power itself, the power is consistent as it is now. So the amendment would not lead to further consistency and only serves to make it sort of a novel or different exercise of power and a different standard of review from what courts or how courts would traditionally review ministerial order or the exercise of a ministerial order power.
Okay. So we're talking here about judicial review. So has there been precedent or case law that has led to the need for this amendment?
The case law is voluminous on standard of review of ministerial orders or of any discretion of exercise of administrative discretion. It's very extensive at the Supreme Court as well as at other appeal courts and the Federal Court of Canada. There are significant there's significant analysis that goes into the determination of whether to exercise judicial review on a standard of correctness or a standard of reasonableness. In general, a ministerial order power would be reviewed on a standard of reasonableness, but for a legislative provision that says otherwise, which would do that.
So the language refers to a few different circumstances: national security, national economic security, competition. Do those make sense from your perspective?
The threshold found in the proposed ministerial order power is really one of imminent harm. So it has to be imminent harm to those subject matters that you've listed, national security, national economic security, or competition. That is a relatively high threshold, all things considered. It's not just in the interest of these subject matters, but there has to, in fact, be imminent harm caused by the circumstances to national security, national economic security, or competition. And it has to also constitute a threat to the safety or security of persons, goods, ships, or port facilities, or the security of supply chains. It is altogether a relatively high threshold that already in the proposed provision of Bill C-33 that the minister would have to believe to be established or to be met by the circumstances, that is the facts and the law, before any order could be issued.
So you mentioned a high threshold, and we're talking about three different factors. Are there other factors that maybe should have been considered or are in your view missing from this that we should consider adding to the language of this clause?
So we added those three elements. The ministerial order power is effectively part of a broader, I would say, suite, which we've called the investment framework. So it's the Minister of Transport released a policy statement at the same time that the legislation was tabled, which really sought to ensure that supply chains were protected. And really, the investment framework, as it relates to port investment, there are three elements to it. The first one is the financial thresholds under which transactions are reviewed under the CTA would be amended for certain trading partners. So that would give the Minister of Transport and the Department a greater line of sight into what was happening at ports. We then also looked at data and making sure there was greater data availability so we could understand what was happening. There was a process by which the department could request data. And we would look at things from a gateway level perspective. So that would say, on the West Coast, that wouldn't just be the Port of Vancouver. It would be, for example, the Port of Vancouver, Nanaimo, Prince Rupert, etc. A part of that as well, as a part of this investment framework, was really the ability to, I would say I call it in case of emergency break glass. This is one of those situations where if all of those other protections that have been added in a part of the investment framework are unable to kind of protect the economy, competition, or that other factor that we considered, then this would be a mechanism that the minister could use. So, for example, early COVID days, we didn't, the government didn't know what it would actually need. And so this is meant to be that safeguard in case of extreme urgency or in case of concern or issues with respect to protecting Canada's supply chain for those three reasons. And they were well thought out. Competition, obviously. Canada Port Authorities need to be competitive. It's part of their raison d'etre. There's national security. That's something that, the government considers all of the time. But then there's also national economic security, which is something that obviously over the past couple of years, we're making sure that we're protecting supply chains, making sure that there's fluidity and there are no impacts to the Canadian economy. So those three elements were carefully considered, and that was, again, a part of that broader suite. And that was why those were brought into and a part of this legislation.
So that's sweet, the break glass in case of emergency. Is that something that is required in legislation, or would there not be tools that exist in other forms through whether it be through regulation or ministerial order or policy directives from Transport? I mean, there must be other tools that exist, and so I guess, is this necessary?
So the answer to that is actually yes. We we did our work, we evaluated what was available, what currently would address any concerns. There are certain protections, and what is here is what we've assessed that is actually needed to ensure that Canada has a great line of sight into port infrastructure investments and has the ability to step in should it need to. So, for example, I mentioned that financial thresholds exist under the Canada Transportation Act. One of the amendments under the CTA that is a part of this bill was reducing those thresholds from $93 million to, in some cases, a lower threshold of 10, unless we're prohibited by our trade agreements. And so really what that does is it exists, but we need to make a refinement to it so that we can see more, so that we're able to understand what happens at ports because of the fact that they're critical infrastructure and they're important to Canada to make sure that goods flow freely. So there are some, so that's an example of what currently exists, but a tweak that's needed. And this is an example of something that's new. And so this together is that suite of things that we're seeking to undertake.
And so this is, you mentioned earlier on that at the beginning of COVID, there was obviously a great constraint in our supply chains, and that had impacts on consumers and businesses and trade and all sorts of things. Is this an attempt to remedy that? And given the experience of what you saw in 2020 and what has transpired since, is this sufficient?
I think what this enables, this stems a lot from the Ports Modernization Review, which was initiated before the pandemic. I think what we can say is what the measures that are contained in this bill were definitely time-tested during the pandemic and made us realize that, yes, these are important and needed. We hope that these measures together will protect us in the future. I unfortunately can't say for certain because we don't yet know what's going to happen, but we hope that these measures together will ensure that the supply chain is protected and give us the tools that we need.
And so how would this work with, things like the Supply Chain Office and some of the other recommendations coming out of the National Supply Chain Task Force to address those issues?
Yeah, good question. I believe we've already tabled some information in terms of how the measures or how Bill C-33 helps to seek to address some of the measures contained in the supply chain report. I like to say that Bill C-33 is a bit of a down payment on what's to come from the supply chain office and so from that report. So this helps to protect supply chains, ensure fluidity, but it, we're not sure where the supply chain office is going. It's on its feet. There may be more coming from a port's perspective, but it may be more integration. This will certainly help our colleagues in the supply chain office as they seek to move forward with their work, because it will give them a lot of what they need to kind of advance and ensure that ports are those intermodal hubs which connect all other sorts of modes of transportation, so to make sure that they can do what they need to do.
So if this is a bit of a down payment, and a lot of that still needs to be fleshed out, is this putting the cart before the horse?
Another great question. What I would say is the time to advance the port's elements are now. The review concluded that ports were working well, but more was needed to kind of strengthen the governance of ports to make sure we had what we needed to prepare them into the future. We don't know what other measures will be needed as a part of the supply chain office or the report. These are a step in the right direction, and I'm sure anything else will not only complement this, but will build off what we have here. C-33 obviously is more port-specific, whereas the supply chain office is very much multimodal, and I understand there will be other elements coming from that as well.
Okay, given that testimony, and I know this is an amendment from Mr. Barcelou-Duval, he may wish to comment on that, so I'll stop there.
Thank you, Mr. Muse. I'll turn it over to Mr. Kirk before Mr. Badaway. Mr. Kirk.
Thanks very much, Chair, and it's good to be back before the Transport Committee here. I appreciate what my colleague Mr. Muse had to say about this clause, and I would just note that as soon as this clause is over, Chair, I would ask for a brief intervention. Thanks.
That's all, Mr. Kirk? Okay, thank you. Mr. Badaway.
I'm good.
Seeing no other debate, I'll go to a vote on BQ6.
Sure. There was a...
I thought Mr. Badaway had the floor.
He just ceded his time, so I'll turn it over to the clerk for a vote.
Mr. Badaway?
Against.
Monsieur Iacono?
No.
Madame Koutrakis?
No.
Miss Murray?
No.
Mr. Rogers?
No.
Mr. Kurek?
Yes.
Mr. Muse?
Yes.
Mr. Lewis?
Yes.
Dr. Lewis?
Yes.
Monsieur Barsalou-Duval?
Oui.
Mr. Backrack?
Opposed.
5 yeas, 6 nays.
Thank you, Madam Clerk. Block 6 does not carry. We'll now go to NDP
Thanks,
16.
Chair.
Yes, Mr. Kirk.
Thanks, Chair. I'm just looking for the appropriate moment, but just when it comes to Block 16. That's
NDP 16, Mr. Kirk. Yeah.
Yeah. Thanks, Chair. Just looking at the possible impacts that this has when it comes to the impact that it might have on the economy. I'm wondering if Ms. Heff or Ms. Moriarty would be able to comment just when it comes to some of the changes. I know that there's a bill before the House right now that has Bill C-58 I'm just wondering if there's been any consideration about the possible impacts between that legislation and what is being proposed here by Mr. Bacharach.
Ms. Moriarty? Oh, Ms. Heft, excuse me.
We would have to examine that legislation to look at any proposed correlation or impacts between this proposed amendment and what's proposed in C58. Having said that, I'm not aware of any conflict that would arise on account of the proposed amendment in NDP 16 with respect to an order not being used for the purpose of terminating a strike or lockout. I'll turn to my colleague for a policy perspective.
What I think I can offer in this regard is, if I look at NDP 16, it's about for the purpose of terminating a strike or a lockout or imposing a settlement or dispute. The intent of the ministerial order is not to actually be invoked in any of those scenarios. If anything, first of all, the order can only be issued to a Canada Port Authority or a person in charge of a port facility. And the order power would not enable the minister to compel a labour group striking to return to work. And so I would offer as well that because this is under the CMA, the purpose is more related to shipping and navigation within navigable waters, CPAs, and natural harbors. So I would offer that the relevance as it relates to a strike or a lockout doesn't actually apply under the CMA, and so it was never the intent for this to apply in any sort of labor situation.
Thank you. Next we have Mr. Bacharach.
Thank you, Mr. Chair. Perhaps just partly in response to Mr. Carrick's questions, I think this addresses something that is somewhat different from Bill C-58, which deals with the use of replacement workers in the case of a strike or lockout. This has to do with the minister's use of discretionary powers that are provided for in this act. And I take the point of Ms. Moriarty that the intention of the government is not to use this section in those cases. The reason we brought forward this amendment was to provide greater clarity, because when union members and union leadership read the bill, and because labor actions are sometimes construed as risks to national economic security or competition, or et cetera, it gets exaggerated in all sorts of different ways. The concern was that this casts a wide net and that it's worth articulating very clearly that it is not intended to be used in the case of labor disruptions. So I hope that answers the question around whether this is similar to Bill C-58. As was noted earlier, I think the risk is that it would be used to order people back to work, which is not something that C-58 deals with. C-58 deals with the continuation of activities using replacement workers. So related, I guess, in terms of the fact that they both relate to labor, but different aspects. I hope that helps provide a bit of the thinking behind why we brought this forward.
Thank you, Mr. Bacharach. Next, we have Mr. Badaway, followed by Mr. Lewis, followed by Mr. Muse. Mr. Badaway.
Mr. Bacharach just basically said what I was going to say, so we're good.
Thank you, Mr. Badaway. I'll turn it over to you, Mr. Lewis.
Thank you, Mr. Chair. Thank you again to the witnesses for joining us here this evening. So I want to try to see if I can tie in here, and I know that we're already done with BQ6, but I think this is very relevant to the conversation. So the way that if I'm reading this correctly, and I'm looking for clarification, please. So under such an order must not be exercised or performed for the purpose of terminating a strike or lockout or imposing a settlement in a labor dispute. What if there was an imminent threat or imminent harm to our port terminals? Would the minister be able to still use his powers to force it back? Force workers back?
So the order power can be used in the case of, like you had said, risk of imminent harm to national security, economic security, or competition. That constitutes a significant threat to the safety and security of goods, persons, ships, port facilities, or the supply chain. But the order can only be issued to a Canada Port Authority or a person in charge of a port facility. And so just coming back to what I had stated earlier, that in itself wouldn't enable the minister to issue it to anyone other than the CPA, or the Port Authority, or whomever is in charge of that Port Authority. So if you were looking at it from a perspective of a labor group, they would not be applicable in those terms.
Thank you, Ms. Moriarty. And just to build on that a little bit, if I could, please. So can you just give me a couple of examples, or just one example? What would be an imminent threat? What might an imminent threat look like at our ports?
You know what? I think, as I had said earlier, this is a part of a suite of tools, so that to make sure that the minister had the ability to protect the safety and security of supply chains. In terms of a threat, there could be anything. There could be a threat to, and remember, it's a threat to safety and security. It's a threat to competition or national economic security. So one of those three factors. So a threat could be, for example, maybe a port shuts down, or a terminal, operator decides it's not going to accept it. I believe my colleague used this example when she was here last week. Maybe there was a terminal that decided it was no longer going to accept goods from a country or something like that. I think back to COVID and protective equipment and those sorts of things. Is that a threat? I don't know, but there are lots of threats that could happen in the transportation space. I could come back to you with one. We haven't yet, encountered anything in that regard. But again, I think about natural disasters on the West Coast. There could be. There could be the pandemic itself. So depending on what the threat is, again, this is a measure of last resort and not something that would be meant to be implemented or used in a light fashion. It's a case of emergency. So we would need to look at the situation and the instances, the factors at the time, to do the assessment, to work with our colleagues to see whether or not the threat is real, to assess it, make best advice to the minister, and then take it forward. So this is not something that the department nor the minister would be advancing in any sort of, it wouldn't be advancing lightly, sorry.
Okay, thank you. That begins some clarity. So, and I'm glad that you brought up the pandemic, COVID. I would assume that would potentially be an imminent threat. Whatever it's called in the future, that certainly could be determined an imminent threat, I'm sure. Are there other ministries or other departments, not departments, ministries that have similar verbiage, similar powers, such as what's being proposed here?
certainly there's federal legislation with ministerial order powers, such as these, to deal with sort of urgent circumstances. The degree to which they're similar or different usually depends on the subject matter that they regulate. But generally, ministerial order powers are used for situations that are somewhat unpredictable, in order to ensure that the federal government has the appropriate tools to respond when there are urgent threats.
Thank you. And so I know that we are, I'm sorry, I am somewhat putting the cart before the horse, but I think it's important for this conversation. So we know that we have Bill C-58 in front of us in the House as we speak, at least on the floor of the House. And so I'm wondering, again, just for clarification, would this supersede Bill C-58 if C-58 did indeed get through the House without amendments? I don't expect you to be looking at a crystal ball. But would the minister's powers, so to speak, supersede what Mr. Bachrach is proposing here?
So if I could, I can't comment on Bill C-58, but what I can, share with you is that, this applies to Canada Port Authorities only, or those in charge of a port authority. So it is very limited in terms of to whom it could apply. So the scope of this is very narrow, and I understand C-58 is replacement workers in terms of legislation and those sorts of things. So possibly quite different. So in terms of what would supersede or not, like I said, this is quite narrow. And I don't believe there's anything in C-58 for the Minister of Transport as it relates to protecting supply chains.
Thank you. And are there other groups that have expressed concerns with the broad nature of this section? And I suppose if so, how will they be protected, or how will any future group not listed here, like labor, might soon be enjoying the same level of protection?
So if I could, I think this committee has heard from some that we're unsure of the process or what it actually meant. We had, as a part of our work, didn't really hear anything in terms of concerns with respect to the ministerial order. I think during, once it is implemented, should, the legislation pass, there will be quite a bit of rigor in terms of whether or not this actually gets used or implemented, and the scenarios and situations under which conditions it would actually be used. So it's not, it's like I said, it won't be taken lightly. There are a number of factors and due diligence that would need to be undertaken before the minister would even consider whether or not they would even want to entertain the use of such an order.
Thank you. And I think for now, anyways, the last question I have is, so I'd be very curious with regard to what the unions, such as the ILWU, would be saying about this. Has there been consultation with any of the unions with regard to this? Because I do believe to a certain extent it's going to kind of contradict C-58 to some extent. However, I do realize that it's very important that we have backstops in place if we have another COVID-19 that hits, if we have a natural disaster, to your point. We still have to make sure that we have commerce coming in and out of Canada. So that's important. But has there been any discussions at all with the unions and or just skilled trades workers as to what this implementation, how it could affect them?
So we did not have any conversations with ILWU or any trade unions. I believe committee has heard from that group respectively. What I can share with you is within the federal government, we have consulted with Labour Canada, who is the organization which really is responsible for, working with labour groups and taking care of any sort of labour actions. And there were no concerns raised. I would say, really, from our perspective, we did consult. Broad across the federal sphere, and there were no concerns raised in that regard.
Thank you, Mr. Chair. One final thought, and I really want to say thank you for your very thoughtful answers. I appreciate it. So my final thought is, do you, in your opinion, should there be more consultation done with the unions if specifically they haven't had a chance to be at the table? And if I'm wrong that they haven't had a chance to be at the table, then I apologize. But do you think that we should have more time to discuss this?
I'm sorry, I'm here to answer questions as it relates to the bill in front of us. I do not express an opinion at this time. Thank you.
Thank you, Mr. Lewis. I have Mr. Muse, followed by Ms. Koutrakis. Mr. Muse.
Thank you for your testimony. So I'm trying to determine from what I heard from your testimony. I mean, we had a strike at the Port of Vancouver. We had a strike at the St. Lawrence Seaway recently, both of which had a significant impact on our economy and our supply chains, which is, of course, what Bill C-33 is purported to help address, although I'd argue insufficiently. So I think what you're saying is this provision would not actually apply in those two recent examples.
That is correct.
And why is that?
Because this order is only for a Canada Port Authority or somebody who's in charge of a port facility. The relationship that exists from a labour perspective, Canada Port Authorities are not the direct employer of unions or anything like that. So they don't have the ability to step in and intervene. So it is kind of the way, the structure and the governance that's been set up as it relates to Canada Port Authorities. And again, this was never intended to address any sort of labour actions. If anything, it was entirely competition, national economic security, national security as it relates to supply chain fluidity and making sure that the minister has in his or her toolkit as a measure of last recourse to protect supply chains and anything resulting from it. So not in any sort of a labor context.
And so does this duplicate, or how does this work in congruence with other pieces of federal legislation that already deal with strikes and lockouts? Notwithstanding C-58, which we still have to.
I can't speak to other federal legislation that deal with strikes and lockouts, but what I can say is, given that this is for CPAs or for those that are in charge of those facilities, it applies only to them, and it is not any way related to or intended to address strikes or lockouts in any scenario.
So you just mentioned that it's not intended to address those situations. You talked about various situations and scenarios, and not taking this lightly. So maybe we can get granular, and you can tell us how and why this is different than other limitations that already exist on strikes and lockouts at ports.
So the ministerial order power that's proposed in section, for the proposed section 107.1, only allows the minister to make an order to require a port authority or a person in charge of a port authority to take any measure. In situations where there's an ability to order workers back or to order, some form of arbitration, it would apply to those individuals or even potentially to any person if it were that broad. But this particular formulation states that the minister can only, by order, require a port authority or a person in charge of a port facility, to take any measure. So it's really not targeted at workers at all. It doesn't allow the minister to order unions or other workers back to the table or to binding arbitration. It wouldn't relate to strikes or lockouts in any way. So from that perspective, it is distinct from labor legislation, including C-58.
So if that's the case, what's the point? What's the point of this provision?
I'm not in a position to comment on the intent of the proposed amendments.
So in your opinion, is this necessary? Are there not other pieces of legislation that already deal with this?
If I could ask clarification.
Sorry, Ms. Moriarty, I have Ms. Reed who has her hand raised. My apologies. Ms. Reed.
Sorry, my apologies. Thank you, Mr. Chair. And actually, I was probably going to say exactly the same thing that my colleague was going to ask, which was, could we get clarity on the question in terms of what the member was trying to ask in terms of what it was intended to deal with? Where I'm not clear on what the question is.
So we've heard a couple times that this is, break glass in case of emergency language. How likely is such a scenario to arise, and is this even necessary at all? I mean, it sounds like we're being overly prescriptive with this.
I think, as the colleague has noted numerous times, there are a number of scenarios that could possibly arise where such a provision would be used outside of the context of a labor dispute. So it's not intended for labor disputes, and I think we've noted that a couple of times in the context of the responses that were provided. However, there are a number of scenarios outside of that where a provision such as this may, in fact, be necessary. It's impossible to predict what situations may arise in the future, but this is really designed to deal with emergency situations and ensure that the Government of Canada has the tools at its disposal where it's necessary to prevent that imminent harm from happening to the supply chains, to national security of the supply chains, in case like those situations do arise.
You've just indicated that it's impossible to crystal ball scenarios where this may be necessary in the future, but so if we harken back to the beginning of the pandemic in March of 2020 and the supply chain issues, you just referred to the fact that this may be something that where this provision would have been used. So do you think that having this been in place in federal legislation at that time, what benefits would you have seen in the years 2020, 2021, 2022 as those supply chains were in crisis?
So in the context of the of previous actions, like we would have to go through an analysis of the situation and the evidence at that time, and then try to apply, what the provision would look like. I don't have all of the evidence and all of the information at hand that we can go through that whole assessment in terms of how or when this would be applied to various situations. We've been looking at scenarios, for example, in the context of geopolitical unrest, where where a terminal operator, for example, may refuse to accept certain shipments or refuse to load certain shipments, and ensuring that we are able to continue to preserve the security of Canada's Canada's competition, to be able to enable those types of in order to prevent that type of harm from occurring. So that would be certainly one example. Another example, for example, may be in the event of a climate disaster or some other event that would require certain actions to be taken by port authorities or terminal operators in a very short period of time. So those are the types of events that we are, we are looking at, but it is a twofold test. It is a high threshold. It is meant to be a high threshold. It is not meant to be an order that is used lightly and without appropriate due diligence and urgency and a risk of significant harm.
So you feel then this would have been a tool that would be helpful to have in your toolbox, and that, when you look back or you look forward at scenarios that may develop, this would have been helpful in addressing that?
We think that this was put forward in terms of legislative proposal in order to be part of the toolbox or suite of tools that can be used to address the possibility of imminent harm to national security or to the supply chain.
Looking forward, you mentioned geopolitical tensions, and obviously the world is a much more dangerous place than it was even a year ago. So you would see that this would be a good tool to have in the event that it was required for the government to use this provision to protect national security.
Sorry, I may have misspoke. I meant national economic security or the security of the supply chain.
All right. I'll leave it at that for now.
Thank you, Mr. Muse. Next, I have Ms. Koutrakis. Ms. Rodriguez, Ms. Koutrakis.
Thank you, Mr. Chair. My answer has been answered. My question has been answered. I've received the clarification that I needed.
Okay. We'll go to a vote, Madam Clerk.
Mr. Beraway,
Yes.
Mr. Iacono,
Yes.
Madame Koutrakis,
Yes.
Ms. Murray,
Yes.
Mr. Rogers, Mr. Muse,
Yes.
Mr. Lewis,
Yes.
Dr. Lewis,
Yes.
Mr. Korek,
Yes.
Monsieur Barsalou-Duval,
Oui.
Mr. Backrack,
Yes.
11 yeas, 0 nays. Carried.
NDP 16 carries. We'll now go to shall clause 122 carry. Oh, as amended, excuse me. Yes. Shall 122 carry as amended, colleagues?
Yes.
Go to a vote.
Request a recorded division.
Requested a recorded division.
Mr. Beraway,
Yes.
Monsieur Iacono,
Yes.
Madame Koutrakis, Miss Murray,
Yes.
Mr. Rogers,
Yes.
Mr. Muse,
Yes.
Mr. Lewis,
Yes.
Dr. Lewis. Sorry, I could not hear you. You're mute.
Yes.
Mr. Korek,
Yes.
Monsieur Barsalou-Duval,
Oui.
Mr. Backrack.
Yes.
11 yeas, 0 nays.
Clause 122 carries
Sure.
as amended. Yes, Mr. Kirk.
Thank you very much, Chair, and I appreciate the opportunity to get into the debate on this bill and how important it is, especially when it comes to national transportation infrastructure. I would, however,
Point of order, Mr.
Kirk?
Backrack.
Just so I'm not interrupting him when he's into the full, glory of his remarks. I'm just wondering, in the past when we've done line by line, we first introduced the amendment that we're going to be debating. And before Mr. Kirk gets into debating the many merits of NDP 16.1, I would just add that I believe that it's been dealt with. I don't know if that's what he was going to indeed be debating, but I think that's the next amendment that's coming up. And
No, we're on whether clause 123,
okay.
then
Well,
124, and then 125 is NDP 16.1.
Okay.
Yeah, so
Maybe
right now
I'll just.
we're discussing whether or not 123 will carry, and
Yeah,
I believe
thanks,
Mr. Turek had the floor for
Powerful
123.
amendment.
Thanks very much, Chair, and I appreciate this because certainly in light of our transportation infrastructure, it is certainly an important issue to many Canadians, and that's why, in part, why it leads me to move a motion that was put on notice, and I have a copy here for the clerks. Thank you very much. That was put on notice on December 1st, 2023. And Chair, it's an important issue that certainly we hear about so very often, and I look forward to being able to discuss this at length because certainly when it comes to the issue of the carbon tax, and how the carbon tax impacts the people of this country from coast to coast to coast. And for distribution, I appreciate the clerk giving that, and we'll move this motion in due course. But Chair, I have heard from constituents, from Albertans and from Canadians about the impact that the carbon tax has on their livelihood and the ability for them to truly make ends meet. But I want to share a number with you that is, I think, very, very telling. And according to Statistics Canada, there are 189,874 farms in this country. Now, the reason why I share that number, Mr. Chair, is because that number this past weekend actually changed. It changed by one. Now, that may not seem like a lot, but as that number goes from 189,000 to 874 to 189,873, Chair, it is the story that I would hope that the committee will oblige me sharing, and that's of Dawn. The story of Dawn and a multi-generational farm that she, up until this past weekend, ran. And that farm was Shirley's Greenhouse. Shirley, the namesake of her farm, was that of her late mother. And what is so very tragic about this story, Chair, is that she was forced to sell her operation. This multi-generational farm is finished. And in my conversation with her this past weekend, she asked me to speak up on her behalf and the many other farmers across our nation that are suffering the consequences of the carbon tax. So in due time, Chair, when I do in fact move this motion that I believe everybody now has a copy of in both official languages because that is so very important, it is the stories like Dawn and the fact that her multi-generational farm operation saw its end because of the policies of this Liberal government. So, Chair, what I intend to do here, just so that members of the committee know fully, I will speak for a few minutes and then move the motion and look forward to further discussion on this. But I would, in this conversation I had with Don, there's two parts of it that I believe are so very noteworthy that speak to something that is.
Mr. Clerk, the motion's already deemed moved, otherwise you can't speak on anything. So you are speaking to the motion that you've moved.
Perfect. Well,
just to be clear. Thank you, Mr. Clerk.
I appreciate the clarification. So, as I was sharing, the story that Dawn told me was very, very clear about how, over the last number of years, she ran a successful business, small business. A lot of the work she did was a greenhouse and about a 10, 15-acre garden. And what she had found over the last number of years is in the midst of resiliency planning for her farm operation, and I asked her if I could share this story, and she encouraged me to. She found herself in a situation where there were some unexpected things that happened in her personal life. And Chair, as a result, she had there were some unexpected costs that called into question some of that long-term planning that so many farmers work diligently to undertake, and just a few small life things. But what ended up happening is that she was able to make it work and worked very diligently to try and continue the farm that she was so proud to have been carrying on in the name of her mother. But what she found over the last number of years is how it came to the point, Chair, that there were two factors that made it untenable for her to continue her operation. And she outlined to me how, despite her efforts and the work that she put in and the extra hours that she endeavored to just make the math work on her being able to continue her family farm operation, she just couldn't, in fact, do it. So, Chair, what she described was two factors that added to the costs of her specifically monthly operations. And what ended up being the case, Chair, is that there were two line items that had grown almost exponentially. First was interest rates. Now, because of some of the personal circumstances she had found herself in, she ended up having to take on some additional liabilities in terms of debt. And over the time since she did that, the rising cost of interest rates had made it so that the cost of borrowing had increased dramatically. And although I could certainly talk at length about that situation and where the reasons for that, to keep and ensure that we're relevant on the discussion at hand, the second item that she had shared with me is how the carbon tax had increased the cost of her farm operation by the tune of thousands of dollars a month. And in the summer, she could make it work. She was able to ensure that to keep things at a minimum and whatnot. But Chair, I'm not sure if you've noticed this, but what has generally been the case in our country is that it gets cold in the winter. And in order to have high-quality food grow in a cold climate to which we face here in our country, you need to have greenhouses, and greenhouses have to be heated. And the natural gas costs associated with Dawn being able to heat her greenhouses became untenable, to the tune of thousands of extra dollars a month. So despite her best efforts, despite the fact that she had done everything that she could to make her operation work, because of the carbon tax and higher interest rates, we saw the demise of this operation that she was so very proud of. Now, I want to talk about the Minister of Agriculture's involvement in this because it is very, very key. But before I jump into that, I would emphasize something that I found really, really moving as I was hearing this story. As I chatted with Dawn on the phone, I could hear the emotion in her voice and how much she cared about the work that she had done for years, providing high-quality food. And for those around the table that might not be aware, what direct sale often means is that she would attend farmers markets. So people got used to seeing Dawn at farmers markets in the Didsbury area. That's the community that her greenhouse was located near. And what ended up happening is that although she was incredibly proud of the greenhouse that was named after her mother, instead of putting her logo on her trailer and vehicle, what Dawn did was share, not her own farm's logo, but she had the statement on her vehicle and the trailer that she pulled that said, "No farmers, no food." And it speaks to how seriously Dawn takes feeding the world. And in her case, feeding the folks in central Alberta. Now, I talked about the number of farmers in Canada, and I'll get into more specifics around the Alberta circumstances. And of course, I have a lot that I can say about Battle River Crowfoot and those good people that I represent in East Central Alberta. But what I would like to emphasize here is part of this story has a real tragic twist. And it's that as the Minister of Agriculture has been asked a whole host of questions surrounding Bill C-234, and its impact on agriculture and agricultural production and the needed carve-out. Certainly that's what Conservatives and the majority of parliamentarians, actually, including a number of Liberals at different points in time, have supported this important exemption from the carbon tax to ensure that Canadians have affordable food. I have heard the Minister, and as I'm sure we all have as well, the Minister of Agriculture stand up and say how he talks to farmers all the time, and that he hasn't heard the concerns related to C-234, which, Chair, I knew to not be an accurate statement the whole way along. But in my conversation with Dawn, here's what I found truly tragic. Only a few days before I spoke with Dawn, she was actually on a Zoom call with the Minister of Agriculture, where she shared directly her concerns, where she outlined the impact of the carbon tax. And as opposed to being empathetic and understanding that how, and at that point in time, Dawn shared with the Minister of Agriculture how she was not only speaking on behalf of herself, but so many others that she deeply cares for, those who provide the high-quality food that we need as Canadians and that our people from coast to coast to coast need. We see how there was that lack of empathy, and there was an unwillingness to understand, and to the point where she got frustrated with the Minister of Agriculture because at the point where it was acknowledged that there was a problem, he offered to reach out and try to help her situation. But it was at that moment that Dawn said, no, I don't want just help in my situation. We have to help all farmers. We have to help all Canadians. So, Chair, the reason why I share Dawn's story as the one farm that no longer exists because of the carbon tax is because it speaks to whether it's the other 189,873 farms that are left, or in the case of Alberta, the approximately 41,500 farms, or in the case of Battle River Crowfoot, the approximately 4,715 farms, of which I am proud to, and my family for now 5 generations, are proud to have been a part of that farming legacy, Chair. It speaks to how, as Canadians, we have the opportunity to be leaders. So in this motion, we talk about how frustrating it is that senators were delaying, and what ended up being the case is gutting the passage of Bill C-234 and taking out some of the most valuable aspects of that. And the fact that now that they made the amendments, this motion is so very relevant because as it comes back to the House, where there will likely be changes and it'll go back to the Senate. Chair, we need this carve-out. We need the fact that that we have the potential as a country to feed our people with high quality, affordable food. Yet we have politics that seem to get in the way. Now, I want to get into some of the details here in a moment about what exactly the situation on farms is. But, Chair, I think it's important to mention something, because this is not the first conversation around carbon tax carve-outs we've had even this fall. You know, coming into the fall sitting of Parliament, we had only a few weeks into it. We saw that the Prime Minister, doing what seemed to be a hastily arranged press conference up on the 3rd floor of this very building, where he announced that a few Canadians, just a few, would receive a break from the carbon tax. He proposed that there would be an exemption granted. to Canadians that are that heat with home heating oil. Now, home heating oil is the reality that, especially in certain parts of the country more than others, I know in Alberta, where we have an abundance of clean, green Canadian natural gas, we don't have as much heating oil, although there is some. But what we saw the Prime Minister undertake was to give a carve-out to a small group of Canadians who were impacted by the carbon tax. Now, it worked out to be about 3% of households in this country that got that carve-out. Now, when one looks at the cruel, crass politics of the situation, you saw the Prime Minister's poll numbers and an absolute nosedive, specifically in Atlantic Canada, Chair, where so many of I have no doubt the Liberal MPs were, and in some cases because they said very publicly that this was the case, that we're facing immense political pressure. And as the Prime Minister's poll numbers were falling through the floor, action had to be taken. And we heard just some astounding statements that, for example, Minister Hutchings, she said about if you don't vote Liberal, don't expect an exemption. Like, my goodness, how absolutely embarrassing that you would only serve people who vote for you. Certainly, I would hope that members around this table wouldn't, if somebody came up to their office door, turn them away because they didn't cast the ballot, put the X beside the right person. An absolute embarrassment. We heard the Minister of Northern Affairs say in this conversation that he had never heard that this was a concern. We had the minister, the only minister, one of only two Liberal MPs from Alberta, Minister Boissonneau, say that he simply wasn't concerned about the costs that were associated with the carbon tax. We saw that as a government was desperate because of the costs being imposed because of the carbon tax, they created this carve-out for 3% of the population. Whereas the other 97%, Chair, were not so lucky. So as we come into the fall session, there was this understanding that the Prime Minister was willing to engage in carve-outs because it was a de facto admission that his carbon tax was costing Canadians. Now, when it came to home heating oil, it was costing Canadians significantly for them to be able to heat their homes. Now, what's interesting is in the conversation surrounding the carve-out, we had a political firestorm that ensued. In fact, we had economists from across the country saying publicly that it's obvious that this is an admission that the carbon tax and pricing and is not working, an admission that it costs Canadians more than it's worth. And in fact, there was one headline that even suggested that the carbon tax is dead. It's just a matter of time now. But what was interesting is in the follow-up to that initial carve-out, Chair, is we saw that the Environment Minister, convicted climate activist Stephen Guilbeault, and I say convicted because he was convicted of a crime while he was a climate activist in a previous career. He made the statement that if there were any more carve-outs, he could expect to resign. And although some of us certainly wouldn't be disappointed if that was the case, I found it very, very interesting how all of a sudden you saw a doubling down on a whole host of things, but specifically the carbon tax, how now that there was a 3% carve-out, the Prime Minister was unwilling to go any further, was unwilling to see that there would be a willingness for some common sense when many Canadians who are at this point in time when we have what is an affordability crisis. I hear about it all the time. We had so many examples where there was just a tone deafness and unwillingness for there to even be a conversation that maybe the carbon tax was in fact simply not worth the cost. So when it comes to the conversation around home heating, of course, that is a key part of this larger conversation. But then we had Bill C-234. This bill that would provide practical relief for farmers. And I mentioned that I will get into the on-farm dynamics of this, because there's a lot of misinformation, or what I would suspect is simply a misunderstanding. And I'll use some examples actually from question period and what the Prime Minister referenced here today. But we saw how the Environment Minister was so quick to demand that the Prime Minister and the rest of the Liberal Party follow his heed by not allowing any further what have come to be known as carve-outs. Now, Conservatives believe fully that we need to axe the carbon tax, and we are calling for that to be the case. And Pierre Poilievre, as leader of Canada's Conservatives, has made it very clear that we look forward to being able to fight a carbon tax election where Canadians will be able to make that choice. However, Chair, when it comes to practical relief that could be provided now, my colleague Ben Lobb, Member of Parliament, he's been around here for a little while, not too long, but a little while. He had put forward Bill C-234 that was not the first time that this had been introduced. In fact, when the Prime Minister called the unnecessary election in 2021, at the time when he promised that he wouldn't, when we were still in the midst of the COVID-19 pandemic, and which basically ended up returning Parliament almost exactly to the way that it was prior to that point in time.
Point of order. Point of order.
Yes, Dr. Lewis.
Yes, I have two conflicting notices with respect to the duration of this meeting, how long we're going to be in this meeting for. And I'm sorry, it may be my office that misinterpreted. So I would just like clarification on the correct start time, which I presume was 4:30, because that's what time I showed up here. So I think that they got that right. And they're very, very competent. I just think that because we were served notice, I think I only received notice that the time changed from 7:30 to 4:30 about 1 hour before. So there was a little bit of confusion. So I would just like clarification on what time we expect to be here till, and if everything is in order for us to be here for that duration.
Thank you, Dr. Lewis. To answer the first question, how long we stay here for is at the discretion of the members. How long we are able to stay here with regards to resources is 11:30. The notice was sent out from 4:30 to 11:30. Thank you, Dr. Lewis. I'll turn it back over to Mr. Kirk.
Thank you very much, Chair, and I appreciate that clarification. Thank you, Dr. Lewis. As I was mentioning before, my colleague Ben Lobb, who's been a Conservative MP for a number of years, including serving in Parliament under former Prime Minister Stephen Harper. He took the what was a bill that had been put forward in a previous Parliament, the previous Parliament to this one, and because it had seen a great level of support. Now, although it's been politicized now to the point with the Environment Minister threatening to resign, but there was, in fact, cross-partisan support at different points in time for this bill. And when it was introduced in the previous Parliament, I believe it was my colleague John Barlow who had brought it forward. It had made it through the House of Commons, had gone to the Senate, but then died on the order paper when Justin Trudeau called that unnecessary election in 2021. But, Chair, when my colleague Ben Lobb was able to...
Sorry, Mr. Kirk. Yes, Mr. Badaway.
Mr. Chair, I was giving the member the benefit of the doubt in terms of where I was going to go with this, and the more I'm listening to the testimony or his intervention, and I look at the motion, and I've done it 3 or 4 times now, I can't see how this motion is actually relevant to this committee. I know another committee had brought this up in I'm not sure, sometime this week, whereby the same attempt was brought forward by the Conservatives to bring this motion. I believe it was international trade, and there they ruled it in terms of not relevant for the committee. And now that I see it being brought here, I have the same concern that this is not, in fact, relevant to this committee. So therefore, I'm asking, Mr. Chair, that we rule it not relevant and move forward
on the point of order.
Get back to Bill C-33.
Thank you, Mr. Badaway. I would have to agree. So I will rule it out of order.
Okay, Thank you, Chair. Then I look forward to being able to move the other motion that Mr. Stroll had put on notice, I believe on December 1st, of which I do have a copy of
Mr.
that, being able
Now
to
that it's out of
ensure
order, you no longer have
that.
the floor, and I will go to a vote on shall clause 123. Carrie.
Point of order, Chair.
Yeah.
You didn't actually allow me to respond to the point of order as I did, and I believe the record would show.
The clerk, and I do not need to do that, and therefore we are now going to a vote on shall clause 123.
Challenge of the chair. Point of order.
We're going to a challenge of the chair.
Yep.
Madam Clerk.
Mr. Baraway,
Yes to sustain.
to sustain. Monsieur Iacono,
Bien sûr, oui.
Madame Koutrakis,
Yes to sustain.
Miss Murray,
Yes to sustain.
Mr. Rogers,
Yes to sustain.
Mr. Muse,
No to challenge.
Mr. Lewis,
No to challenge.
Dr. Lewis,
No to challenge.
Mr. Correct,
No.
Monsieur Barsalou Duval,
Oui.
Mr. Backrack,
Sustain.
7 yeas, 4 nays. Sustain.
Thank you, Madam Clerk. We'll now go to a vote on clause
Point of order,
123.
Mr. Chair. Point of order.
Apologies, Mr. Strahl. I already went to a vote. You can get your point of order after
Well,
that.
you didn't even call for debate on the motion, on the clause.
There was nobody on the speakers list.
That's because you cut off the motion and went straight to a vote.
I'm just sorry I called the vote. I'm going to have to send it over to the
Okay,
clerk.
well, I'll look forward to Mr. to taking the floor after this vote to move another motion. Just so you don't call another motion for a vote before I have an opportunity to speak.
Mr. Baraway,
Yes.
Monsieur Iacono,
Oui.
Madame Koutrakis,
Oui.
Miss Murray,
Oui.
Mr. Rogers,
Yes.
Mr. Muse,
No.
Mr. Strahl,
No.
Mr. Lewis,
Nope.
Dr. Lewis,
No.
Monsieur Barsalou Duval,
Oui.
Mr. Backrack,
Yes.
7 yeas, 4 nays.
Chair.
Thank you. I want to recognize Mr. Strahl on 124 now. I promised I would give you the floor on that.
And on the speaking list, Chair.
Mr.
Now,
Chair,
for 124, I have Mr. Strahl and I have Mr. Couric.
Right, and Mr. Chair, simply because you call a number at the start of this, I guess you're trying to prevent us from exercising our right to move motions that have been duly put on notice, because that's what just happened. Mr. Kirk was not given an opportunity to address the arguments of Mr. Badaway, who was able to move a motion on a point of order, which I think in and of itself is out of order. So, we can talk about clause 124 for some time, I guess, if that is the way that the chair wishes to proceed, or he can recognize the rights of members of parliament to move motions
Point
that
of order,
have been
Mr. Chair.
duly noted.
Point of order, Mr. Chair.
Yes,
Point
Mr.
of order,
Iacono.
Mr. Chair. So, if I hear well, virtually, we were on 123. Opposing colleague was speaking, and my colleague Vance asked for a point of order on relevance. Following was the challenge of the chair's position to go forward. So I think that matter has been decided, voted, and we need to move on to the next. I don't think we need to go backwards and get more explanation if the chair has already taken a position and his position has been challenged and a vote has been held. So I think it clarifies that matter and it's time to move forward. So, Mr. Chair, I would like you to see to it that we move forward and not reiterate on what happened in the past. Thank you, Mr. Chair.
Thank you, Mr. Iaconu. I would tend to agree. We're now at the issue of 124, and Mr. Strahl, you have the floor, followed by Mr. Kirk, who's also expressed interest in speaking to 124.
Right. And Mr. Chair, I believe that my privileges actually were violated by not giving me a chance to speak to a clause of a piece of legislation that we are debating by simply calling a vote on it and saying there's no speakers list, by not allowing, by not even calling for debate and simply moving to a question. How are we to know that we were going to go back into the legislation when Mr. Kirk was in the middle of debating a motion? So by failing to allow for a debate on a clause of a piece of legislation, you have violated the privileges of all members of this committee. So I would like to move a motion that we debate whether or not my privileges were violated by the chair when he refused to call for debate the previous clause that before calling for a vote. So that is the motion that I would move, that you have violated my privileges by not allowing us to discuss a clause of this bill and simply slamming the door and moving to a vote. That is not how we have operated for the entirety of this debate. That is not how we've operated for the entirety of our consideration of Bill C-33. So to get rammy now and start to push this through in a way that we have not operated in, I recognize that the chair and the government doesn't like when members of parliament in the opposition exercise our rights and use the tools at our disposal to hold the government to account and to move duly accepted and duly moved motions at the time of our choosing, as is our rights as a member of parliament, that they want to simply end that discussion and move on to something that they would rather talk about. But that is not what the rules allow for. The rules call for members of parliament to have the opportunity to discuss, debate, consider, amend, propose changes, hear from all sides, and then make decisions. It is not for the chair to suddenly say, I call the vote the very second that Mr. Badaway gets his way and a motion gets shut down. So, Mr. Chair, I've always respected your commitment to fairness. I've always respected how you have been neutral in that position, but I can't quite believe what is happening here tonight, where there is a departure and a decision to simply ram these motions through without giving us an opportunity to debate. So you've ruled Mr. Kurik's motion out of order. There is another motion that deals specifically with the transport component of Bill C-23. That motion is in order and does specifically deal with this issue. But it is very clear that the rights and privileges of members of parliament are protected by our standing orders. They are protected by, quite frankly, the Constitution, and they are to be limited only in very extreme circumstances. And a privilege motion actually takes precedence. We know this in the House. A privilege motion takes precedence over all other matters. When a privilege motion is moved, all other legislation, anything else before the House is set aside, because the rights and privileges of members of parliament are to supersede the rights and privileges of the government, who might not want them to be exercised. They are sacrosanct. They are, quite frankly, something that we should be very, very concerned when any member, not just those who wear our team colors, are impacted by. So this is the sort of thing you can bet that Liberal members of Parliament, when they were in opposition, would have raised hell about. They would never have accepted this sort of clauses being rammed down our throats without the ability to even discuss them for a minute, to have a single word brought forward before they were voted on. So that supersedes, quite frankly, whether or not the chair is sustained by a vote. This is something that is bigger than that. It is something that touches on the very core of what we do in this place. So I know that the government's frustrated that there have been concerns raised with this bill, Bill C-33. We heard it in the numerous meetings that we had with testimony, none of which were particularly beneficial to or spoke about the benefits of the legislation. They were all very critical of the legislation. I know they didn't like that. I know they don't like that we're going clause by clause through the bill, and they don't like that a member of Parliament might want to speak about issues about cost of living and the cost of transporting goods and the sort of thing that Mr. Badaway shut down with the assistance of the chair. But Section 116 of the standing orders say that in a standing, special, or legislative committee, the standing order shall apply so far as may be applicable, except the standing orders as to the election of a speaker, seconding of motions, limiting the number of times of speaking, and the length of speeches. And specifically, it talks about the end of debate. And it says in Section 2A, unless a time limit has been adopted by the committee or by the House, the chair of a standing, special, or legislative committee may not bring a debate to an end while there are still members present who wish to participate. A decision of the chair in this regard may not be subject to an appeal to the committee. B, a violation of paragraph A of this section may be brought to the attention of the speaker by any member, and the speaker shall have the power to rule on the matter if, in the opinion of the speaker, such violation has occurred. The speaker may order that all subsequent proceedings in relation to the said violation be nullified. So, Mr. Speaker, this is a very, very serious section, and it says very clearly, while there are still members present who wish to participate, not who are on a list that didn't exist before debate was decided to be closed, before it was shut down. So this is very much a serious issue, and one that we will take very seriously, because in attempting to get a bill passed by an artificial deadline, there is now clearly an attempt, and there has been in this committee, a violation of the rights of the members of this committee. All of the members on the Conservative side of this table were prepared and willing to speak to the clause that was upon which debate was ended artificially. And again, as it says here, a decision of the chair in this regard may not be subject to an appeal to the committee. So quite frankly, it doesn't matter that even if once I stop talking, there's an attempt to have this matter, that the chair's ruling be sustained, because again, this is not a matter for a majority vote on the committee. Members' privileges are not subjected to the tyranny of the majority. Members' privileges are protected by our standing orders and are protected by our roles, our the people that we're sent here to represent. It would be quite something if we could, instead of having our rights protected, have our rights dictated to us by the majority of committee members who find them to be inconvenient tonight. that is quite frankly something that we can't tolerate and something that should supersede any of the other things that we were going to talk about here tonight. So we've seen this time and time again where this is attempted, where there's an attempt to shut down debate. We know that that has been done in the House of Commons a record number of times, shutting down a debate. There's a process in place for shutting down debate, which the government promised in their election campaign in 2015 that they would never use the rules of the House to shut down debate. We've seen them break that promise time and time again, both in a majority and with the help of the NDP in a minority government. They've done that on numerous occasions, hundreds of times they've shut down debate. But that is by a motion. That is using a process that is in place. The speaker doesn't simply get up and say, debate is over, we're having a vote right now.
Thank you, Mr. Strahl. Thank you. I appreciate your comments on this. You have raised that you feel that this is a point of privilege. My ruling is that it is not a point of privilege.
Point of order.
I'm ruling right now, Mr. Carrick, and so I'll finish my ruling, and then I can turn the floor over to the next person who raises their hand and who I turn the floor over to.
But point of order.
I'm responding to Mr. Strahl and ruling on his point of privilege.
Yeah, but you're not able to do that.
I am able to do that according to the clerk who's next to me and shares the rules with me. So I am ruling.
So point of order, Chair.
That it is not a point of privilege. I manage the speaking list as the chair of this committee. Over 122 clauses so far. I have been very diligent in ensuring that that list has been followed. In this particular instance, I had no names on that list, and I went to a vote.
Point of order, Chair.
Immediately following that, I turned the floor over to Mr. Strahl to address 124 because he had raised his hand to address 124. That is the ruling, and I now turn it over to committee members on that ruling.
Point of order.
Yes, Mr. Carrick.
Thank you, Chair, and with the utmost respect to you as the chair occupant and, of course, our exceptional clerks that operate in the House, I would refer you to page 154 of Bosch and Gagnon, 2017, where Chapter 3, it talks about privileges and immunities, where it says, unlike the Speaker, the chair of a committee does not have the power to censure, disorder, or decide questions of privilege. Should a member wish to raise a question of privilege in committee, or should some event occur in committee which appears to be a breach of privilege or contempt, the chair of the committee will recognize the member and hear the question of privilege, or in the case of some incident, suggest that the committee deal with the matter. The chair, however, has no authority to rule that a breach of privilege or contempt has occurred. So, Chair, with all due respect to you in that role, Mr. Strahl was still speaking, and I believe you have a speaking list on the point of privilege that he has raised, and to ensure that we are in operating in accordance with the rules and procedures of this place and the privileges and immunities associated with us as duly elected members of this caucus. The debate should be allowed to continue, as is very clearly articulated in the rules that help make sure that all members, including members of the government, backbench, party members, opposition, and otherwise, are able to do the jobs that we've been sent here to do.
Point d'ordre, Monsieur le Président.
I'll recognize Mr. Barsley Duval, but I'm just conferring with the clerk really quickly. I'll turn it over to Mr. Barcelou-Duval on a point of order.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chairperson. Now, I notice that there are 5 Conservative members in attendance at the committee today. I know that there's nothing that prevents a greater number of members from being present than the normal quota or contingent of members per party. But when it comes to votes, especially in the waiting, but I think it's important to know which members have the right to vote and which do not. I think that otherwise might lead to a lot of confusion. Thank you very much, Mr. Barcelou-Duval. I'll just ask Mr. Shaw to confirm who are the voting Conservatives. Mr. Shaw, Dr. Lewis, Mr. Lewis and Mr. Muse. Is that correct?
Oh, Mr. Currick.
And not Mr. Currick. Is that correct, Mr. Stroll?
I think the clerk has the list of our members, but
that's it. Yeah.
Yes, of course.
Okay.
The members are here. They're not.
C'est bien ça, Monsieur.
So that is correct, Mr. Barcelou-Duval. Thank you.
With regards to challenge, did you want to? Is that not what you wanted to do? Okay.
So point of order, Chair. I believe that Mr. Strahl still had the floor.
Ruling.
You made your ruling.
Yeah. So there's nobody that can speak to the ruling of the chair at this time. The members can challenge
Point
the
of
chair.
order. Point of order. I'd like to speak to that matter.
You can't speak to a ruling of the chair. You can challenge the chair, Dr. Lewis.
Then I'd like to challenge the chair.
Thank you, Dr. Lewis. I'll turn it over to the clerk.
So if you vote yes, then you sustain the decision of the chair. If you vote no, you are appealing the decision of the chair. Mr. Badaway?
Sustain.
Monsieur Iacono?
Okay, that's where we're at.
Vous étiez en mute, Monsieur Iacono.
You were muted, Mr. Iacono. I didn't hear you.
Sustained.
Madame Koutrakis?
Sustain.
Miss Murray? Miss Murray? Miss Murray, could you hear us?
Okay.
I'm sorry, Iacono.
Yes.
Okay. Mr. Rogers?
Yes.
Mr. Straw?
no.
Mr. Muse?
No.
Dr. Lewis?
No.
Mr. Lewis?
No.
Monsieur Barcelou-Duval?
Oui.
Mr. Backrack?
Yes.
7 yeas, 4 nays.
Point of order,
Ruling
Chair.
The chair is sustained. Now we will go to...
Point of order, Chair. I'd like to be on the speaking list, and just to ensure that that does in fact happen, I am raising a point of order so that
I actually
we
have
don't move
Mr.
into that.
Strahl on the speakers list for 124, Mr. Currick already. If you'd like to add your name to the speakers list, it'd be a pleasure to do so.
That's why I raised a point of order, to make sure that it didn't get missed.
Perfect. Always good to be diligent. Mr. Strahl, the floor is yours.
Well, thank you very much, Mr. Chair. And I just to get some clarification there, when am I able to move a motion? Because there's been, seems to be a moving target as to when members of Parliament can exercise their rights to move motions that have been duly submitted with notice, translated and distributed to members. So at what point in the discussion can I do so now, or do I need to...
The rules state, Mr. Strahl, that you can do so in between the clauses, not when I've already called for debate on a clause. So right now we're discussing 124, but as was the case with Mr. Currig that I recognized and was able to put forward a motion, you can do so as he did in between clauses. So right now, Mr. Strahl, just for clarification, we are on clause 124 and the floor is yours.
And I appreciate that. And I will just let you know, Mr. Chair, that I will be moving a motion at the end of this clause after the vote takes place, just so there's no ambiguity as to whether or not I'd like the floor before the debate on section 125. takes
Thank you,
place.
Mr.
I think
Stroll.
that,
And I encourage you to raise your hand so that I can recognize you and see that you indeed want to speak, as members do change their minds once in a while. The floor
well,
is
I'm
yours.
not going to this time, Mr. Chair. I will try to keep that raise hand function up. It does automatically go down after a while, which is unfortunate because I do want to ensure that that I am able to speak, and I'm happy to speak to section clause 124. I think as we have been doing throughout this bill, we've been pointing out the importance of the need to consider what we heard from the witnesses who came forward to discuss this piece of legislation, and that it is one that we heard, quite frankly, this piece of legislation is one that many had significant concerns with, and that there were concerns with every section of this legislation. Every clause concerns were raised by different groups, all the way from unionized workers at the ports to the port authorities. We heard from terminal operators. We heard from the Marine Chamber of Commerce, railways. All had concerns with the scope and focus of this bill, and I think Clause 124 is just another example of the government failing to take what they heard and apply it to this legislation. We heard time and time again that this was all about supply chain efficiency, that this was all about making Canada's supply chains more reliable, and Clause 124, talks about when this bill receives royal assent and how the sections are to come into force, and we've had many different discussions about how that should be done. When should the provisions of this bill come into effect? When will royal
point of order? Thank you, and I believe that Mr. Stroll is the vice chair, and I know he's not in the room, but I would just take this opportunity. There seems to be a trend as of late that committee chairs may have taken, I don't know, lessons or something of the effect to tread a very, very fine line where it seems that members' privileges can be violated without regard, and by using a coalition of left-leaning parties, that the rights and privileges of members can be treaded upon without discretion. And certainly we've seen that at the Natural Resources Committee, where there were such egregious violations of members' privileges that it seemed to truly disrupt and delegitimize the democratic process that we have.
Are you referring to anything in particular?
Yeah, I'm on a point of order, and I have before me Chair Bosch and Gagnon, and again, I think that it is absolutely key that we keep the context of the very foundation of where we are in the context of how we are able to most effectively do our jobs in this place, and the basis of that is the rights and privileges of members. Now, many people watching will not understand some of the context and nuances surrounding what this looks like. But, Chair, what we have witnessed before this committee, and I mentioned natural resources, and there are other examples as well, how it seems to me that with the observances of many who are watching,
point of order is,
that there is
debate. I do not deem it in order. I made a ruling. And therefore, I'll turn the floor back over to
Chair,
Mr.
with respect,
Strahl.
you made a ruling on an item that specifically you are not given the ability to make a ruling
Mr.
on.
Couric, that item has been dealt with, and therefore we will be moving on to Mr. Strahl.
In which is a violation of our privileges as members.
You are out of order, Mr. Couric. Mr. Strahl, the floor is yours.
Thank you, Mr. Chair, and I suspect that that we'll be dealing with that matter in the House of Commons at our earliest opportunity, which is when privilege motions will be raised. But back to
point of order.
Section.
Point of order. Point of order.
Yes, Dr. Lewis.
Yes, I just need some clarification. I'm a little bit confused here as to what is happening, because I do understand that Section 116, when debate is ended, that somehow we had, it seems like we've invoked Standing Order 60 to adjourn debate somehow. And if you look at Standing Order 67-0, it is clearly in conflict with that, because Standing Order 60 says that you can only adjourn unless otherwise prohibited by these standing orders. And when you look at Standing Order 67-0, it clearly states that debate is permissible. It gives the elements of when debate is permissible. So if Standing Order Debatable Motion 67, and then you go to O, it says for the suspension of any standing order unless otherwise provided. So if you take that into context, and we then say Section 116 is being suspended by your order,
Dr. Lewis, thank you very much. Sorry, Dr. Lewis, I'm going to have to cut you off there. There has been a ruling on the point of privilege. The matter has been dealt with, and therefore I'm turning the floor back over to Mr. Strahl. Thank you very much.
I'm just seeking clarification. I think that as a member,
Mr. Strahl, the floor is yours.
I am entitled to
I have responded to your question. I made a ruling on the matter. The matter is now closed, and I'm turning the floor over to Mr. Strahl.
So there's no reason that we're suspending that
Dr. Lewis,
Section
debate on this
67.
debate on this is concluded. The floor now belongs to Mr. Strahl.
Thank you, Mr. Chair. And this bill is a coordinating amendment. If the copy of the legislation that I have is correct, which states that if Bill C-26 introduced in the first session of the 44th Parliament, entitled An Act Respecting Cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts, receives royal assent, then on the first day on which both Section 18 of that Act and Section 123 of this Act are in force, subsection 2, sub 3 of the Transportation Appeal Tribunal of Canada Act is replaced by the following: jurisdiction in respect of other acts. 3, the tribunal also has jurisdiction in respect of reviews and appeals in connection with administrative monetary penalties provided for under sections 177 to 181 of the Canada Transportation Act, sections 127 to 133 of the Critical Cyber Systems Protection Act, sections 43 to 55 of the International Bridges and Tunnels Act, sections 129.01 to 129.17 of the Canada Marine Act, section 16.1 to 16.25 of the Motor Vehicle Safety Act, sections 39.1 to 39.26 of the Canadian Navigable Waters Act, sections 130.01 to 130.19 of the Marine Liability Act, and sections 32.1 to 32.28 of the Transportation of Dangerous Good Act 1992. So I'm hoping that either the legislative clerk or perhaps some of the witnesses can indicate for me what is the status of Bill C-26, and has it received royal assent? And if not, where is it in the process? Just so we know, how likely it is that that this coordinating amendment will be utilized with Bill C-33. So if they could just tell me what the status of that bill is.
One of our witnesses wants to address that. Ms. Heft?
It appears that Bill C-26 completed second reading on March 27th, 2023.
Okay, so that bill is clearly still before the I would assume that is with the industry committee, cybersecurity. Perhaps it could be with public safety. But I know that we had some serious concerns with that piece of legislation, and I think that we want to ensure that the rights of Canadians are always protected, and when we're considering Bill C-26, which deals with cybersecurity, we know that is an evolving field, and there's an evolving threat level that comes with that, and we know that the government, quite frankly, has failed to protect the rights of Canadians when it comes to their security, both personal security in our communities, but also when it comes to the online environment. That they've been lax. They've turned a blind eye, quite frankly, to threats to cybersecurity, and I think we've seen that again and again and again. We saw it when this government refused to ban Huawei from the 5G network for years, in spite of overwhelming evidence that the communist regime in Beijing was using that technology in the Huawei network as a way to gain access to the personal information, that was a security vulnerability. And we saw that our Five Eyes partners in the security establishment across with our international partnerships with Australia, New Zealand, the United States, all took action to protect Canadians, or to protect their citizens, I should say, their networks from cybersecurity threats, something that this government did not do. It took them years and years and years, and they fought it and they fought it and they fought it before they took the decision, much too late, to exclude Huawei from our cyber security networks, which resulted, quite frankly, in embarrassing situations where Canada was excluded from high-level meetings of the Five Eyes. We've seen it very recently when Australia had their deal with the United States to purchase submarines, for instance. There was an exclusion of Canada because Canada's networks were not deemed to be secure enough to allow us to participate in those very important high-level meetings. And I think these are examples where the government has failed to take cybersecurity seriously, and as I said, we have grave concerns with Bill C-26. So it's troubling to see that we would that this bill would cede power to another piece of legislation, or have this coordinating amendment that would there'd be two pieces of legislation that we believe are flawed, coordinating with one another. And I think this is the sort of thing that we should be we should be considering what is in Bill C-26 as we discuss this, because we can't simply agree holus bolus to something in another act if we haven't considered that fully here at this committee. So I think that this particular clause is one that perhaps as the evening goes on, we will find a way to bring about an amendment or to look at ways that we can make sure that the flaws that we had, or that the concerns that we had with Bill C-26 are addressed. Now, Part 1 of Bill C-26 amends the Telecommunications Act to add the promotion of the security of the Canadian telecommunications system as an objective of the Canadian telecommunications policy, and to authorize the Governor and Council and the Minister of Industry to direct telecommunications service providers to do anything or refrain from doing anything that is necessary to secure the Canadian telecommunications system. It also establishes an administrative monetary penalty scheme to promote compliance with orders and regulations made by the Governor and Council and the Minister of Industry to secure the Canadian telecommunications system, as well as rules for judicial review of those orders and regulations. Now, Part 2 of Bill C-26 enacts the Critical Cyber Systems Protection Act to provide a framework for the protection of the critical cyber systems of services and systems that are vital to national security or public safety, and that are delivered or operated as part of a work, undertaking, or business that is within the legislative authority of Parliament. So it also, among other things, authorizes the Governor and Council to designate any service or system as a vital service or vital system. It authorizes the Governor and Council to establish classes of operators in respect of a vital service or vital system. It requires designated operators to, among other things, establish and implement cybersecurity programs, mitigate supply chain and third-party risks, report cybersecurity incidents, and comply with cybersecurity directions. It provides for the exchange of information between relevant parties and authorizes the enforcement of the obligations under the Act and imposes consequences for non-compliance. Now, cybersecurity, as I said, is of a growing concern for Canadians. It remains a national security concern. It remains an economic security concern. We know that if we don't have adequate cybersecurity protocols in place, that we lose when things like patents and trademarked information secrets are lost because of a failure to ensure that we have adequate cybersecurity. And industry, we know that the government doesn't have a legal mechanism to compel action to address cyber threats or vulnerabilities in the telecommunications sector. Now, Bill 26 is another example, Bill C-26, where a minister is given sweeping powers the Minister of Industry is given sweeping powers, just like we've heard with Bill C-33, where the minister is given sweeping powers to enact orders that, in his opinion, are necessary to protect port infrastructure, port operations, et cetera. We've just dealt with that in a previous iteration, a previous clause. And so I think this is another example where we need to ensure that the powers that are given in Bill C-26 are proportional, that there are checks and balances, and that that the rights of Canadians are always protected when the minister is exercising those rights and those powers that have been given to him or her in the legislation. So it's another example of giving the minister broad powers to enact the legislation. Now, certainly, cybersecurity has been something that Conservatives have been raising the alarm about for a long time. We did it when we first created, under a Conservative motion, created the Canada-China Special Committee. That was an issue that was raised there, and again, in the context of Huawei, it was something that we raised time and time again. Our concerns that our 5G network was not being protected, and you know, I think there's obviously opportunities to strengthen our cybersecurity protocols, but we need to ensure that not only are the privacy rights of Canadians respected, but that there's also no attempt at censorship for Canadian citizens when they are operating in the cyber environment. And we've seen that the government has certainly gone down that road with Bill C-18 and C-10 as well, that they want to control what Canadians see and what they control the algorithms, for instance, of what can be shown, what will show up in their social media, for instance. So we have a hard time trusting the government when it comes to anything with cybersecurity, internet regulations. They've proven time and time again that they're willing to sacrifice the rights of Canadians in order to promote their own narrow agenda. So this bill C-26, unfortunately, increases regulation and red tape, often without the oversight, without adequate oversight, we believe, and without votes in Parliament. Again, we've seen even here today that the rights of members or the rights of parliamentarians, the supremacy of Parliament, is something that this government is not entirely, doesn't put as the highest priority. If Parliament gets in the way, they simply try to bypass it, and I think Bill C-26 is another example of where that has happened, and we have grave concerns with that, as I've outlined briefly. There's also
Mr. Strahl. Mr. Strahl, if you will permit, I will give you the floor back immediately following this. But I'm looking around the room at the witnesses and perhaps some of the other members here who would very much appreciate a 5-minute break to be able to go to the restroom. So if you will permit, I'll turn the floor right back over to you immediately to continue your dialogue in 5 minutes.
Take 10.
Seeing no objection, the meeting suspended for 5 minutes. this meeting back to order, and as promised, I turn the floor back over to Mr. Strahl. Mr. Strahl, the floor is yours.
Thank you very much, Mr. Chair. I hope everyone feels.
Sorry, Mr. Strahl, I have a point of order from Mr. Couric.
Just to ensure we don't end up in the same situation where members' privileges are called into question, I'd ask, Chair, if you could outline just who is on the speaking list so that we can understand fully
That is a great question, Mr. Couric, and the last thing I would want is for a member to question privilege. So I have Mr. Badaway, Mr. Couric, Dr. Lewis, if that is not a legacy hand, and Mr. Muse. And Mr. Lewis. Not on this. Not on this, Mr. Backrack. However, if you want to be on the list. Oh, you did?
I have the page open to a point of privilege.
Can we recess, Mr. Chair, so we can... Do we have a tape that we can go back and listen to see?
I can tell you this, Mr. Backrack, that at 7:30 we will have to take a 5-minute recess in order to ensure that all the translators and teams supporting us can be switched over. So.
Right. No, it was less about having a recess so I could have yet another break, because we just had a break. It was more about whether my hand was on the list. And I thought that I had put up my hand earlier and tried to get on the speakers list, but I know things are fluid, so maybe I'll just put my hand up now and try to get on the list.
Your name is now on the list.
Wonderful.
I can confirm that.
I look forward to speaking.
Thank you, Mr. Couric, and back over to you, Mr. Strahl.
Well, thank you, Mr. Chair. And as we were talking about Bill C-26, which is referenced here, and I want to quote from a source called openmedia.org, which on November 28th, 2023 has an article which says that a new report by Citizen Lab finds serious charter concerns with proposed federal cybersecurity legislation Bill C-26, and I'm just going to read here. It says, civil liberties groups welcome call to make Bill C-26's impact on equality, freedom of expression, and privacy a central consideration of parliamentary committee study. It goes on to say that the federal government's draft cybersecurity legislation, Bill C-26, contains serious deficiencies and risks impacting the charter rights of people in Canada to equality, freedom of expression, and privacy. That's according to a new report by the Citizen Lab at the Munk School of Global Affairs and Public Policy at the University of Toronto, which highlights that Bill C-26's charter implications, quote, should be a central consideration for the committee and throughout the parliamentary process ahead, end quote. The report has been submitted to the House of Commons Public Safety and National Security Committee, which is expected to commence its scrutiny of Bill C-26 shortly. Again, this is from a few weeks ago. Among the significant charter concerns identified by the Citizen Labs report's authors, Kate Robertson and Lena Lee, are equality, the absence of key transparency, accountability, and proportionality requirements in Bill C-26 raises equality risks surrounding its implementation. Bill C-26's lack of safeguards increases the risk that equality undermining measures will not be adequately prevented or addressed. For example, adverse impacts could undermine efforts to redress disparities in internet access between rural and Indigenous communities and the rest of Canada, result in mandated rules that impede access to assistive technologies for persons living with disabilities, or expose certain groups, including journalists, lawyers, and dissidents, to a heightened threat of hacking and espionage. There are also concerns with freedom of expression. Bill C-26's excessive secrecy jeopardizes the freedom of expression rights of the public, the media, and commercial entities. Courts and government should be open and accessible or risk impeding meaningful discussion on matters of public interest. Such discussion is especially important in the cybersecurity sphere, and greater transparency in Bill C-26 is required to ensure this. Privacy. Bill C-26's new information collection and sharing powers are insufficiently bounded or defined, posing a potential privacy risk exacerbated by the absence of key accountability and oversight mechanisms, The bill permits the government to collect the personal information of Canadians, creates criminal offenses which incentivize oversharing, and its extensive secrecy undermines the ability of courts or oversight bodies to assess whether such information collection is proportionate and necessary.
Point of order,
Civil
Chair.
society.
Yes, Mr. Patzer.
Yes, thank you very much. I understand there's been a few questions in regards to the speaking order. Now, knowing that I was just recently subbed into the committee, I'd just be curious to know who's next up on the speaking list, but also if there's a way, Mr. Chair, that I'd be able to get myself onto the speaking list, as I understand there's some potential issues that would be of great interest to the people that I represent.
Mr. Pastor, as chair, it would be an absolute pleasure for me to add your name to the list. You will be following Mr. Bachrach.
Correct me if I'm wrong, but don't members who are swapping in have to spend the requisite 30 minutes getting up to speed on the topic of debate and getting comfortable with the local environs before they're added to the speaking list?
Maybe if you...
On that point, you have to be recognized, Mr. Patzer.
Yeah, on that point, maybe you want to spend a half hour to enlighten me on what's happening.
I didn't recognize you. Just in direct response to your inquiry, Mr. Bachrach, he is an official replacement for one of the members, so he can add himself to the speaking list. Yes,
Okay.
sir.
Interesting.
So once again, Mr. Patzer, you will be following Mr. Bachrach. Mr. Strahl, my sincere apologies. I don't like to break up your train of thought. The floor is yours, sir.
No, I appreciate the clarity. We've had some issues here.
Point d'ordre, Monsieur le Président.
Oui.
On a point of order, Mr. Chair. Yes, Mr. Barcelot-Duval. Thank you, Mr. Chair. I am trying to wrap my head around this and understand if this is a new standard to use points of order to get added to the speakers list, or if there's other ways of being added to the speakers list that are more appropriate. Well, thank you very much, Mr. Barcelot-Duval. I think that the first party wanted to know who was on the list, and I put that individual's name on the speakers list. So there you have it. The floor is yours, Mr. Straw.
Just continuing with the article that expressed some concerns about Bill C-26. It says civil society organizations campaigning to fix Bill C-26 have welcomed Citizens Lab's findings, stating that they reinforce long-standing concerns and that significant amendments are required to uphold civil liberties and strengthen public confidence in the resulting cybersecurity framework. These organizations recently submitted detailed recommendations to make sure the legislation delivers strong cybersecurity for everyone in Canada while ensuring accountability and upholding our rights. These recommendations reflect the findings of a previous Citizen Lab report entitled Cybersecurity Will Not Thrive in Darkness.
On a point of order, Mr. Chairperson again. Yes, Mr. Iaconu. I'm having trouble hearing from the French interpretation. Okay, we'll double check. Please be patient.
Okay, je vais juste vérifier.
I'll just double check. I'll speak in English.
To see whether or not the French translation works. Can you hear me, Mr. Iaconu, in the French translation? Are there other members who are also experiencing, actually the only person who would know that, Mr. Barcelot-Duval, est-ce que la traduction en français?
Is the simultaneous interpretation in French working well for you, Mr. Barcelot-Duval? Well, I'm sorry, Mr. Chair. In fact, I'm listening to the floor version, I admit. Well, could you please change channels just so that we can confirm whether or not the French interpretation is working?
That we see whether or not the French translation works, Mr. Barcelot-Duval?
En tout cas, ça vient de fonctionner.
It seems to be working. I just heard some French interpretation. Well, thank you, Mr. Barcelot-Duval. I can see that things are working now for on Mr. Iacono's end as well.
Interrupted far too many times, and I want to apologize for that and turn the floor back over to you, sir.
Just continuing on, these recommendations reflect the findings of a previous Citizen Lab report entitled Cybersecurity Will Not Thrive in Darkness by Dr. Christopher Parsons, which was published.
Oui, Mr. Bassel Duval, my apologies.
Yes, on a point of order, Mr. Chair, perhaps you can shed light on this, but I'm wondering whether the current remarks being made by Mr. Stroll on Bill C-33 are in order and have to do with what we're discussing, because up until now we've been discussing C-26. And I think it's even legislation now, not even a bill. So I just wanted to make sure, according to you, whether or not the members' remarks are in order. Thank you very much, Mr. Bassel Duval.
Make the link in his continuation of his remarks between what he's discussing and Clause 124. And I'll turn the floor back over to you, sir.
Thank you very much, Mr. Chair. I'll go back just to make sure that people listening can follow along to the train of thought of the article here. These recommendations reflect the findings of a previous Citizen Lab report entitled "Cybersecurity Will Not Thrive in Darkness" by Dr. Christopher Parsons, which was published last October. The legislation has been subject to fierce criticism for its impact on civil liberties since it was first introduced by former Public Safety Minister Marco Mendicino in June 2022. The groups and expert individuals campaigning to fix Bill C-26R, the Canadian Civil Liberties Association, the Canadian Constitution Foundation, the International Civil Liberties Monitoring Group, League.
On a point of order, Mr. Chair, once again, yes, Mr. Iacono. It's highly interesting what my colleague is saying, but unfortunately I'm having trouble following him because I don't have any documents at hand. I have nothing to refer back to better understand what he is saying. I was all prepared this evening to discuss Bill C-33, and now the member's talking about another bill. Now, if the member wants to talk about another bill, well, perhaps I demand some level of detail, some documents, so that we can at least follow. Because, listen, I want to feel useful tonight at committee. I don't just want to be a bump on a log listening to someone else speak. So if the member's going to refer to something, in particular, specific, it'd be great to have the document at hand so that we can think long and hard about what the member's saying and follow the member's remarks so that we can be edified in the same way as he has been educated on the topic. So as I said, I'm a tad lost. I have no documentation. I have no idea what bill he's referring to. I don't have any details at my disposal, so I defer to you to guide us on this matter, because it's kind of like we're speaking out in a void, and the outcome will be just that, a void. Thank you, Mr. Iacono. And Mr. Iacono, there's a problem with your sound. It seems that your microphone isn't properly working. The interpreter concurs. Perhaps it has something to do with the placement of the stem of your microphone. Well, I've just moved it. It's a tad lower. That's much better. That's much better, says the chairperson. Can you hear me better? Yes, we can, and our interpreters are very grateful. Thank you very much, Mr. Chairperson, for the excellent job you're doing this evening. Thank you, Mr. Iacono. Mr. Stroll.
Mr. Iacono's intervention, if you do have any documents that your team perhaps can share with committee members who are very interested in what you are currently sharing, please pass those along to committee members, to the clerk, and the clerk can perhaps pass those along to members. And with that, I'll turn the floor back over to you.
Well, thank you, Mr. Chair, and of course, if we wanted to, perhaps during one of the adjournments this evening, I can share some information, including Bill C-26, which is clearly referenced here. This is a coordinating amendment, And so we need to be having a discussion about what we're coordinating with and the concerns that have been raised. So I'll just continue on here. The groups and expert individuals campaigning to fix Bill C-26 the Canadian Civil Liberties Association, Canadian Constitution Foundation, the International Civil Liberties Monitoring Group, Ligue des droits et libertés, the National Council of Canadian Muslims, Open Media, the Privacy and Access Council of Canada, Professor Andrew Clement, and Dr. Brenda McPhail. And it ends with a quote here. It says, today's report should set alarm bells ringing on Parliament Hill. As written, Bill C-26 gives the government and its spy agencies a blank check to intrude on our private lives and endanger our...
On a point of order, Mr. Chair. Yes, Mr. Basil-Duval. Well, earlier I raised the fact that my colleague isn't talking about Bill C-33, but rather Bill C-26. And he said that he was going to establish the link between the two. But I'm noticing that he's still talking about Bill C-26 and not Bill C-33, and specifically not the clause that is currently under consideration. So I'm wondering if you could direct him to speak to something in relation to the bill specifically.
Merci, Monsieur Basil-Duval.
Thank you, Mr. Basil-Duval.
I have to ask you to perhaps be more diligent about linking what you're currently speaking about and Clause 124, and perhaps ensure that you're explaining to members how what you are speaking of right now is related to Clause 124, or I will have to pass the floor on to another member. So I encourage you strongly to do that. Thank you, sir.
Mr. Chair, I would strongly object to anyone suggesting that they get to choose for another member what they bring to the table in terms of a background information that should inform us on how we address a specific clause. The first three words, if my copy of the bill is correct, of Section 124, the title of the section says Bill C-26. So there's the link for you. And then 124 says if Bill C-26, and it continues on. So I am talking here about a bill that is specifically referenced in Bill C-33, and this is a coordinating amendment. So I will raise my concerns with Bill C-26 and the idea that if we pass this clause, that we are endorsing Bill C-26 with all of its problems. Quite frankly, it's not my job to convince other members of Parliament that they too should be concerned about that if they're not listening to what I have to say, but I will continue to address the concerns that this bill that is specifically referenced in Clause 124 relates to. So I'll just go back to this particular thing that I was reading from. I'll start the quote again, which says, today's report should set alarm bells.
Mr. Chairperson, on a point of order, Mr. Iacono. Well, the member is reading something. Now, given that he's reading something, could he please share what he's reading? Listen, Mr. Chairperson, the member just made a comment that I found a tad out of order and targeted Mr. Xavier and myself. Both of us raised points of orders that were similar in nature, and now he's started back up again and he's reading something and stated that he's doing so. Could we please get a copy of what he's reading so that we can follow a bit better? Now, he just reached the conclusion that Bill C-26 is mentioned in Bill C-33. If that's the case, why doesn't he just share that reference with us? Be kind of straightforward.
Mr. Iacono.
Thank you, Mr. Iacono. Just for your edification, I think he's reading what's on page 169 of the current bill, that is C33, or rather page 79.
Of the piece of legislation that we are currently addressing. And I just wanted to confirm that for Mr. Iachino so that he knows what you are referencing.
I'm referencing the clause that we are currently debating.
Yes, and you're referencing C26, which is referenced on page 79 of the piece of legislation that we are currently looking at. I'm just sharing with Mr. Iachino so he can follow along.
I appreciate that. I don't have. I'm looking at a digital version of the bill, so I don't have a number, I'm afraid.
So I hope that answers your question, Mr. Iachino, and I apologize, Mr. Strahl. The floor is yours.
It's okay. I'll get this quote read eventually, which says that today's report should set off alarm bells ringing on Parliament Hill. As written, Bill C-26 gives the government and its spy agencies a blank check to intrude on our private lives and endanger our fundamental charter rights. Frankly, as currently drafted, it is little more than a spy agency wish list. MPs need to fix this risky and deeply flawed legislation so that it delivers the cybersecurity we need while protecting the freedoms we hold dear. Canadians deserve nothing less. And that's from Matthew Hatfield, Executive Director, Open Media. Now, he, one of the groups that he referred to in that article is the Canadian Civil Liberties Association. And they have also provided some detailed information on their concerns with Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. And they made a submission which I'd like to share with the committee as well, because it is important to hear from when we're talking about civil liberties and how this bill will be coordinated into Bill C-33. I think it's important that we consider whether or not we believe that
My apologies once again, Mr. Strahl. I just wanted to confirm whether or not that raised hand by Dr. Lewis is a point of order, whether she has something she would like to share. Dr. Lewis?
No. Oh, I'm sorry. My video wasn't even on. I'm sorry about that. That's probably why you thought that. Sorry, no, not at all. I'm waiting for my turn to speak. Thank you.
Oh, okay. Thank you, Dr. Lewis. I wanted to make sure that we didn't miss you there. Your name is on the list, Dr. Lewis.
And thank you for indicating, for calling on me. I think it's because my video, I probably didn't turn it back on from the break. So my apologies to my colleagues for that. Thank you.
You're very welcome, Dr. Lewis. Mr. Strahl, the floor is yours once again.
Well, thank you. So as I was saying, the Canadian Civil Liberties Association has raised significant concerns with Bill C-26, which again is referenced in Clause 124. And so I'll just read their submission here so that we can consider it in our deliberations on whether or not we believe that we want to approve this coordinating amendment clause in the legislation. So the Canadian Civil Liberties Association is an independent national non-governmental organization that was founded in 1964 with a mandate to defend and foster civil liberties, human rights, and democratic freedoms of all people across Canada. Their work, I'll quote it directly. Our work encompasses advocacy, research, and litigation related to the criminal justice system, equality rights, privacy rights, and fundamental constitutional freedoms. Working to achieve government transparency and accountability with strong protections for personal privacy lies at the core of our mandate. In this submission, CCLA speaks to Bill C-26, the Government of Canada's telecommunications and cybersecurity legislation. This submission addresses the concerns Bill C-26 raises for human rights and civil liberties, with a particular focus on privacy. Cybersecurity is an essential part of national security, and the digital ecosystem in which we increasingly live our lives needs to be safe, reliable, and secure from threats. Cybersecurity is also crucial for our democratic institutions, the economy, critical infrastructure, national defense, and the privacy of our online life. It is important that Canada take steps towards protecting the digital foundations on which modern life is built. However, in its current form, Bill C-26 risks undermining our privacy rights, due process, and the principles of accountable governance, all of which are part of the very fabric of our democracy. Bill C-26 must not pass without substantial revisions to protect fundamental rights and due process. This submission makes recommendations for how Bill C-26 can improve the way government and telecommunication companies define, handle, and protect individuals' personal information, and thus protect individuals' right to privacy. Privacy is, after all, an essential component of individuals' personal sense of security, both off and online, and stands to be positioned more centrally in C-26. CCLA believes that our recommendations enable the legislation to better fulfill its stated objectives, bolster cybersecurity across the financial, telecommunications, energy, and transportation sectors, and help organizations better prepare, prevent, and respond to cyber incidents. Oh, that's when our committee was supposed to start. The amendments outlined in this submission echo the joint letter of concern that CCLA sent with civil society partners in September 2022. In addition, our recommendations are consistent with those contained within the, quote, Fixing Bill C-26 Recommended Remedies package, of which CCLA is the signatory, as well as with the recommendations in Christopher Parsons' report, Cybersecurity Will Not Thrive in Darkness. It's the second time that's been referenced. I think we'll be bringing that up again shortly. Defining personal information. As it stands, Bill C-26 undermines privacy by empowering the government to collect broad categories of information from designated operators at any time, subject to any conditions, or even no conditions at all. This may enable the government to obtain identifiable and de-identified personal information and subsequently distribute it to domestic and perhaps foreign organizations. Given the sensitivity of the information people in Canada provide to designated operators, this provision poses an extraordinary risk to individuals' privacy. Measures must be established to constrain the government's collection, use, and distribution of individuals' sensitive information. In general, the privacy of personal information is one of the keys to strong cybersecurity protections. Building privacy into cybersecurity legislation will go a long way toward ensuring the cybersecurity protections proposed in Bill C-26 are successful. Some degree of monitoring is required to protect telecommunications infrastructure from attack, but this should not come at the expense of personal privacy. There is no excuse for governments to surveil and analyze online activity without clear safeguards for personal privacy and individuals' fundamental rights. One way to reasonably restrict the government's capacity to collect information is to refine how Bill C-26 conceives of information worth protecting. This would involve codifying personal and de-identified information as confidential. Personal information is any information that can be used to identify an individual through association or inference. Many kinds of information qualify as personal in their capacity to identify an individual These, according to the European Union's EU General Data Protection Regulation, GDPR, include names, ID numbers, location data, online identifiers, or factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of a person. Further, personal data can be anonymized or de-identified, but de-identified information requires additional protections. Anonymization involves permanently deleting identifying
Mr.
data.
Strahl, my apologies for cutting you off. For cutting you off. We do have to suspend in order to ensure that we can transfer over to a new crew of interpreters and support staff. So we'll suspend for 10 minutes, and you can pick up where you left off following the suspension. This meeting is suspended. I'll call this meeting back to order. I just want to verify that we do indeed have Mr. Strahl. There he is. Perfect. So, Mr. Strahl, I'll turn the floor back over to you.
Thank you, Mr. Chair. I just want to make sure I'm in the right position there. Thank you. Just continuing on from the Canadian Civil Liberties Association's submission on Bill C-26, which, just to remind colleagues, is referred to in Clause 124. We're deciding whether or not we believe that there should be a coordinating amendment with Bill C-26 and Bill C-33. So building the case for why I have concerns with that. And I'll just continue reading. Perhaps I'll go back just to make sure that information wasn't missed. It says, further, personal data can be anonymized or de-identified, but de-identified information requires additional protections. Anonymization involves permanently deleting identifying data, while de-identification involves stripping away and separating different bits of identifying information from one another, or protecting identifying information through encryption or key, but not permanently deleting it. Anonymizing data is irreversible, while de-identified data can be re-identified. De-identified data requires greater protection than anonymized data, so Bill C-26 should ensure de-identified information is explicitly acknowledged as confidential. As it stands, Bill C-26's proposed amendments to the Telecommunications Act do not designate personal and de-identified information as confidential under Section 15.5 sub 1. Nor does that matter, nor for that matter, does the Critical Cyber Systems Protection Act, CCPSA, which under Section 6 sub 1 does not flag personal or de-identified information as confidential. In order to protect this information, both acts contained within C-26 need adjustment to better align with our privacy rights, freedoms, and democratic values. Handling personal information. It's a new section. Bill C-26 gives the minister overbroad powers for handling personal information. Telecommunications companies and companies likely to be designated under the CCSPA collect, process, and store vast amounts of personal data and metadata, including call logs, messages, financial data, and location data. But as worded, Bill C-26 allows the minister to share this type of personal information with anyone they designate or who is prescribed by regulations. It is one thing for government to ask designated operators for information about themselves and how they are complying with orders, but there needs to be a significantly higher standard when ordering companies to hand over information about their customers. This is especially important for telecommunication companies, given the high volume of personal information they hold about the public and how telecommunications data can be used to identify individuals, track their movements, and monitor their communications. Bill C-26 should better protect the privacy of personal information and communications by creating a more effective stopgap between this information and the minister's ability to disclose it. The legislation should be amended so that the government must first obtain a relevant judicial order from the federal court before it can compel a telecommunications provider to disclose personal or de-identified information. Further, Parliament should strengthen the bill's privacy protections when it comes to telecommunications providers and designated operators sharing information with foreign parties. In the proposed new section 15.7 sub 1 of the Telecommunications Act, quote, any information collected or obtained under this act, other than information designated as confidential under subsection 15.5 sub 1, may be disclosed by the minister under an agreement, a memorandum of understanding, or an arrangement in writing between the Government of Canada and the government of a province or of a foreign state, an international organization of states, or an international organization established by the governments of states, or any institution of any such government or organization, if the minister believes that the information may be relevant to securing the Canadian telecommunications system or the telecommunications system of a foreign state, including against the threat of interference, manipulation, or disruption. The provision's breadth and vagueness would allow not only for tremendous ministerial overreach, but it could also lead to privacy risks that cross provincial and national borders, resulting as well in potential risks to life and security for affected individuals and groups. CCLA strongly urges the amendment of the bill to preclude the minister from sharing personal or de-identified personal information to foreign governments or organizations, and that the minister should inform telecommunications providers and designated operators when and to whom information may be disclosed when the receiving party is a foreign state, agency, organization, or party. Finally, Bill C-26 lacks strong provisions around data retention periods. Data should only ever be kept for as long as they are useful, and storing data indefinitely can increase the risks and harms of potential data breaches. Data retention periods are crucial for ensuring that any information obtained under either the Telecommunications Act or the CCSPA would be held only for so long as it is necessary to make a legislative order or to confirm compliance with such an order. CCLA recommends that the legislation be amended to make this data retention period as limited in duration as possible, and that the legislation include, to the extent that the legislation permits any data sharing, a requirement to attach data retention and deletion clauses in agreements or memoranda of understanding that are entered into with foreign government agencies. Ensuring accountability for mishandled information. Bill C-26 lacks key accountability measures for privacy issues. Accountability is a core principle of effective government and should similarly be a core principle of Bill C-26. A key accountability concern pertaining to privacy is that Bill C-26 does not allow individuals to seek relief if the government mishandles personal or de-identified information. Allowing for this recourse is an important step toward accountability for privacy violations. CCLA recommends that Bill C-26 be amended to enable individuals to seek relief if the government or a party to whom the government has disclosed their personal or de-identified information negligently loses control of that information and where that loss of control impacts the individual. Their conclusion, in its current form, Bill C-26 undermines personal privacy and violates due process. Privacy and due process are not only essential to cybersecurity and the protection of our critical infrastructure, but are also part of the very fabric of our democracy. The bill gives government the power to collect broad categories of information about people without adequate protections for information that should be deemed confidential. The bill also threatens personal privacy and creates other serious risks and dangers to people by allowing government to distribute this sensitive information to domestic and foreign organizations without proper checks and balances. And the bill contains inadequate mechanisms for people to seek appropriate redress in cases where their private information has been mishandled and abused. In this submission, CCLA has recommended remedies to address these concerns while still enabling the legislation to fulfill its stated goals, bolstering cybersecurity across the financial, telecommunications, energy, and transportation sectors. Interesting. And helping organizations better prepare, prevent, and respond to cyber incidents. We urge the committee members to adopt these proposals for strengthening Bill C-26. So the Civil Liberties Association has very grave concerns and has proposed some significant changes to Bill C-26, which once again, for the purposes of Clause 124, the first words again are, if Bill C-26 receives royal assent, then on that day, we go into whether or not there should be changes to Bill C-33. So I think it's very important that we discuss whether or not we believe that this clause should be passed, given the incredible concerns that there are with Bill C-26. IT World Canada is another website, itworldcanada.com, for Mr. Yakino. If you wanted to get onto that website, I'll be reading a bit from that, where the bill, they have an article here under the section of Industry Voices, Bill C-26 regulation and its implications for the critical infrastructure's cybersecurity in Canada. And this is by Frank Lawrence and Eric Jensen of Fortinet. The article begins, as the last G7 nation and one of the few G20 nations without a firm regulatory framework around cybersecurity, Canada must act to protect the nation's critical infrastructure assets. In 2016, member states of the European Commission, EU, passed what was called the most comprehensive cybersecurity bill in the history of the EU. The bill was called the NIS Directive. The EU cybersecurity rules introduced in 2016 were updated by the NIS2 Directive ratified in 2023. NIS2 continues modernizing the legal framework to keep up with increased digitization and an evolving cybersecurity threat landscape. Expanding the scope of the cybersecurity rules to new sectors and entities further improves the resilience and incident response capabilities of public and private entities, competent authorities, and the EU as a whole. Most G7 member states are under the umbrella of the EU. The US, UK, and Japan have separately implemented cybersecurity regulations to differing degrees. Canadian businesses continue to be impacted by malicious cyber activity, ranging from cyber attacks to ransomware. Many attacks, including those on critical infrastructure, that accounts for nearly half, go unreported. Concerningly, the Canadian Centre for Cybersecurity, CCCS, has identified attacks against OT networks as the most pressing threat to the physical safety of Canadians in their biannually published National Cyber Threat Assessments. In this context, the Ministry of Public Safety acted to introduce new legislation, Bill C-26, an act respecting cybersecurity. Bill C-26 passed its first step in Parliament in November of 2022 and went into its second reading on March 27th, 2023. The bill sits in committee and is believed to go into legislation and law in the calendar year of 2023. I would state that this article was a little optimistic there. The primary focus of Bill C-26 is to add teeth to the governance and compliance of cybersecurity, especially in the much-needed operational technology area where critical infrastructure lies. Although the bill has not yet received royal assent, between the absence of similar legislation in Canada and the trend towards increased cybersecurity regulation among our international peers, Canadian businesses would be wise to prepare. Canada has yet to pass laws that govern cybersecurity, let alone require reporting vulnerabilities and critical infrastructure breaches. Bill C-26 would empower the regulators to impose fines or issue summary convictions to ensure governance and compliance. Bill C-26 in its current form includes 4 critical infrastructure sectors: telecommunications, finance, energy, and transportation. The requirement for organizations in these sectors is threefold. 1, implement, maintain, and report on a cybersecurity program to address risk across the organization, third-party services, and supply chains. 2, report any cyber incidents involving critical systems to the appropriate regulator and the Canadian Centre for Cybersecurity. 3, use or discontinue any specified product, service, or supplier. The intended outcome of these requirements is to improve the standard of cybersecurity amongst critical operators and deepen the level of visibility the federal government has into the security operations of these organizations. It is known today that certain companies that are considered high risk and vital to national security would become the federal government's focus. Following the process of the proposed legislation of Bill C-26 and its passing, federal government departments will communicate with the companies impacted in the focused sectors with details on how breaches are to be reported and the required timeline for reporting. Furthermore, the companies must, quote, keep records of how they implement their cybersecurity program, every cyber incident they have to report,
Point of
any
order.
step taken.
Point of order.
My apologies, Mr. Strahl. I have a point of order from Dr. Lewis.
Yes, Chair, could you advise me, are the witnesses also going to remain here until 11:30? I'm just curious because because of the way that we set up this meeting, I wasn't sure whether or not we had them for the whole time or if we
here until 11:30, and we are very grateful for their service to this committee.
Thank you.
Thank you, Dr. Lewis. I'll turn it back over to you, Mr. Strahl.
To this committee and to all Canadians, Mr. Speaker, we're grateful for that service. I'm just going to make sure I don't miss any of this important article here. Following the process of the proposed legislation and its passing, federal government departments will communicate with the companies impacted in the focus sectors with details on how breaches are to be reported and the required timeline for reporting. Furthermore, the companies must keep records of how they implement their cybersecurity program, every cybersecurity incident they have to report, any step taken to mitigate any supply chain or third-party risks, and any measures taken to implement a government-ordered action. Again, let's be very clear, although only the 4 key sectors, telecommunications, finance, energy, and transportation, are considered in scope by Bill C-26. Sectors such as agriculture and manufacturing are likely to be included later, as is the case in the EU. The federal government of Canada hopes this legislation will serve as a model for provinces and territories to implement similar legislation that regulates cybersecurity requirements for entities under their purview, including hospitals, police departments, and local governments. To help companies comply with the requirements of Bill C-26, there's been more now. They're talking about their services, which I don't need to give them that free plug, Mr. Chair. I think we've got an idea of what they think the merits and some concerns about C-26 are, and you'll note that the transportation sector obviously is mentioned as a key part of Bill C-26, which is likely why there is a reference in Bill C-33 in Clause 124 to that piece of legislation, and I think that it is again, we need to fully understand whether or not Bill C-33 should be. We should be coordinating amendments with a piece of legislation that has so many concerns that have been raised. And so I want to raise some other concerns. Obviously, anytime you're dealing with cybersecurity, et cetera, there is going to be a charter analysis that has been done, and the Monk School of Global Affairs and Public Policy, along with the University of Toronto and Citizen Lab. I referenced an article to it, but I did want to also get into the details of the report, a submission that was made to the Standing Committee on Public Safety and National Security concerning a charter analysis concerning cybersecurity and telecommunications reform in Bill C-26. So this again was referenced in the previous article, but this is the base documentation that gave way to that article. So I want to make sure that we're not just hearing an interpretation of a report, but are considering it directly. And so this report goes on to say that on June 14th, 2022, Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act and making consequential amendments to other acts, was introduced in Parliament for the first reading by Canada's Minister of Public Safety, Marco Mendicino, former Minister Marco Mendicino now. Hearings on Bill C-26 are scheduled to begin in SecU on December 4th, 2023. So a very recent, Mr. Chair. Kate Robertson, Senior Research Associate, and Lena Lai, I hope I'm saying that correctly, made a written submission to the Standing Committee on Public Safety and National Security regarding Bill C-26, and with an emphasis on privacy in particular. The submission tackles the issues Bill C-26 brings up regarding civil liberties and human rights. The fundamental tenets of accountable governance, due process, and our right to privacy are all at risk of being compromised by Bill C-26 in its current form. In order to better protect people's right to privacy, this submission offers recommendations for how Bill C-26 can be implemented in terms of how the government and telecom companies define, manage, and safeguard people's personal information. The submission suggests that safeguards for the new government powers that the bill establishes be included in order to address general shortcomings such as issues with secrecy and transparency. There is evidence that signaling protocols used by telecom companies for facilitating roaming services also enable networks to obtain incredibly detailed user data. Such extent of access with the telecom service providers poses an unprecedented risk to the privacy of individuals. Owing to the extent of data available with the telecommunications providers, the telecom sector has become a primal target for surveillance actors. In an attempt to address the concerns in the telecom ecosystem, this submission to the Standing Committee on Public Safety and National Security provides a critical response to the federal government's charter statement on Bill C-26. The Citizen Lab welcomes the opportunity to submit to the Standing Committee on Public Safety and National Security. Their submission highlights how Bill C-26 will impact equality, rights, and freedom of expression while providing recommendations to address a series of thematic deficiencies identified in Bill C-26. To ensure that its actions adhere to Canada's democratic values, as well as the standards of accountability and transparency, the government must make changes to its legislation. Below is Citizen Lab's full submission to SecU regarding Bill C-26. Part 1, Introduction and Summary. 1. Citizen Lab researchers routinely produce reports concerning technical analysis of information and communications technologies, ICTs, the human rights and policy implications surrounding government surveillance that occurs using ICTs, as well as the cybersecurity threats and digital espionage targeting civil society. Citizen Lab research has also examined the openness and transparency of government and organizations, including telecommunication providers, with respect to the collection, use, or disclosure of personal information and other activities that can infringe upon human rights. 2. This month, the Citizen Lab published Finding You, the Network Effect of Telecommunications Vulnerabilities for Location Disclosure, authored by Gary Miller and Christopher Parsons. The report provides a high-level overview of geolocation-related threats sourced from 3G, 4G, and 5G network operators. Evidence of the proliferation of these threats shows how the signaling protocols used by telecommunications providers to facilitate roaming also allow networks to retrieve extraordinarily detailed information about users. These protocols are being constantly targeted and exploited by surveillance actors, quote, with the effect of exposing our phones to numerous methods of location disclosure, close quote. Risks and secrecy surrounding mobile geolocation surveillance are heightened by layers of commercial agreements and sub-agreements between network operators, network intermediaries, and third-party service providers. Ultimately, vulnerabilities in the signaling protocols have enabled the development of commercial surveillance products that provide their operators with anonymity, multiple access points, and attack vectors, a ubiquitous and globally accessible network with an unlimited list of targets, and virtually no financial or legal risk, close quote. 3. Finding You highlights the importance of developing a cybersecurity strategy that mandates the adoption of network-wide security standards, including a requirement that network operators adopt the full array of security features that are available in 5G standards and equipment. The report's findings also underscore the importance of public transparency and accountability in the regulation of telecommunications providers. As the authors note, quote, decades of poor accountability and transparency have contributed to the current environment where extensive geolocation surveillance attacks are not reported, close quote. In short, it is long overdue for regulators to step in at national and international levels to secure our network services. However, Canada's approach to the regulation of telecommunications and cybersecurity also needs to be transparent, accountable, and compliant with applicable human rights standards. 1 year ago, Citizen Lab published Cybersecurity Will Not Thrive in Darkness, a critical analysis of proposed amendments in Bill C-26 to the Telecommunications Act. The report was authored by Dr. Christopher Parsons. Dr. Parsons critically examined the proposed draft legislation under Bill C-26, including identified deficiencies. In doing so, Dr. Parsons provided necessary historical and international context surrounding the federal government's proposed telecommunications sector reform. Canada is not the first of its allies to introduce new government powers as a result of heightened concern and awareness surrounding real and pressing risks to critical infrastructure. However, Dr. Parsons identified that although the draft legislation may advance important goals, its current iteration contained thematic deficiencies that risked undermining its effectiveness. This report is set out in Appendix B and is the focus of this brief. The main submissions in this brief are set out in two parts. Part A, Part 2, Bill C-26 and the Canadian Charter of Rights and Freedoms, Charter. Obviously, we will be very concerned about that. Part 2 of this brief discusses the nexus between Bill C-26 and the Charter.
Oui, sorry, Mr. Schral, I have a point of order from Mr. Iacchino. Oui, Mr. Iacchino, à vous la parole.
Monsieur Iacchino, c'est à vous. Alors, it is 8:08, and it's been quite a while now that we've been working at this. I'm asking, at what time are you anticipating taking a break? We have many people from the various departments here. I think they deserve a break so they can stretch their leg, they can eat. It is now 8 p.m. So what is the plan for this evening, Mr. Chair? Thank you, Mr. Nakano. We took a break at 7:30. So as a speaker, as a chair, I decided to take another break around 9 p.m. it was a very brief break at 7:30. Let's say it was a bathroom break. I think a break to eat something else. Well, that's a different length. Mr. Iacono, we can definitely take another break, 5-10 minutes. Is this what you're asking? It is not just for me. It is for the people who are here, for the witnesses, for example. I mean, they certainly deserve. They deserve a moment of relief to, I don't know, have some rest. I mean, feel free to ask the other members of the committee, but I think we have to take into consideration the fact that these people are not used to being here so late. Thank you, Mr. Iacono. I'm going to ask our witnesses if they need a break.
Merci. Thank you, Ms. Moriarty. Mr. Iacono, nos témoins indiquent...
Mr. Iacono, the witnesses are indicating that they do not need a break, so I'm going to give the microphone to Mr. Stroll so he can continue.
Thank you very much, Mr. Chair.
Monsieur
and of course,
le Président, est-ce que vous allez quand même prendre votre prochaine pause? À quelle heure?
Are you still going to take the next break? At what time? If the committee agrees, I believe that the next break will be around 9 p.m. And then after that, what time will it be? Maybe 10:30, and then we will finish at 11:30. Thank you very much, Mr. Chair. My pleasure, Mr. Iacono. Mr. Troll, your turn.
thank you. The main submissions in this brief are set out in two parts. Part 2, Bill C-26 and the Canadian Charter of Rights and Freedoms, Charter. Part 2 of this brief discusses the nexus between Bill C-26 and the Charter. It focuses in particular on how Bill C-26 may impact equality rights, Section 15, freedom of expression, Section 2, Sub B, and privacy, Section 8. The Charter implications of the proposed legislation should be a central consideration for this committee and throughout the parliamentary process ahead. And just put a pin in that, Mr. Chair, that's something that we'll want to discuss going forward, as well as whether we want to link to a bill that is here being it's being implied that it could violate numerous sections of the Charter. B, Part 3, recommendations for amendment to Bill C-26. Cybersecurity will not thrive in darkness provides substantive analysis and recommendations to address a series of thematic deficiencies identified in Bill C-26. We agree that these recommendations are appropriate in the spirit of addressing overarching deficiencies, including secrecy and transparency issues, and the need to incorporate guardrails for the new government powers that the bill creates. As a result, Part 3 provides a summary of Dr. Parsons' recommendation, as well as comments and supplementary recommendations flowing from the Charter analysis in Part 2. So Part 2, Bill C-26 and the Charter towards a human security approach to cybersecurity. In analyzing the proposed amendments to Canada's Telecommunications Act in Bill C-26, Dr. Parsons identified the following thematic deficiencies in the proposed legislation. Bullet 1, the breadth of what the government might order a telecommunication provider to do is not sufficiently bounded. Excessive secrecy and confidentiality provisions in the bill threaten to establish a class of secret law and regulation. Significant potential exists for excessive information sharing within the federal government as well as with international partners. Costs associated with compliance with reforms may endanger the viability of smaller providers. Vague drafting language means that the full contour of the legislation cannot be assessed. There is no recognition of privacy or other charter-protected rights in Bill C-26 as a counterbalance to the proposed security requirements, nor are appropriate accountability or transparency requirements imposed on the government. These thematic deficiencies relate to the effectiveness of the government's cybersecurity strategy, as well as to potential risks to charter-protected rights. Like the Canadian Radio, Television and Telecommunications Commission, CRTC, the federal government must act in a manner that is consistent with the Charter when regulating in respect of telecommunications services and cybersecurity. Following the publication of Dr. Parsons' report in October 2022, including his recommendation that the federal government table a charter statement in relation to Bill C-26, the federal government tabled its charter statement in the House of Commons on December 14th, 2022. The quote, non-exhaustive, end quote, statement identifies areas where charter protected rights are engaged by Bill C-26. The statement, however, does not fully address relevant charter-related issues linked to Bill C-26. In the following paragraphs, we raise additional charter issues to, first, inform the appropriateness of amendments recommended by Dr. Parsons, and second, to underscore the importance of bringing a human rights and human security approach to cybersecurity and regulation of telecommunications services. Equality rights and Section 15 of the Charter. This section identifies examples of equality-related issues that could foreseeably arise during the government's implementation of Bill C-26. We raise the potential for adverse impacts in the implementation of orders and regulations under Bill C-26 in order to provide guidance to this committee about the importance of ensuring that the transparency and accountability mechanisms surrounding Bill C-26 are fit for purpose to guard against foreseeable risks. As noted in paragraph 6, accountability and transparency gaps are a thematic deficiency in Bill C-26, which are the subject of recommendations throughout Part 3 of this brief. In 2019, the federal government passed the Accessible Canada Act. The Act recognizes the importance of the economic, social, and civic participation of all persons in Canada, and to allow all individuals to fully exercise their rights and responsibilities in a barrier-free Canada. The Act notes equality and non-discrimination rights protected under the Canadian Charter of Rights and Freedoms and the Canadian Human Rights Act, which are implicated by laws and public policies affecting the accessibility of telecommunication services. Access to affordable, high-quality telecommunication services is unevenly available in Canada. Government measures that have the effect of exacerbating the digital divide for charter-protected groups may result in discrimination under Section 15 of the Charter. If orders in council, ministerial orders, or regulations issued under Bill C-26 are implemented in a manner such that disadvantaged communities are disproportionately exposed to security vulnerabilities or disproportionately unable to access network service, it perpetuates the disadvantage experienced by charter-protected groups, thus engaging Section 15 of the Charter. The following are examples of equality-related issues that are foreseeable when considering the types of orders or regulations that may be imposed under the broad powers proposed in Bill C-26. A. Firstly, barriers to affordable telecommunication services place a particularly heavy toll on low-income communities in Canada. There is a close connection between poverty and the historical disadvantage that is experienced by groups protected by Section 15 of the Charter. As a result, government orders or regulations that impose material costs on telecommunications services may result in heightened barriers to access, which would disproportionately affect historically disadvantaged communities. B. Secondly, government orders or regulations that hinder efforts to redress regional disparities in access to telecommunication services in Canada, such as disparities between Indigenous communities and the rest of Canada when it comes to accessing high-speed internet services, can also disproportionately affect charter-protected groups under Section 15. Thirdly, persons living with disabilities may also be impacted in unintended but foreseeable ways by orders and regulations issued under Bill C-26. For example, measures that slow the availability of secure network services may slow or impede secure access to assistive technologies enabled by connected homes or communities. As another example, orders or regulations that mandate the deployment of certain cybersecurity measures could bind companies to cybersecurity tools that are not accessible. While physical environments are more traditionally integrated into accessibility and inclusivity frameworks, cybersecurity tools often assume, quote, that users are fully abled, example, can see CAPTCHA, cognitively impaired, example, can create and retain passwords, have the necessary resources, example, time, appropriate technology, and internet access in a distraction-free environment, and have the required dexterity to interact with the security system. Example, can use the mouse and keyboard with ease, close quote. Fourthly, network insecurity and privacy risks also expose certain groups to heightened threats. Civil society, including dissidents, journalists, opposition politicians, lawyers, and family members, are routinely exposed to targeted threats, hacks, and digital espionage. If governments and regulators fail to address persistent vulnerabilities in our network services, including the widespread abuse of telecommunications networks described in Finding You, certain groups, including communities protected by Section 15, may be disproportionately left in harm's way. As an alternative, hypothetical, cybersecurity measures mandated through orders or regulations could lead to the unintended creation of new or worsening security flaws. Dr. Parsons provides the example that, quote, in the process of prohibiting an upgrade, known good security patches, hardware upgrades, or service offerings in the same update package might also be blocked, close quote. Ultimately, these tensions highlight the overarching importance of inclusivity in setting security standards and the corresponding importance of regulating telecommunications in a transparent and accountable way that enables the government's cybersecurity approach to be fully
Mr.
integrated.
Bachrach, it is your right to do so. Point of order. Sorry, Mr. Strahl. I have a point of order from Mr. Bachrach.
I'm really struggling, Mr. Chair, to follow what my colleague Mr. Strahl is talking about. So I'm looking at I think it's clause 124 in the act that the bill C-33 that we're debating tonight. And it reads that if Bill C-26, introduced in the first session of the 44th Parliament and entitled an Act for Cybersecurity, amending the Telecommunications Act and making consequential amendments to other acts, receives royal assent, then on the first day on which both Section 18 of that Act and Section 123 of this Act are in force, subsection 2, sub 3 of the Transportation Appeal Tribunal of Canada Act is replaced by the following text. Now,
point of order.
It seems to me, well, you can't.
Point of order during a point of order. He's in the middle of explaining his point of order.
I'm helping your filibuster.
But this would seem like it's debate, and I would love to hear Mr. Bachrach's interjection.
I'm just trying to give my colleague, Mr. Strahl, a chance to, take a breath, take a drink of water, But this is actually a serious point of order because I know. Is he off camera at least? I won't go further down that line of thought, but I digress, Mr. Chair. So, Clause 124 just references Section 18 of the of Bill C-26. Now, Section 18, and I was looking for it on my phone, but I'm struggling to make a connection between. I'm worried you're not going to be able to rule on my point of order if you're not listening, Mr. Chair. I demand your attention.
Maybe you should challenge him, Taylor.
Well, no, but on a serious note, it refers to Section 18 of Bill C-26, and looking at Section, I don't think it's in order, to refer to the entirety of Bill C-26, but rather only to the portion that is referenced in the clause that we're currently debating. and that section is section 18. And so I'm wondering maybe if the clerk or one of the legislative personnel could, our witnesses, right? Yes. I wonder if our witnesses could help me.
Can't do this in a point of order, Mr. Chair.
This is venturing into debate, I would fear. I look forward to hearing Mr. Baccarat's points, but he's on the speaker's list.
But the point of order is around relevance. And in explaining my point of order, I believe that it would only be relevant if it deals with Section 18, and perhaps it's partly a question through to the legislative clerk as to the extent of relevance. Like, if a clause references a specific section of an act, is it therefore relevant to refer to other parts of that act? Because I'm listening carefully to Mr. Stroll's contribution, and it seems to me that he's reading at length. I had 6 hours of subject. I know.
C2, 3,
bear
4.
Bear with me. It seems like he's reading references to the act that don't pertain to Section 18. Man, it's hard for me to maintain my train of thought here. I'm quite fixated on Section 18 of Bill C-26, and I wonder if the witnesses could help us understand what is in Section 18 so that you may determine as chair whether what Mr. Strahl is contributing is relevant to that section, seeing as it's the only section of Bill C-26 that is referenced in Bill C-33. That's. I wanted to read Section 18 into the record, but I can't find it. This is my point of order on relevance, and I'm waiting for the chair to rule on relevance.
So what I will do is I'll turn it over very briefly to the witnesses so that I can get an answer to that question before I rule, and I'll turn it over to you, Ms. Heft.
Thank you. Section 18 of Bill C-26 is a provision that ensures that the Transportation Appeal Tribunal of Canada has jurisdiction to review administrative monetary penalty issues or notices of violation that are issued under the Critical Cyber Systems Protection Act. So where you can issue an administrative monetary penalty under that act, we have to ensure that where that is issued to a transportation undertaking, that the proper tribunal has jurisdiction. That's what Section 18 does.
Okay. So, Mr. Chair, on my point of order, I would be happy to discuss and debate that aspect of Clause 124. But it feels like the debate that we're currently having does not relate to Section 18, and Section 18 is the only section of C-26 that is referenced in Clause 124. So I just want to bring it back to the core, because this is a very important clause and obviously worthy of detailed debate. And I'm hoping that you can encourage Mr. Strahl to come back to this very important Section 18, which deals with administrative monetary penalties.
Thank you, Mr. Baccarat. And I will do just that, and I'll kindly ask that Mr. Strahl try and keep his remarks, which have been quite informative, to the topic at hand, and make reference to 124, which we are indeed discussing. So I'll remind Mr. Strahl of that and turn the floor back over to him.
Well, thank you, Mr. Chair, and I think it's important to, again, if we look at Bill C-33, the title says Coordinating Amendment, and then the subtitle is Bill C-26. If Bill C-26, introduced in the first session of the 44th Parliament and entitled An Act Respecting Cybersecurity, Amending the Telecommunications Act and Making Consequential Amendments to Other Acts, receives royal assent, that is what I am talking about. And it does not say, the title does not say if Section 18 of that act receives royal assent. It talks about the bill, and the bill, Section 18, cannot be considered in isolation from the rest of the bill. So I'm sorry that, and perhaps Mr. Baccarat, when he gets the floor in a more fulsome way, can indicate why he thinks we should focus solely on a certain section, but it's very clear in my reading of Bill C-33, which again, we are discussing whether or not we believe that there should be coordinating amendments with a piece of legislation, which is Bill C-26, which is, and as the witness just said, this is about cybersecurity. Section 18 is about cybersecurity, and it's about how we deal with threats to cybersecurity in the transportation space. And I've highlighted numerous of the briefings have referenced the transportation sector as being one of the key sectors that is impacted by Bill C-26. So certainly I don't think we can consider one section of a bill. It's not a private member's bill that amends one section of a bill that we're considering here. This is the entire bill. As is said in the title, Bill C-26, if Bill C-26 receives royal assent, then these following issues happen. So I'm expressing, putting on the record some very serious concerns about Bill C-26, and I'm hopeful as I continue to read from these people that are very concerned about things like the implications on the rights of Canadians under the Charter. I believe that I know that Mr. Bacharach is a fan of the Charter and certainly would want to ensure that any clause that he voted on, that the concerns of individuals who spend their lifetimes defending Charter rights are considered, and that he would want to have knowledge of what this bill that is referenced directly, the entire bill, not just one section, the entire bill, the impact that it could have on the Charter rights of Canadians. So I will continue to talk about Bill C-26 in its entirety, because that is a piece of legislation that includes the relevant section that he's talking about. It's not a standalone clause that has been introduced by the government. This does not specifically indicate that if Section 18 remains unamended or taken on its own, could receive royal assent. It talks about Bill 26 receiving royal assent. So I appreciate the latitude that is given to members of Parliament to raise their concerns and to share the concerns of Canadians when we're considering a piece of legislation as important as Bill C-33, and which cross-references specifically, purposefully, Bill C-26, which is also currently before this House. So I appreciate the spirit in which Mr. Bacharach's comments were made. However, I would simply believe that I don't believe you can consider Section 18 in isolation. When considering Bill C-26, we would do Bill C-26 and what it means to Canadians a disservice if we simply talked about Section 18. Now, I will get to that part of when we break down the detailed analysis of the clause, but this is the information that I believe is relevant to consider whether or not we can support Clause 124. So I will continue because I know that it would be extremely out of order to rule talking about a bill that is specifically referenced by title and by in the first part of this clause that we weren't allowed to talk about that bill in our deliberations here. So I will hopefully not miss any of the information that I made here. If so, I would apologize to Citizen Lab for not exactly getting all of their words into there. So I'll start back again at the freedom of expression and Section 2B of the Charter, which states that the current draft of Bill C-26's excessive secrecy and confidentiality provisions jeopardizes the right to freedom of expression under Section 2B of the Charter. The government's charter statement focuses on the speech of the commercial entities who will be directly regulated under Bill C-26. The charter statement posits that because restrictions on commercial speech do not tend to implicate the core values of Section 2B, restrictions can be more easily justified. However, this analysis fails to account for how individuals' charter rights may be impeded under the current drafting of the legislation. The excessive secrecy and confidentiality provisions in the bill also restrict the public's and media's expressive freedom in Canada. The principles of open courts and open government are derivative components of Section 2B of the Charter, the freedom of expression. The open court principle requires that court proceedings, including judicial reviews in federal court, presumptively be open and accessible to the public and to the media. Access to information about government actions can also arise as a derivative right to Section 2B if a denial of access to government information effectively precludes meaningful public discussion on a matter of public interest. Where restrictions on access substantially impede meaningful discussion and criticism about matters of public interest, the government must reasonably justify its infringement on the freedom of expression. Telecommunications and cybersecurity law and policy is undoubtedly a matter of public interest. There is a close nexus between human rights and public policy concerning the regulation of telecommunications services. Canada's telecommunications policy is intimately linked with the social and economic fabric of Canada and its regions. Equitable access to telecommunications services is sometimes described as a mechanism for digital self-determination, which speaks to the need to protect the potential for human flourishing in the digital era. The recent Citizen Lab report, Finding You, highlights several ways in which excessive secrecy surrounding telecommunications oversight has in itself endangered the public. The authors note historical deficiencies in oversight and accountability of network security, which have led to geolocation-related threats associated with contemporary networks. Excessive secrecy has contributed to the persistence of the, quote, low-hanging geolocation threat identified in Finding You. Decades of poor accountability and transparency have contributed to the current environment where extensive geolocation surveillance attacks are not reported. This status quo has effectively created a thriving geolocation surveillance market while also ensuring that some telecommunications providers have benefited from turning a blind eye to the availability of their network interconnections to the surveillance industry. The geolocation surveillance threats discussed in Finding You disproportionately jeopardize human rights defenders and other individuals who faced heightened risks of targeted security threats, that is, corporate executives, military personnel, politicians and their staff, senior bureaucrats, etc. Industry has historically charged large amounts of money to receive information about well-known industry threats, with the effect of impeding non-industry groups such as security researchers and civil society from obtaining and disseminating information about the nature of the threats faced by at-risk individuals, or from advocating for the remedies that would benefit the security and privacy of civil society. The authors note that, in many instances, individuals cannot determine whether their own telecommunication provider has, quote, deployed and configured security firewalls to ensure that signaling messages associated with geolocation attacks, identity attacks, or other malicious activity are not directed toward their phone, close quote. Citizens Lab research highlights the substantial public interest in enabling the media.
Sorry, Mr. Strahl, I have a point of order from Mr. Backrack.
My apologies, Mr. Strahl. I am going to ask the chair to rule on the relevance of your intervention, mostly because I feel like we've kind of lost the room and people are no longer hanging on your every word, as important as
On the
the
point of
text
order.
that you're reading from may be. And so, further to my previous point that I don't feel like this really speaks to Clause 124, I'm going to ask the chair to rule on my point of order on relevance.
On the point of order.
Mr. Kirk?
Thank you, Chair. And whether or not people are paying attention, I certainly have been riveted by the information that Mr. Stroll has been sharing. And I think he had outlined very specifically after the previous intervention how this does, in fact, have relevance. And to note, it was not Conservatives who wrote this bill. It was the government. And the fact that it does, that both the principles of relevance speak to some latitude that can be given, but I would suggest that that is not even necessary in this case, because what Mr. Stroll has been, I think, very, very articulately doing is bringing forward a series of points that had been presented related to a bill that Bill C-33 references in its widespread application. So, Chair, I would urge this to be that this is not only relevant but very prescient to the larger conversation that we are having here before us.
Thank you, Mr. Kirk, and thank you for that point of order, Mr. Bachrach. I see no reason to stop Mr. Stroll mid-discussion. He is addressing an aspect that is included in this bill and bringing up a concern that he feels is legitimate, and so I will give him the floor.
Me greatly to do this because I have such deep respect for you as a chair, but I'm going to have to challenge that ruling because I really feel like we've strayed from the topic at hand, and I would love to talk about Clause 124 and these administrative monetary penalties under the
Mr. Chair.
Communication Act, Critical Cyber Systems Protection Act, International Bridges and Tunnels Act, Canada Marine Act, Motor Vehicle Safety Act, Canadian Navigable Waters Act, Marine Liability Act, and the Transportation of Dangerous Goods Act. So,
on that point, Mr. Chair,
I don't think it's not debatable.
But had the chair ruled?
Yeah,
I did. I ruled that he had the right to continue speaking, and therefore I was overruled.
Been debating my own.
You can rule on whether I get to continue to speak. You can overrule the chair on that.
Yeah,
I don't think so.
I think you have to have the floor to do that. No.
And ask for your indulgence, colleagues, as I confer with the clerks. So, Mr. Bachrach, with regards to that, unfortunately, what has been explained to me by the clerks is that challenging the chair on this would essentially equate to you putting forward a motion to impede another member from being able to speak, which there's a direct way of doing things and an indirect way of doing something. And I didn't think it was, but that would be the conclusion. That would be the result of us allowing for you to challenge the chair on
To
this.
challenge the ruling on relevance?
Yes.
Oh.
Yeah. So unfortunately, I will turn the floor back over, or not unfortunately, you are overruled, and I will turn the floor back over to Mr. Strahl, who, once again, I look forward to.
If I may just get clarity first, so I don't pull this in the future, make this same grievous error in the future. The chair's ruling on relevance cannot be challenged?
So the chair can rule that a member is out of order because there's no relevance.
There's no relevance, yeah.
However, for a chair to say that they are allowing a member, because it is relevant, to be challenged, it then gives the power to the committee to put forward a motion, a quasi-motion, if you will, to deny another member's right to speak.
So what you're saying is that we can challenge your ruling, but what it does is it de facto prevents Mr. Strahl from speaking further?
Yes.
It's just sounding very attractive.
You also can't move a motion on a point of order.
It's not a motion, but the result of it would be as if you put forward a motion to adjourn debate or stop Mr. Strahl from speaking, which we're not allowed to do.
You're not allowed to do. Okay, well.
So I've ruled that already what he is saying is linked to this piece of legislation. And unfortunately, from what I've gathered from the clerk, you cannot challenge that, because by challenging it, if it were to win, the committee would be denying this member their right to speak, which is something that only the chair has the power to be able to do if the chair decides that what he is saying is not relevant to the topic at hand.
So I'm just a little bit unclear, Mr. Chair. Like, we can put forward a motion that a member be heard, but we can't put forward a motion that a member not be heard? Just seems like unsymmetrical.
According to the clerk, motions have to be in the affirmative, worded in the affirmative, which is currently not the case. Does that clarify things for you?
Could we adjourn debate on discussion of clause 124?
When our time.
When you get the floor, you can.
Okay, I just wanted clarity because I'm surprised by the inability to challenge the chair's ruling on certain things.
Thank you, Mr. Backrack. I'll turn the floor back over to you, Mr. Strahl.
Well, thank you very much, Mr. Chair. And of course, I believe it's quite fortunate that that the rights of members to speak are being upheld in this case by the chair and by the clerks. And I certainly understand that, as has been said, I'm no longer capturing Mr. Backrack's attention or offering him something that he feels is compelling. But that's not really my job, to keep him entertained. My job is to speak to the bill and to, as you said, there is a direct link, whether the government now regrets putting it in there because we're now talking about it, or hope that this would just be breezed past, that Bill C-26 would be considered irrelevant, even though it's the title of the clause that we are debating, even though it specifically refers to Bill C-26, if it receives royal assent, the following will happen. And to somehow believe that it's irrelevant to be talking about a bill that is specifically named and specifically referred to as having an impact on this piece of legislation, I think is truly unfortunate. And I appreciate the chair recognizing the relevance of the discussion, despite the fact that clearly the Mr. Backrack and some others might not enjoy the conversation. But I don't operate for Mr. Backrack's enjoyment or entertainment or captivation or any of the other things that he's talked about. So I will continue to read from the relevant information about the relevant.
Just on a point of order, I feel like
point of order, Mr.
Strahl
Backrack
is misrepresenting my remarks. I did not indicate that he was not entertaining me. I did not indicate that what he was saying was not important. What I indicated was that it was difficult to follow the relevance, and that it was difficult to follow the relevance, and it was difficult to hear. And I appreciate that Mr. Strahl isn't in the room with us, but it was difficult to hear his presentation because people in the room were talking about other things, the Christmas party, the different things that are happening that are perhaps of greater interest to people. So I just that was my main contention and why I felt like it was no longer relevant to what we were talking about. It was not meant as a critique of his entertainment value or the importance of what he was reading, and I will listen on with great interest.
Thank you for the clarification on that, Mr. Backrack, and I will try and do my part as chair to keep the chatter down in this room and ensure that members are able to speak and we're able to hear them, even if they're joining us virtually. Mr. Strahl, the floor is yours.
Right. Thank you, Mr. Chair. And if there is a technical issue in the room, if the volume is not being brought up to the appropriate level, I certainly would hope that the chair and others would correct that matter with IT staff who are very capable and I know do a great job of ensuring that members can be heard and that members who are speaking are able to.
Sorry, Mr. Strahl, I have a point of order for Mr. Barcelou-Duval. Mr. Barcelou-Duval, à vous la parole.
Duval, you have the floor, Mr. Barcelou-Duval. I would say that it's been at least 1 hour, if not more, that Mr. Strahl has been reading documents that he thinks are relevant to this bill, and we all have our own opinion about this. But for the benefit of the committee, would it be possible to have an idea of how long this member is intending to continue reading these documents? Just so we know if anybody else is going to have the opportunity to speak before the end of the meeting, because I think this is important for everybody. Thank you, Mr. Barcelou-Duval.
Mr. Badaway, Mr. Couric, Dr. Lewis, Mr. Muse, Mr. Lewis, and Mr. Backrack. And therefore, I'm sure the members would like to possibly know. Oh, and Mr. Patzer, who's just indicated to me once again that, yes, he did want to speak. Yes, thank you very much. Thank you for reminding me. So I guess the question is a relevant one to Mr. Strahl, just so members are aware of when they can expect to be able to have the floor, if at all, Mr. Strahl.
Well, I am just getting started, Mr. Chair. I have so this document, I will read it till the end, and then I will probably have some other documents that I believe, some other briefs that are very important that give some great insight into this Bill C-26, which is extremely relevant. So I will speak until I believe that my point has been made, which evidently I still have some work to do to convince some members of the committee that we should be concerned about this bill and its link to Bill C-33. So I'll continue reading this document until it ends, and then at the end of every brief that I submit to the committee, that I read into the record, I kind of take stock then and determine whether or not I believe that the point has been received or if that there's no further relevant information. So I'm sorry I can't give a more specific answer. I know we're 8 minutes away from Mr. Yakino's next break, but I will continue reading this particular document here, if because I know many of my colleagues are interested for me to pick that back up. So we talk, the next section of this brief talks about privacy impacts and Section 8 of the Charter. Bill C-26 proposes several new information collection and sharing powers and may include the collection or sharing of personal information. Many of these powers are insufficiently bounded or defined. The potential privacy risks posed by the powers are heightened by the absence of key accountability and oversight mechanisms. The breadth of the supervised information collection and sharing powers heightens the risk that the legislation, if passed as drafted, could unreasonably interfere with Section 8 of the Charter in at least 3 or 4 ways. First, the federal government's charter statement posits that Bill C-26 does not interfere with Section 8, in part as a result of the fact that the information being gathered and shared in this context relates to the technical operations of TSPs, which are commercial entities, as opposed to personal biographical information that attracts a heightened privacy interest. However, Bill C-26 does not explicitly draw this distinction between technical information or other forms of personal information when defining collection or information sharing powers in the bill. Instead, Bill C-26 provides authority to compel a broad array of information holders to disclose a broad array of information. While the charter statement for Bill C-26 emphasizes the regulatory nature of the scheme in Bill C-26, unlike other statutory inspection powers that have been subject to charter challenges historically, there's no reason to interpret the statutory powers in Bill C-26 as applying only to provide information in which there is a low expectation of privacy. Rather, Section 15.4 would provide authority to compel, quote, any person, end quote, to provide, quote, any information, close quote, under, quote, any conditions that the minister may specify, close quote, so long as the minister believes it is relevant to its order-making powers. The persons and entities subject to this provision in many circumstances play an integral role in the lives of people in Canada and may well be information holders in respect of highly sensitive or personal information. Second, while some aspects of Bill C-26 are regulatory in nature, Bill C-26 also creates criminal offenses punishable by imprisonment for noncompliance with specified orders or regulations. Statutory powers authorize collecting and sharing information for the purposes of verifying compliance or preventing noncompliance with those orders or regulations. The legislation therefore creates risks that information will be compelled or shared during investigations pertaining to the criminal offenses created by Bill C-26 or other offenses. Furthermore, the breadth of the order-making powers under Bill C-26 mean that the collection of information for the purposes of making such orders may cause serious consequences that are separate and apart from any regulatory or criminal prosecution. Third, Section 8 also protects privacy by requiring adequate accountability and review mechanisms to accompany information collection powers even in administrative or regulatory contexts. The Supreme Court states that while less exacting review may be sufficient in a regulatory context, the availability and adequacy of review is nonetheless relevant to reasonableness under Section 8. Canadian constitutional law has long recognized that without clearly defined safeguards, often including prior judicial oversight, legislation that authorizes intrusions on reasonably held expectations of privacy is inconsistent with Section 8 of the Charter. In some circumstances, involving searches that are not subject to warrant requirements, the court still expects that additional safeguards will be established to ensure the requisite level of transparency and accountability, and to help ensure that such powers are not abused. For example, requiring notice to the persons whose information is affected allows the affected individuals to identify and challenge invasions of their privacy, as well as seek a meaningful remedy. Appellate courts have recognized a range of accountability measures when assessing the reasonableness of search and seizure powers, such as notice requirements, including after-the-fact notice, reporting obligations to independent institutions of Parliament, the availability of clear mechanisms for review of the exercise of collection powers, clear rules limiting collection powers to what is necessary, reasonable, and proportionate, and record-keeping requirements. Part 3 of this brief will identify several mechanisms that are necessary to improve accountability surrounding the proposed powers in Bill C-26. For example, the draft legislation proposes broad information sharing powers with no notice requirements. This would mean that individuals and organizations whose information has been collected would have no way of knowing of the fact that information has been shared, thus thwarting review and challenge. Individuals who have private information held by and collected from third-party organizations would also not be aware that their information has been collected in the first place, let alone shared with other government entities. Fourth, the extensive confidentiality provisions in Bill C-26 may actually further undermine accountability mechanisms surrounding the bill's proposed information collection powers in ways that would be difficult to reasonably justify under Section 8. Section 15.4 of the proposed Telecommunications Act authorizes the minister to require any person to provide any information under any conditions that the minister may specify. These conditions would foreseeably include conditions to extend confidentiality obligation to the minister's use of collection powers. The secrecy provisions in Bill C-26 and the authority to extend those secrecy obligations through further conditions could effectively chill or silence individuals or entities from notifying other persons that their personal information has been collected, or from challenging the exercise of government power. Furthermore, excessive secrecy surrounding
I just don't want you to go on to furthermore just yet. As I promised to some members, we will break now. It's 9 p.m. We will ensure that everybody has a 10-minute break for the benefit of all members as well as our witnesses. So this meeting stands suspended for 10 minutes. Back to order, and I'll turn the floor once again to our esteemed member of the committee, Mr. Strahl.
Well, thank you, Mr. Chair, and thank you for giving me the reference point to begin my comments again, which start with furthermore. Excessive secrecy surrounding existing orders or regulations would further undermine accountability, as courts or oversight bodies wouldn't be able to assess whether collecting or sharing of information was reasonably necessary and proportionate in furtherance of those secret orders or regulations. In short, it is unclear how the proposed confidentiality and secrecy provisions align with the need for accountability measures to ensure there is not an inappropriate intrusion into Section 8 Charter rights. The Charter statement notes various information sharing agreements that are contained in the legislation. However, there are broad information sharing powers in Bill C-26 that are not subject to any information sharing agreements or limitations on how the information may be used once shared. Furthermore, the majority of the Supreme Court has previously noted, in the context of other information disclosure powers accompanying supervised warrant provisions in the Criminal Code, that information sharing agreements are not a panacea, given that there is always a risk that a foreign law enforcement agency may misuse the information disclosed. Part 3. Towards more secure, transparent, accountable governments and telecommunications networks in Bill C-26. This Part 3 summarizes recommendations identified in Cybersecurity Will Not Thrive in Darkness, as well as supplementary comments and recommendations flowing from the Charter analysis set out in Part 2. The report, including its specific textual recommendations, is enclosed as Appendix B. Where recommendations are identified in this brief for the first time, they're numbered with letters, that is Recommendation 1A, to maintain the original numbering of the report. So here's some recommendations. Limiting powers to order modifications to organizations' technical or business activities, to include appropriate safeguards surrounding compulsion powers under Bill C-26. Cybersecurity Will Not Thrive in Darkness makes the following recommendations. Recommendation 1. Orders in council and ministerial orders must be necessary, proportionate, and reasonable. Currently, the legislation allows the government to issue an order when necessary to secure the Canadian telecommunications system. However, necessity is an insufficient curb on the government's power. Bill C-26 should impose more conditions regarding the specific circumstances under which the government can exercise its power. Recommendation 2. Orders should include a reference to timelines. The legislation should be amended to include a requirement that telecommunications providers must implement cybersecurity demands or orders within a reasonable period of time in situations where compliance with a demand or order would require significant or material changes to the recipient's business or technical operations. Recommendation 3. Government should undertake impact assessments prior to issuing orders. Government assessments of its orders should identify secondary or tertiary impacts that would have the effect of worsening an organization's cybersecurity practices or stance. These assessments should be presented to telecommunications providers, along with any demands or orders or regulations that are based upon these assessments. Such assessments should be included in any and all proportionality analysis of government demands or orders. Recommendation 4. Forbearance or cost minus clauses should be inserted. The government may issue a direction that could severely alter how a telecommunications provider is able to offer a service to customers. The legislation should be amended such that telecommunications providers can seek forbearance of certain orders where implementing them would have a material impact on the provider's economic viability. Alternatively, if an order or regulation would have a deleterious effect on a telecommunications provider's economic viability, and the government demands that the order be fulfilled regardless, the provider should be compensated on either a cost or cost minus basis. Recommendation 5. The standards that can be imposed must be defined. Without a clear definition of what a standard in the draft legislation entails, it becomes difficult to assess what kinds of standards the government is seeking to implement and whether it is adopting them safely. The legislation should be amended such that it is clear what kinds of standards are within and outside of the scope of the legislation. The evidence and analysis in Finding U underscore that urgent action is needed to establish mandatory security and privacy standards for telecommunications providers, to require security postures that address the vulnerabilities in signaling protocols that enable mobile geolocation surveillance threats. It should also be made explicit that an order or regulation compelling the adoption of particular standards cannot be used to deliberately or incidentally compromise the confidentiality, integrity, or availability of a telecommunications facility, telecommunications service, or transmission facility. The intent of this recommendation is to prevent the government from ordering or demanding that telecommunications service providers deploy or enable lawful access-related capabilities or powers in the service of securing infrastructure by way of adopting a standard. 2. Secrecy and absence of transparency or accountability provisions. As noted above, Bill C-26 has, quote, extensive and overly onerous secrecy and confidentiality requirements. Laws that impose meaningful limits on the freedom of expression must be balanced and reasonably justified. While some confidentiality will be appropriate to ensure that unresolved security vulnerabilities are effectively brought into control, certain powers in Bill C-26 go further than what is required to accomplish cybersecurity and national security objectives. Furthermore, certain powers proposed are unaccompanied by reasonably available measures to protect the public's interest in access to information concerning an important area of government action. In light of identified deficits concerning excessive secrecy or the absence of accountability provisions, we reiterate the following recommendations from Cybersecurity Will Not Thrive in Darkness. Recommendation 6. Orders should appear in the Canadian Gazette. Bill C-26. In Bill C-26, orders are required to be published in the Canadian Gazette, but the minister has the authority to direct otherwise in the order. As such, the result is that the government might issue orders that never appear in the Canada Gazette, and there is no requirement for the order to ever be published in a complete and non-redacted format. The potential effect could unjustifiably restrict meaningful public debate on a matter of public importance and, as a consequence, the freedom of expression. The legislation should be amended such that orders must be published within 180 days of issuing them or within 90 days of an order being implemented based on whichever condition is met first. The legislation also expressly defines circumstances that should also expressly define circumstances that justify secrecy. Recommendation 7. The minister should be compelled to table reports pertaining to orders and regulations. To better safeguard the public interest, privacy, and the freedom of expression, the legislation should be further amended such that the Minister of Industry is required to annually table a listing of the number of orders and regulations that have been issued, the kinds of orders or regulations that have been issued, the number of telecommunications providers that have received the orders, the number of telecommunications providers that have partially complied with the orders, the number of telecommunication providers that have completely complied with the orders, a narrative discussion of the necessity, proportionality, reasonableness, and utility of the order-making power. Recommendation 8. Non-disclosure orders should be time limited. Bill C-26 also proposes gag provisions with respect to orders in council or ministerial orders which are not limited either temporarily, that is, how long is secrecy necessary, or substantively, that is, what circumstances justify secrecy. As noted at paragraph 15, non-disclosure orders affect not only the recipient of the gag order, but also the public's right to information that informs democratic debate. The legislation should be amended to include time constraints surrounding non-disclosure orders. Recommendation 8A. The circumstances purporting to justify confidentiality in a non-disclosure order should be defined in the legislation. Recommendation 9. The CRTC should indicate when orders override parts of CRTC decisions. The legislation should be amended to, at a minimum, require that the CRTC post a public notice attached to any of its decisions where there is a contradiction between its decision and an order in council or ministerial order or regulation that has prevailed over part of a CRTC decision. Recommendation 10. An annual report should include the number of times government orders or regulations prevailed over CRTC decisions. The legislation should be amended to require the government to annually disclose the number of times it has issued orders or regulations that prevailed in the case of an inconsistency between a given order or regulation and a CRTC decision, as well as denote which CRTC decisions were affected. Recommendation 11. All regulations under the Telecommunications Act should be accessible to the Standing Joint Committee for the Scrutiny of Regulations. The legislation should be amended such that the Standing Joint Committee for the Scrutiny of Regulations is able to obtain, assess, and render a public verdict on any regulations that are promulgated under the proposed draft reforms to the Telecommunications Act, as well as on regulations pertaining to the Telecommunications Act and that are modified pursuant to Section 18 of the Statutory Instruments Act. 3. Deficient judicial review process. Bill C-26 contemplates that telecommunications providers may initiate judicial review proceedings in respect of orders or regulations issued under the proposed legislation. In pages 22 to 24 of his report, Dr. Parson identified problems that would arise if Bill C-26 is passed without amending Section 15.9. As drafted, Section 15.9 would permit a series of mandatory limits on open court principles, which would prevent judges from exercising judicial discretion in balancing the need for secrecy or confidentiality with the public's interest in disclosure. As noted at paragraph 15 in this submission, the Charter protects open court principles that apply in the context of judicial review, including Charter protections for the freedom of expression. Cybersecurity will not thrive in darkness recommends, recommendation 12, that Bill C-26 should explicitly enable appointment of amicus curiae or a special advocate during judicial review. The legislation should be amended such that at the court's pleasure, amicus curiae or a special advocate can be appointed to contest and respond to information provided by the government in support of an order in council, ministerial order, or regulation under Section 15.8, in when evidence is sufficiently sensitive to bar a telecommunication provider's counsel from hearing it. We also recommend Recommendation 12A. Section 15.9 should be amended to ensure the judge retains authority to balance the public interest in disclosure against the interest in confidentiality. In general, mandatory limits on open courts, which prevent the judge from balancing the public interests at stake, are generally viewed as excessive infringements on Section 2B rights. For example, even in analogous provisions of the Canada Evidence Act, permitting secrecy in judicial proceedings for matters injurious to international relations, national defense, or national security, or endanger the safety of any person, the judge retains the authority to determine that, quote, the public interest in disclosure outweighs in importance the public interest in non-disclosure. The same safety valve should be incorporated into Section 15.9 of Bill C-26 in order to ensure that any limits to openness minimally impair freedom of expression. Recommendation 12B. Where summaries are provided of evidence and information received by the court pursuant to Section 15.9, Sub 1, Sub C, these summaries must also be available to the applicant and the public. As noted at paragraph 15, the open court principle protects the public's and the media's interest in the openness of court proceedings. Practically speaking, the public's right of access to judicial summaries of this nature is typically accomplished by making such summaries as an exhibit to the proceedings. The public's right of access to exhibits is a corollary of the open court principle. Recommendation 12C. The triggering threshold justifying limits on the openness of the proceedings should not be higher than that which is already contained under analogous provisions of the Canada Evidence Act. In that regard, we recommend mirroring the language from the Canada Evidence Act through the following amendment. Section 15.9, Sub 1, Sub A. If in the judge's opinion, the disclosure of the evidence or other information should be changed to would be injurious to international relations, national defense, or national security, or endanger the safety of any person. 4. Extensive information sharing within and beyond Canadian agencies. Bill C-26 proposes to create broad information sharing powers within and beyond government agencies, without accompanying those powers with necessary limits, oversights, or accountability mechanisms. As noted at paragraph 24, the absence of reasonable procedural safeguards to review government powers that infringe upon privacy interests can render legislation invalid under Section 8 of the Charter. To impose more appropriate guardrails on the proposed powers to share information within and beyond Canadian agencies, recommendations 13 to 20 of Cybersecurity Will Not Thrive in Darkness are the following. Recommendation 13 and 14. Relief should be available if government mishandles confidential, personal, or de-identified information. The legislation should be amended to enable individuals and telecommunication providers to seek relief should the government or a party to whom the government has disclosed confidential, personal, or de-identified information loses control of that information, where that loss of control has material consequences for the individual or for a telecommunication provider's business or technical operations. Recommendation 15. Government should notify telecommunications providers how it will use collected information and which domestic agencies information will receive the information. Recommendation 16. Information obtained from telecommunications providers should only be used by government agencies for cybersecurity and information assurance activities. Information should not be used for the purposes of signal intelligence and foreign intelligence activities, cross-department assistance unrelated to cybersecurity, or active or defensive cyber operations. These restrictions should apply to all agencies. Recommendations 17 and 18. Data retention periods should be attached to telecommunication providers' data and to foreign disclosures of information. The legislation should be amended to highlight that confidential information will be retained only for as long as necessary to make, amend, or revoke an order under Section 15.1 or 15.2 of a regulation under paragraph 15.8 sub 1 sub A, or to verify the compliance or prevent non-compliance with such an order or regulation. Similarly, an amendment should also require that the government attach data retention and deletion clauses in agreements or memoranda of understanding that are entered into with foreign agencies. Retention periods should be communicated to the affected telecommunications providers. Recommendation 19. Telecommunications providers should be explicitly informed which foreign parties receive their information. Given that foreign parties can use information to launch investigations and bring non-penal charges against providers, the government should provide some notice when telecommunication providers' information is being or has been shared for cybersecurity purposes. Recommendation 20. Legislation should delimit the conditions wherein a private organization's information can be disclosed. As drafted, Section 15.7 sub 1 appears to set an excessively low threshold for disclosing information and could enable significant sharing of private, if not confidential, information to address unspecified threats that are not set out in the legislation. Proposed textual amendments are found on page 30 of Cybersecurity Cannot Thrive in the Darkness. 5. Costs associated with security compliance. As noted above, imposing substantial costs of compliance on telecommunications providers may have the potential to impact upon the accessibility of telecommunications services, the digital divide, and charter-protected rights or interests. To address concerns surrounding the costs associated with security compliance, Cybersecurity Will Not Thrive in Darkness makes the following recommendations. Recommendation 21. Compensation should be included for smaller organizations. There should be a mechanism whereby smaller telecommunications providers, example, those with fewer than 250,000 or 500,000 subscribers or customers, that have historically been conscientious in their security arrangements, can seek at least some temporary relief if they are required to undertake new, modify existing, or cease ongoing business or organizational practices as a result of a government demand or order or regulation. Such relief may be for only a portion of the costs incurred and thus constitute a cost minus expense formula. Recommendation 22. Proportionality and equity assessments should be included in orders or regulations. The results of these assessments should be taken into consideration by the government prior to issuing an order or regulation, should be provided to telecommunications providers alongside associated orders or regulations, and should be included in any evidentiary packages that may be used should a telecommunications provider seek a judicial review of any given order or regulation. Recommendation 23. Government should encourage cybersecurity training. The government should commit to enhancing scholarships, grants, or other incentives to encourage individuals in Canada to pursue professional cybersecurity training. 6. Vague drafting language. The last set of recommendations pertain to ambiguities in Bill C-26. Notably, Bill C-26 does not specify the kinds of security threats that might be addressed by orders or regulations, fails to define key concepts like interference, manipulation, and disruption, provides the minister with unnecessarily open-ended powers, and lacks clear guidelines as to how personally identifiable information that is obtained from telecommunications providers is to be treated. As a result, Cybersecurity Will Not Thrive in Darkness makes the following recommendations. Recommendation 24. Clarity should exist across legislation. The government should clarify how the envisioned threats under the draft legislation, including threats against the threat of interference, manipulation, or disruption, compare to the specific acts denoted in Section 27, Sub 2 of the CSE Act, quote, mischief, unauthorized use, or disruption, end quote, with the goal of explaining whether the reformed Telecommunications Act would expand, contract, or address the same classes of acts as considered in the CSE Act. Recommendations 25. Explicit definitions for interference, manipulation, and disruption should be in legislation or else publicly promulgated. Recommendation 26 and 27. Ministerial flexibility should be delimited, that is, remove open-ended language around powers such as, quote, among other things. In the event that a corresponding amendment is needed for ministerial powers constrained to emergency circumstances, those powers should be subject to judicial review in federal court, including assessment for necessity, reasonableness, and proportionality. Decisions emergent from review should be published by the federal court. Recommendation 28. The legislation should make clear that personal information and de-identified information is classified as confidential information. As noted above, the federal government's charter statement appears to conclude that it is not the intent of Bill C-26 to authorize the collection and sharing of personal information. If that is the case, the legislation should expressly say so. Alternatively, personal and de-identified information should be treated as confidential. Recommendation 28A. Individuals should be explicitly informed if their information has been collected or shared. If the federal government does not expressly state that personal and de-identified information should not be included in collection and sharing powers, it should ensure that notice obligations are extended to individuals whose information is impacted by the collection and sharing powers under Bill C-26. Recommendation 29. Prior judicial approval should be required for the government to obtain personal or de-identified information from a telecommunications provider. The information is further to be used exclusively for the purposes of making, amending, or revoking an order under Section 15.1 or 15.2 or a regulation under paragraph 15.8 sub 1 sub a, or of verifying compliance or preventing noncompliance with such an order or regulation. Recommendation 30, the government cannot disclose personal or de-identified information to foreign organizations. Part 4, concluding remarks. We urge this committee to take seriously the recommendations that were identified in Cybersecurity Will Not Thrive in Darkness. We note that most of these recommendations have been either reiterated or expanded upon by the joint submission to the committee submitted by civil society organizations and individuals. In detailing these recommendations for this committee's study, we also urge the committee to consider the additional charter interests that are engaged by Bill C-26, including equality, non-discrimination, freedom of expression, and privacy, as described in Part 2 of this brief. We echo Dr. Parsons' view that cybersecurity efforts through Bill C-26 should seek to build trust between the government and non-government entities, including the general public, and that independent bodies, including the Privacy Commissioner of Canada, National Security and Intelligence Committee of Parliamentarians, or National Security and Intelligence Review Agency, should be integrated into the government's assessments of the necessity, proportionality, and reasonableness of orders in council, ministerial orders, or regulations. Citizen Lab's recent report, Finding You, documents continuing vulnerabilities at the heart of the world's mobile communication networks. The report's findings underscore that cybersecurity has not thrived in darkness. Historical and continuing deficiencies in oversight, transparency, and accountability of network security have led to serious geolocation threats, geolocation-related threats associated with contemporary networks. The report notes that the failure of effective regulation, accountability, and transparency has been a boon for network-based geolocation surveillance. While Canada needs to move forward in combating threats to its telecommunications and critical infrastructure, it should not do so at the expense of democratic norms and safeguards, public transparency and accountability, or respect for the Charter and human rights. Rather, a human security and human rights approach to cybersecurity requires the recognition of the importance of accessible and inclusive cybersecurity, public accountability, and public transparency when regulating telecommunications and cybersecurity. So that the rest of it is just a bit of a biography of the individuals that were involved in putting that together. So that's I think I've given a fairly comprehensive, a lot for the committee to think about. As we want to go back to section or clause 124, which deals with specifically with Bill C-26, and what I think that I certainly I certainly recognize that that there are some who didn't want to have this conversation, but I think that with this provision in this bill, Bill C-26 being such a key part of this clause, that we need to consider whether or not we should support a clause that contains linkage to a bill that clearly has so many glaring errors, where so many critical civil society organizations have come forward and said that this is something that we need to amend. We need to make changes because there are significant concerns with the impact on privacy, significant concerns about the impact on data sharing, the significant concerns with government reporting when they do collect information from individuals or other entities. So I believe that we should give strong consideration to voting against this particular clause, and I think that the information that I've provided should formulate part of that discussion. But I know that other members also have some concerns that they want to share with the committee. And so, Mr. Chair, I would turn the floor over to the next speaker, but I would like to, while I still have the floor, to just indicate that if you could put me on the end of the speakers list as well, I'd like to hear what my colleagues have to say and then have the opportunity to follow up as well. So if you could add me to the list and perhaps just give us all a reminder here as I turn the floor over what that list looks like, and what and just make sure that I do have a place now at the end of that list. Thank you, Mr. Chair.
Thank you, Mr. Stroll. The list as it stands right now is Mr. Badaway, Mr. Kirk, Dr. Lewis, Mr. Muse, Mr. Lewis, Mr. Backrack, and Mr. Patzer. Nope, Mr. Lewis. Oh, Mr. Lewis is no longer here.
And Mr. Stroll at the end of that, please.
And Mr. Stroll.
Thank you.
Okay. And with that, I will turn the floor over to Mr. Badaway.
I'm wondering if you might consider rationing time, given the length of the speakers list and the fact that as of now we only have an hour and 45 minutes. And there are breaks built into that. I'm just worried that we're not going to hear from every member on the list. And just in the interest of sharing time equitably between speakers, I wonder if we could discuss rationing.
Unfortunately, Mr. Backrack, that is inadmissible. And I look to Mr. Badaway for the following remarks. The floor is yours, sir.
Thank you, Mr. Chairman, and I thank Mr. Stroll for the opportunity. After his riveting 2-hour intervention, with that, I have to say, Mr. Chair, that we will be supporting Clause 124. But I'm sort of perplexed over the process right now. All of a sudden, when we're down to our last, I think, 3 or 4 clauses to pass, including the amendments attached to same. And I say perplexed simply because we've been going through clause by clause, right from 1 now to 124, I believe, out of about 126 clauses, not including the schedule, the short title, the title of the bill as amended, reporting the bill to the House, and of course the last very important clause or motion, which would be whether we order a reprint or not. So, and I'm sure that will be a 2-hour discussion as well. But with that all said, I'm perplexed because, Mr. Chair, we've had a great deal of discussion and debate on all the clauses. And that discussion was very important because those clauses included amendments, which brings me to my point. If there was such a concern, what the process includes, and I have to give a lot of credit to both the NDP and Bloc, who brought many amendments forward, and the CPC brought, Conservatives brought a few forward as well. The reason why I'm perplexed, Mr. Chair, is if there's concern, why under 123, 124, of which we're speaking about right now, going into 125, and I'm sure we're going to have another 2-hour discussion about that, no amendments were brought forward by the Conservatives. You would think, like, from 1 to 124, the concerns brought forward, valid, and I respect that, amendments that I would only assume were put forward to deal with those concerns, voted on after debate, and moving forward in an expeditious manner, only to now come to the last 2 or 3 clauses. And of course, we've been discussing those last 2 or 3 clauses for the past 4 meetings. So, Mr. Chair, I'm actually a bit confused. Why? I've been here for 8 years. Oh, thank you, Taylor. Appreciate that. I feel special now.
Did I give you the right one? I gave you the Annie's.
Oh, you mean Annie's? Well, now I don't feel special anymore.
I don't have one for you.
Oh, see. Am I on the naughty list? Yeah. So, Mr. Chair, I just again, I can't understand Mr. Straw and members of the Conservative Party. If in fact, and to expedite this bill, if in fact, like we have in other bills in the past, if in fact there's concerns and there's some thoughts given to the different clauses, I would actually recommend that we don't spend 2 hours reading a document that's been around for quite some time, and actually let's get some work done by bringing some amendments forward and polishing out some of the clauses that in fact some of the members might have a concern with. Thank you, Mr. Chair.
Thank you very much, Mr. Badaway. I know Mr. Kirk has been waiting patiently, and therefore it is a pleasure for me to turn the floor over to him. Mr. Kirk, the floor is yours.
Thank you very much, Chair, and I appreciate the remarks that my colleague, Mr. Stroll, had made, especially in light of just the how the interconnectedness of Bill C. 33 and past Bill C. 26 is, and how in light of those connections that it becomes incredibly relevant, and to just address a few of Mr. Badaway's previous points. I find it perplexing myself how the Liberals seem to have this tendency to find concern with anything or anyone who is unable to simply buy what they're selling hook, line, and sinker. And certainly when I hear from constituents, of which I do on a very, very regular basis, it is they encourage me to do everything I can to ensure that I am being their voice in the nation's capital. And when it comes to some of the legislation that may not always garner the headlines maybe that it deserves, and certainly Mr. Strahl had mentioned and in the brief that he had presented before this committee, I think that it's important for Canadians to know how the discussions that we have before, whether it's the Transport Committee or the various other duties that all of us undertake on a regular basis here in the nation's capital, the important connections that do in fact take place. And just to note, if you would permit me, Mr. Chair, I had endeavored to have a discussion, and I would just to point out, I even had an object lesson. This is a 2019 Rural Alberta Special Areas wheat that I had looked forward to discussing in the context of Bill C-234. Now, I wouldn't want to be off topic from the conversation around the bill we have before us today, but certainly just to express my disappointment that we didn't have the opportunity to discuss that common sense conservative bill that would have brought needed relief to families and support our great farmers from coast to coast. But I do want to ensure that I do stick to the conversation that we have before us when it comes to the way that the bill that this committee is studying and the impact that some of the that when as Mr. Strahl had started, when you have the a bill that references a previously passed bill, and one of the concerns that has been highlighted, and certainly it's not limited to this one, but when briefs are submitted, sometimes they don't get the due opportunity to be engaged in. So I do want to and sorry, the fact that C-26 is currently being studied at committee. You know, I think that it speaks that this interconnectedness, and I know conservatives have endeavored to.
Oui, Monsieur Barceau-Duval.
Oui, je suis désolé, je viens de me rendre compte.
I'm sorry.
Sorry.
C'était pas idéal.
I believe that my sound is not very good. I do hope that it's working. Yes, we can hear you well. Thank you very much. Thank you, Mr. Chair. The reason I am speaking, and again, I haven't written down the name of the member who was speaking. Unfortunately, I was unable to write down his name. But when on screen, you see his computer, his tablet, you are seeing some points referring to the Conservative Party. And I'm wondering if this would not be partisan signage, and I would like to hear you speak to that. How should this be managed at committee? Thank you, Mr. Chair.
Merci, Monsieur Barceau-Duval. Je pense que Monsieur Kirk
Thank you, Mr. Kirk. I believe you have just hidden your computer, no?
Thank you, Chair, and I would, and if the camera points back, I do in fact have a sticker. I know that specifically the member for Kingston in the Islands, as well as a number of other members in the House of Commons, seem to put stickers all over the other side of their laptops and iPads and whatnot that reference different messages, and so certainly I would hope that you would indulge me, but if it bothers
Mr. Kerr, I will
my
have
colleague,
to unfortunately ask you to cover that
so,
up.
So I have done so. It's now out of the line of camera. However, there is another sticker there that speaks to Noah's Law, which I'd be happy to discuss, and certainly is not partisan in nature. But and I know it would be somewhat off topic. That.
Monsieur le Président.
Mr. Chairman.
So the clerks are asking for the symbols to be removed. If you can perhaps put your name tag in front there. This is a rule that applies to all members in all committees. I'm just going to refer with the clerk. Can you see the imagery? Your visual team to put the camera back on Mr. Kirk.
Thanks very much, Chair. I believe now, if you look at it, you know, I find it fascinating. You know, especially the fact that.
Point d'ordre, Monsieur le Président.
Oui, Monsieur Iacono.
Right. Yes, Mr. Iacono. Could we perhaps focus on Bill C-33? I do not see how the member is bringing clarifications, but he's really going in circles at this point. So currently, we're wasting time. Thank you, Mr. Iacono.
Ask the member to address his comments with relation to the law at hand.
Yeah,
thank you, Mr. Kirk. The floor is yours.
I do find it interesting that sometimes when there are interventions in points of order, and we see this in the House on a regular basis, it's the idea of talking in circles and some of the spurious suggestions about subject matter and whatnot. But certainly, I am happy to
Point d'ordre, Monsieur le
address.
Président.
Oui, Monsieur Iacono.
Yes, Mr. Iacono. Point of order. I don't believe that Canadians are interested in listening to the member going in circles. I believe that Canadians want to hear about substance, so he should continue focusing on the bill. Otherwise, I will continue to take the floor, because I think what he's telling us is leading to nothing. He should focus on the bill. Thank you, Mr. Iacono.
Remarks addressed to the law at hand, the bill we're discussing. Thank you.
Absolutely, Mr. Chair. And, again, I do just find it fascinating how when one endeavors to bring points and one will point out stickers on their laptops, and I would encourage that member in particular to speak to his colleagues that do put stickers on their laptops, even in the House of Commons, because certainly that is...
He has red paint on the walls behind him.
Point of order?
We can keep going.
Point of order, Mr. Chairman? Mr. Iacono? Point of order? I don't have any stickers. I don't have to be concerned with that. But I think it is important that we remain serious tonight. And I hope that he's aware of the fact that Canadians are watching us. They will see what he and his colleagues have brought to this debate. And I'm not interested at 10 o'clock at night in hearing him speak about these and about these stickers. I don't believe that I have any lessons to learn from him or from any others. We're here to debate a bill. And truly, I would like us to focus on that and that we stop running around in circles, because I can do that as well. I have the entire evening before me, so I can start having fun, as my colleagues are seeking to do. Thank you, Mr. Iacono.
To the logos and stickers on your computer, I believe, has been dealt with. We thank you kindly for that, and I would ask you to begin your discussion and your debate with regards to the bill and the matter at hand.
Thank you very much, Chair. And it was interesting that member says to keep it serious. And certainly, I would suggest that when he shut down my earlier conversation about C-234 and the impact that has on my constituents, that is of the utmost seriousness. And the fact that member refused to allow that discussion to take place and the impact that has on my constituents, he should certainly look in the mirror if he thinks that it is simply, a joke that there are farmers that are going bankrupt in my constituency and across Canada because of the imposition of that party's carbon tax upon Canadians. Now, when it comes to the issue at hand, and specifically how C-26 has clear relevance in relation to the...
Call to order, Mr. Chairman, again.
No, la parole est à vous. Point d'ordre.
So I'd like that member to look at himself in the mirror and to realize what he did on the weekend in all those votes that they opposed in helping Canadians in many different ways.
Thank
so
you,
if
Mr.
there's
Iacono,
anybody
I
to
think
be
that's
embarrassed,
debate,
it should be him.
And thank you very much. I'll turn it back over to you, Mr. Kirk.
And certainly, it's not only Conservatives that don't have confidence in those Liberals, but an increasing number of Canadians that have no confidence in the Liberals' ability to manage the country. And I certainly hear that on a regular basis. So again, if that member wants to be serious, happy to have that conversation. When it comes to the issue of Bill C-26, and I'm glad to have now the opportunity after that member's push towards talking in circles, I am glad to have the ability to get back to the subject matter at hand. I have a article here before me from the business law section of the American Bar Association that I think bears particular relevance to the conversation that we are having here before us. And Chair, if if you would indulge me, I believe that it has this specific, this context that is so important for being able to enter into the discussions that we have before us, and the clear relationship that, and in particular, I do find it interesting, and I'll jump into this article here in a moment, but how this provides important context for the way that the Liberals wrote the legislation. Does provide a great deal of latitude for how there's two separate bills that are before Parliament, and certainly they're taking great liberties when it comes to the assumption that things will pass, especially in a minority Parliament. But that issue aside, but the way that the legislation was written in particular speaks to how the larger conversation, and especially how it's different committees that study different aspects of these bills. And I know that C26, there was certainly some concern that was brought forward, and I am a member, a regular member of the Ethics Committee, and some of the challenges in relationship, and I know Mr. Stroll and some of the interventions that he had brought forward had referenced this, that there are some specific impacts that are noteworthy. And when it comes to the critical infrastructure that is being addressed in the context of C33. The way that the Liberals have taken the liberty in the writing of the bill that has that wide swath of expectations through to another bill, it certainly creates that context and why this is so relevant. So this article that I will be referencing, Chair, and look forward to this being a part of the discussion here this evening, talks about the Critical Cyber Systems Protection Act. And it goes as follows. The CCSPA introduces a new cybersecurity compliance regime for designated operators of critical cyber systems related to vital services and systems, or designated operators. A critical cyber system is defined as a cyber system that, if its confidentiality, integrity, or availability were compromised, could affect the continuity or security of a vital service or system. Currently, the list of vital services and systems is comprised of the Canadian telecommunications system, the banking system, and other federally regulated industries such as energy and transportation. However, the Governor and Council may add new vital services and systems, and such designated operators will be governed by the CCSPA. Now, I would just take a brief pause there, and I think that the introductory paragraph to this article that I'm entering into the conversation here speaks to that direct relevance to the larger conversation related to Bill C-33. So the article goes on to say, under the CCSPA, designated operators must establish a cybersecurity program, details of which are more fully provided in the CCSPA and its regulations within 90 days of an order being made by the Governor and Council. It must also implement and maintain a cybersecurity program as well as annually review it. It goes on to say, mitigate cybersecurity threats arising from their supply chains or products and services offered by third parties, share their cybersecurity programs, and notify appropriate regulators, namely the Superintendent of Financial Institutions, the Minister of Industry, the Bank of Canada, the Canadian Nuclear Safety Commission, the Canadian Energy Regulator, the Minister of Transportation, and the appropriate regulators of material changes related to the business of designated operators and their cybersecurity.
Point d'ordre, Monsieur le Président.
Oui, Mr. Bartholomew.
Oui, j'ai de la difficulté à faire le lien.
Point of order. Yes, Mr. Basu-Devat. I have a hard time tying in the words of my colleague and Bill C-33, so I don't know if it would be possible for my colleague to clarify to us the connection between the two, or if he could perhaps shorten his preamble in order to, for the benefit of all the members and for the efficiency of this committee. Thank you, Mr. Basu-Devat.
Thanks, Chair. And it's interesting. Happy to address the point of order that was just raised, Mr. Chair. And it was not Conservatives that wrote this bill, and when the Liberals did so, they did with a reference to C-26 26. So if that member has concerns about the wider application about this bill, I would suggest that he has an opportunity to get on the speaking list and ask those very questions, because when it comes to some of the way that there is that cross application, certainly it bears that relevance, and it's because the way that it was written provides that very application. So I would continue there, Mr. Chair, by saying that. Additionally, C26 report cybersecurity incidents to the Canadian Security Establishment, or the CSE. It goes on to say to comply and maintain the confidentiality of directions from the Governor and Council and keep records related to the above. It then goes on to summarize to enforce these new obligations, the CCSPA grants the appropriate regulators investigatory, auditing, and order-making powers, including issuing administrative monetary penalties, AMPs, of up to $1 million per day for individuals such as directors and officers, and $15 million per day for other persons. Additionally, designated operators and their directors and officers may also be fined or imprisoned if a director or officer, if either contravenes specific provisions of the above act. The amount of the fine is at the discretion of the federal court. Now, that's the Critical Cyber Systems Protection Act, but also has this article goes on in its summary of Bill C-26 to reference the Telecommunications Act amendments, and I found it very valuable in terms of that conversation, and how, of course, when we talk about the application to C-33, there is a tremendous amount of overlap when it comes to telecommunications and the critical infrastructure that our country depends on. So it goes on to say, the amendments to the Telecommunications Act, the amendments establish new order-making powers for the Governor and Council and the Minister of Industry, hereafter referred to as the Minister, to direct telcos to take specific actions to secure the telecommunications system. Specifically, the Governor and Council may, by order, prohibit, this is number one, prohibit a telco from using all products and services offered by a specified person, and direct a telco to remove all products provided by a specified person. It goes on to say that the Minister, after consultation with the Minister of Public Safety and Emergency Preparedness, may, by order, prohibit a telco from providing services to a specified person, and direct a telco to suspend any service to a specified person. Additionally, the amendments grant the Minister the power to direct telcos to do anything or refrain from doing anything that is, in the Minister's opinion, necessary to secure the Canadian telecommunications system. And it includes a number of points here, but I would just note and make this connection to some of the evidence that Mr. Stroll had brought into the conversation here from some of the briefs that were entered to the committee, and how, in the context of some of the concerns that especially civil liberties groups, privacy. I know that there's a host of experts, and again, as a member of the ethics committee that deals with privacy, there's a host of concerns that have been brought forward, and we have a great deal, especially because of the tech industry that has found its home both in my province in Alberta, where there's a huge a boom in the high tech sector there, but I know in other areas across the country. In fact, I believe that Ottawa was known as if I could stand to be corrected here, but this area was known as Silicon Valley North at one point in time. So it's certainly privacy and the security related to that. There's a specific tension there that in some of the evidence that Mr. Stroll had read into the record, I think it bears that specific relevance to this larger conversation and how that applies to the infrastructure, the transportation infrastructure of our nation. So what the summary goes on to talk about C26. It includes the following, and there's a number of summaries here that really succinctly identify some of what C26 talks about. And it starts off by saying it prohibits telcos from using any specified product in or in relation to telcos network or facilities or part thereof. Prohibiting telcos from entering service agreements for any product or service, requiring telcos to terminate a service agreement, prohibiting the upgrade of any specified product or service, and subjecting the telcos' procurement plans to a review process. And it goes on to say, Mr. Chair, interestingly, telcos will not be compensated for any financial losses resulting from these orders, although it was noted, I believe, in the debate surrounding C26 that they wouldn't anticipate there to be a large number unless it started getting into the firms. However, that's certainly an open question that I trust will be answered as C26 is further studied in their committee. But I wouldn't want to venture off of the topic that we have before us. The amendments goes on to say, the amendments introduce new enforcement powers for the Minister of Industry to monitor the telco's compliance with the orders or future regulations, including investigatory powers and issuing AMPs of up to $25,000 to $50,000 per day for individuals such as directors and officers, and up to $10 to $15 million per day for other persons. Moreover, contravention of orders or regulations may result in prosecution, whereby the telcos and their directors and officers may have to pay fines whose amount is at the discretion of the court or face imprisonment.
My apologies for cutting you off. I just wanted to make sure that that raised hand that Dr. Lewis has is not a point of order or should not have any technical issues that needs to be addressed. I'm sorry, Dr. Lewis, I can't hear you. You're on mute. I still can't hear you, Dr. Lewis, unfortunately. I still can't hear you, Dr. Lewis.
Can you hear me now?
I can indeed.
Okay, sorry, I guess it was switched off. No, that's not a point of order. I guess I could take it down now since my name is on the list, correct? I thought
Or next, Dr. Lewis.
Right. So I thought you said that we should keep it up just in case. So that's why I still have it up.
I saw your camera was off. I thought perhaps you were trying to get my attention for a audio-visual issue, but everything seems fine.
Okay. Thank you.
Thank you, Dr. Lewis. I'll turn it back over to you, Mr. Kirk.
Thank you very much, Chair, and I certainly look forward to hearing what Dr. Lewis has to say about this, and I know has a great familiarity with this subject matter. Chair, if I could continue, because I do again want to ensure that this is added to part of the record, and I just mentioned how telcos will not be compensated, and I believe I had provided a brief interjection about some of the commentary that has been provided at other committees in relationship to compensation for financial losses, and certainly in the highly regulated telecom environment that Canada faces itself in, that it would be a massive conversation that we could have at some point, but certainly that would be venturing into the territory of not being relevant, so I wouldn't want to go there. I would, however, continue by this summary that talks about the amendments, introduce new enforcement powers for the Minister of Industry to monitor the telco's compliance with the orders or future regulations, including investigatory powers and issuing AMPs of up to $25,000 per day of individuals such as directors and officers. And Chair, as that summary brings to a significant ability and discretion, as and again this relates to, but this summarizes from the perspective of from a legal perspective some of the commentary that was in the brief that Mr. Stroll had provided. And I think that the reason why I want to ensure that this is part of the record, because this is certainly they're not endeavoring to take a specific position, but rather to ensure that there is as nonpartisan, and as hard as that is to believe by certain members of the committee that certainly I'm sure have seen my debates in the House, it's important and valuable that that perspective be included. So it then goes on to say, in regard to information sharing and secrecy, the CCSPA and amendments require designated operators, telcos, and any other person to share confidential information with the appropriate regulators and governor in council and minister respectively. In furtherance of the objectives of this bill, this confidential information may be shared with multiple federal government organizations, provincial and foreign counterparts, as well as international organizations to pursue the objectives of the CCSPA and the amendments. While these information exchanges will be governed by agreements and memorandums of understanding between the parties, the minister may disclose the information if is necessary in the minister's opinion to secure the telecom system. Given the national security purpose underlying this bill, the secrecy of the orders is paramount. The orders from the governor and council and minister may be subject to non-disclosure requirements. Moreover, for the sake of secrecy and expediency, the orders and directions of the governor and council and minister do not follow the complete process outlined in the Statutory Instruments Act and thus are not registered, published, or debated in an open manner. And certainly I think that when it comes to, again, that relationship, it's important to acknowledge the widespread, and I know we've had a number of discussions, and I would note, including one of the sections that we passed here, when I think there was a desire for further debate, but it was able to, it ended up being moved forward, that there is a tremendous amount of latitude that is being given to executive government when it comes to some of the powers that are associated both with C-26 as it relates to C-33, and one has to be aware in the granting of power to executive government. That is certainly something that Parliament is able to do, and that under our Westminster system is, but it's important to keep in mind the larger tension that needs to exist to ensure that we do not forget at the very foundation, and this is incredibly relevant to not only this, but everything we do here, to ensure that we do not forget that that the government is only a function of Parliament. And I know that's something that can be a little bit lost in the midst of conversation. And I know that that very statement has even been deemed controversial at different points in time. And it was earlier this week that we celebrated the Statute of Westminster, where we brought home the Constitution. And I would note that that was an incredibly significant moment in Canadian history. But the reason why that is so relevant to the conversation here today is because it's Parliament that enacts laws that give the government its authority. And I would just note how we have seen, I would suggest, we have seen various instances throughout recent history, and in particular the last 8 years, where there has been more latitude given than I would suggest is appropriate, and how there are times that we could ensure that Parliament is able to better fulfill its job by a government that respects the fact that whether it's committees or whether it's the role that the House of Commons and the Senate, in terms of our bicameral Parliament, play in ensuring that that it is the ultimate arbiter of the land. So we have, and in fact, our Constitution in the Charter of Rights and Freedoms actually ensures that that is in fact the case, with the notwithstanding clause, which I know the Liberals have. In fact, I believe it was Paul Martin in a previous election. Now this is getting back. I couldn't even vote at the time, if members around the committee table can believe that. But it was Paul Martin that had, during a press conference, announced that he was looking at getting rid of that. I'm not sure that he understood the consequences, both in terms of the constitutionality or the amending ability of Parliament to be able to do that. However, when it comes to the relationship to the issue before us, we have these wide sweeping powers being given to executive government. And if there is not the appropriate accountabilities, as the American Bar Association in this article is highlighting, it would be the clear, we need to have clear direction to every element of what government is, to ensure that that there is that check on executive government. And if it was, and I do find it interesting, and I'll get right back into the ABA, and this article has a number of recommendations, and I would just note there's two quite distinguished lawyers that put together this article that gives this overview of Bill C-26 and how it applies in the context of the where C-33 is, but specifically, Chair, if one can never assume that they'll be in power forever. And whether that's the Liberal Party or the Conservative Party, if we have the honor, and I certainly hope we do, and look forward to those days when we'll have the opportunity to govern on behalf of Canadians. But I find one always needs to look in the mirror. And in fact, I've asked in the House quite a number of times that what would the government think if they were in the opposition benches about something that they were doing? Not necessarily the policy, because the policy is one thing. You can disagree with policy, but you need to be very, very mindful about how one approaches the ability for a parliament to function in a manner to which respects the very basis of what our democratic system is meant to be. So, Chair, when it comes to the wide-ranging powers that are given to executive government, we do have to be very, very mindful that there's certainly a role that executive government needs to play in the administration of infrastructure, the administration of security and intelligence, and all of the aspects of what we're talking about here. But when it comes down to it, Parliament is supreme in our country. And we cannot forget that. And to ensure that I don't venture off into an area that would be deemed not relevant, I certainly won't spend time talking about a few examples of that. But there's some very, very pressing issues, and one of which would be the designation of the IRGC as a terrorist entity. Parliament spoke on that, yet we have executive government that refuses to acknowledge. And I use that as an emphasis, not to get into the details of that issue, although it's certainly one that dominates a lot of our time in light of the atrocities that are taking place, that took place against Israel, and how Iran and the IRGC specifically funded and supports Hamas as a terrorist entity. But the fact that there's that disconnect is the point that I'm making here, and that speaks very, very closely to why we need to be very circumspect in the way that we approach the role of executive government. There's that understanding, it has to come back to respecting Parliament. And if I had had the opportunity to talk about Bill C-234, I certainly would have at length talked about how that bill saw a great deal of support, including Liberal support by a few Liberals, a few brave Liberals that were willing to support that bill. But unfortunately, it was not able to get the support that it, I believe, should have received from the other place. But again, I wouldn't want to go into the area of not being relevant. So when it comes to recommendations, I would...
if you may, I'm just going to cut you off there. I will give you the floor back, but I had promised when I outlined when we would be taking breaks, that we would be taking a break at approximately around this time. So I will...
Of course.
I'm 6 minutes early. I'm getting looks of discontent that I would like to address.
Well, I can assure you I won't move a vote or anything if...
No. I mean... I'll ask everybody please to be back here. We'll make this one short, 5 minute break, and then we'll have 1 hour left before we adjourn for, quite a long time actually. So we'll suspend for 5 minutes. Call this meeting back to order, and I turn the floor back over to Mr. Kirk.
Thank you very much, Chair. I hope everybody was able to have a good short break. The 7 or 8 minutes of freedom that people had, as I'm sure they're thrilled to get back to the important conversation that we have here before us. I would, however, Chair, just note, and specifically because I know the 2-hour time change, of course, where I am proud to represent back in Alberta. I would just note that my wife is just putting and finished probably putting my kids to bed. So certainly to my boys, I love you guys. Hopefully you're listening to your mama as she puts you to bed. And look forward to connecting with my wife after post 11:30 after this committee wraps. Of course, that's one of the big things when our families are back home, holding down the proverbial forts. Chair, where I'd left off, I just talked a little bit about the wide sweeping powers associated with how Parliament and we live in a democracy where the idea of parliamentary supremacy is absolutely paramount, and I believe unpacked adequately in the context. Certainly have a whole host of other things to say about that, but wouldn't want to dive too deep into that in the short time that we have here. However, I did want to make sure that I do get to the recommendations that this article does reference in terms of Bill C-26. It goes to say, and I'll summarize this and then have a few other important interjections that I look forward to being able to make. Given that the bill has just been introduced, this, of course, article is a little bit dated, but nonetheless very, very relevant. And being that its passage is not guaranteed, and additional changes to the draft law, or in the Canadian context, bill, may occur. However, and in the interim, if you are a provider of vital services, which speaks to that vital connection that we have with Bill C-33 here before us, and systems as described in the bill, we recommend that you consider taking the following steps to improve your cyber resilience. First is preemptively improve your security posture and processes to confirm with the CSE's best practices and guidance or industry practices, and ensure that your contracts contain sufficient cybersecurity provisions to protect all parties in the supply chain. And given the secrecy and potential immediacy of government orders and directives, telcos and designated operators should draft contracts to flow down potential cybersecurity risks appropriately. And then this, which is, I think, a little bit unique in terms of some of the recommendations that have been made in the context of this bill. The authors go on to talk about how if you are a supplier of products and services related to critical cyber systems of designated operators as described in the bill, we recommend that you consider taking the following steps. Preemptively improve your security posture and processes as described immediately above in anticipation of a more strenuous cybersecurity requirement requested by designated operators. And the final point in this one, and then I'll look forward to getting into a few other aspects of debate here. The final point is anticipate shouldering more risk when contracting with designated operators and consult with your insurance provider accordingly. And just a big thank you to Lisa R. Lifshutz, I believe I'm saying that appropriately, and Cameron McMaster, the authors of this, which I believe provides a good summary and a few very, very relevant recommendations in terms of the context. And I would just note here as well, we're talking about critical infrastructure, and I know specifically some of the larger conversation surrounding Bill C-33. We have the need for resiliency throughout every aspect of that. So whether it's in relation to security, of course, that is very, very important. Whether it's some of the challenges associated with climate, there has to be that security that does exist there. And that has to be, we have to be mindful of that in the larger context of everything that we are discussing and how relevant that is. And I would just in that light, Michael Dantent, who I believe, if I'm correct in this, and certainly happy to stand corrected, but in an opinion to the opinion piece to the Ottawa Citizen, which I believe is relevant, especially for the C-26 aspect here. And I believe that Michael Dantent had ran for the Liberal Party in the 2019 election, if memory serves. He entered just December 4th. So although it seems like it's been certainly more than a couple of weeks, just last week published this column in the Ottawa Citizen that I believe would be very, very valuable to this conversation. Dantent says in his column to the Ottawa Citizen, he says this, Canadian government must take the time needed to get its cybersecurity bill right. And he goes on to say, Bill C-26, the federal government's stab at shoring up the country's cyber readiness, passed first reading in the House of Commons on June 14th, 2022. The legislation has two thrusts. First, to keep hardware from adversarial states out of Canada's telecom networks. Second, to ensure our critical infrastructure is hardened against a plethora of new digital threats. Nearly a year later, in late March of 2023, C-26 limped through second reading. The bill now rests with the Standing Committee on Public Safety and National Security for review and possible amendment. This law continues to languish at committee 16 months after it first saw the light of day, encapsulates one of its core failings, which in fairness is not unique to this piece of lawmaking, despite showing signs of having been written in a hurry, presumably in hopes of keeping pace with technological change. It's emerging too slowly. By the time it passes third reading, then meanders its way through the Senate to royal assent, C-26 may well have been overtaken by events. The threats it is intended to counter are multiplying far more quickly than the glacial pace of the legislative process appears able to match. What are these threats? The latest National Cyber Threat Assessment from the Canadian Centre for Cybersecurity encapsulates them in language for a government document is remarkably direct. Dantent goes on to say, cyber criminals are rapidly scaling up, evolving ransomware and other attacks into transnational enterprise, while state actors, specifically China, Russia, Iran, and North Korea, are deploying vast resources to attack and undermine open economies and societies by eroding trust in public institutions, the factual foundation on which their credibility rests. You may be tempted to stop reading halfway through, writes CCSE head Sami Khoury. In the forward, disconnect all your devices and throw them in the nearest dumpster. And I would just as a note, Mr. Chair, when I had the opportunity to serve on the Public Safety Committee for a short time in the 43rd Parliament, certainly when hearing briefings from experts, it was eye-opening, to say the least, when you had examples, and I believe it was CSIS in their public report had said there are 4 billion attacks on Canadian cyber infrastructure in the course of a year. Absolutely just mind-boggling, the sophistication and growing sophistication that are the enemies of freedom and of Canada the steps they will take to attack us and our infrastructure. Dantent goes on to say, to counter this, the draft bill offers two pillars. First, a revamp of the Telecommunications Act, giving the Federal Minister of Innovation, Science and Industry sweeping powers to order companies to ban certain products, clients or service providers, with possible daily penalties of up to $15 million a day if they don't comply. And second, the Critical Cyber Systems Protection Act, the CCSPA, as I referred to a number of times in the previous brief, which would allow the minister and an appointed official to order cyber measures in federally regulated parts of the private sector considered essential to national security. These include telecom, energy, and power infrastructure, such as pipelines, nuclear plants, federally regulated transportation, banking, clearing, and settlement. And for all those who are questioning the relevance of the conversation with, this is now my words, Mr. Chair, but for those questioning the relevance of this conversation, Dantent himself speaks to how closely connected this is in terms of the conversation surrounding C-33. Seen from 10,000 feet up, the broad scope of the legislation will appear justified to some. After all, don't significant threats justify dramatic action. But there's a difference between action that is on point and action so riddled with gaps that it will need a reboot the day it becomes law. Christopher Parsons, in a dissection for the Citizen Lab outlined 6 major concerns, any of which would be grounds for disqualification. These include an excess of arbitrary power, too much secrecy, inadequate controls on information sharing within government, potentially prohibitive costs for smaller firms, and that includes the legislation draws no distinction based on scale or industry sector, vague language, and no recognition of charter or privacy rights. Brendan McPhail, in an October 2022 analysis for the Civil Liberties Association, echoes many of Parsons' criticisms, noting Riley that the law joins an increasingly long line of legislation that would fill a clear need if only it were better. If the goal broadly is governance that promotes prosperity, security, accountability, diversity, and equity in a democratic society, then C-26 as drafted should not pass. Is legislation urgently needed? Absolutely. But have the drafters gotten it right? No. Given the blitzkrieg pace of growth in cyber threat vectors, it makes sense to continue to manage these threats on an ad hoc basis, as the minister has been doing with assistance from the Communication Security Establishment and the CCCS, and take the time needed to get that legislation right. Now, thank you, Chair, for indulging me in that, because there certainly is it's important context, and I would just note that the specificity of the criticisms that Dantent brings forward speaks to, and the fact that he did run for the Liberal Party a short 4 years ago, I think speaks to it speaks to 2 things that I'd like to reference. I'm sure there's more that maybe my colleagues would be interested in following up on, but that references indirectly how I first that disconnect that exists between Parliament and executive government. And I would just note, and I know my colleague Mr. Stroll referenced this in a different context a number of times, but we had the conversation surrounding Huawei. Parliament had, in fact, a host of times spoken up telling the government that they needed to act. It wasn't a recommendation, it wasn't a suggestion, but it was demanding action. Yet we see that still, in relation to the security of essential cyber networks in our country, that lack of action, the unwillingness for that action to take place, set Canada back what would be with the advancement and the pace that technology advances, has set Canada back very, very significantly. And I know that it is key to ensure that government is responsive not only to the demands of what Parliament is in terms of an institution, but there's no other place in the country, and this is something that I think bears special emphasis. There is no other place in the country where every part of Canada is truly represented. I find it interesting how there seems to be a plethora of advisory boards and consultations, some of which have more legitimacy than others, but it's truly Parliament that is that voice for Canadians. And I would note that when it comes to, I'm always a little bit hesitant. And maybe more than just a little bit. But when an advisory panel is set up, and specifically, I know there's other bills that are before Parliament that set up some of these advisory panels, and this speaks to the disconnect that exists between Parliament and executive government. But when they set up these panels, it sometimes are so disconnected from those who are impacted, and again, fearing that I would venture into something that would not be relevant. However, when it comes to critical infrastructure, and specifically you look at rail, and I have three mainline rail lines that run through my constituency. I represent about 53,000 square kilometers of what I refer to as God's country, just a beautiful area in east central Alberta, where it's a large space. In fact, it's about the same size as the province of Nova Scotia, just for context for those around the table. But when it comes to I always find it very, very concerning when these advisory panels get set up, and they certainly don't have the best interests of my constituents often in mind, and we saw that, and we are seeing that play out in the so-called just transition, that just truly there is no justice for my constituents, including the thousands and thousands that work in the energy industry, and we see that that was very directly the case when it came to the coal phase-out. The federal government promised to be there, yet they were not. They failed my constituents and failed the people that they said that they would have their back, and certainly I think that speaks to a disconnect between what the role that Parliament should be playing as that ability to represent the people of our country, but also the fact that quite often these so-called advisory panels end up being nothing more than a platform for the government to spout its same talking points, and that's a deeply, deeply concerning trend that we have, and one doesn't have to look any further than the appointments of these so-called independent panels. Chair, it's and the reason why I bring this up, there's a specificity in relation to this, because if we want to ensure that we are passing legislation when it comes to C33 or some of the criticisms that we've leveled at C26 and how the government clearly references both here. They're expecting both to pass, although Dan Tent certainly has a host of criticisms to level at at C26, and I'm hopeful that my colleagues in the Public Safety Committee will be fully engaged when this debate comes forward. But I would suggest that one needs to take very, very seriously the role that we have to play here. So that's part one of the criticisms that I would suggest when it comes to where some of these things are. But then the second part here, Mr. Chair, comes to how, as we develop a infrastructure, we have to take seriously our responsibility to ensure that that is done not only in terms of the demands of today, which is key, but that we are building that for tomorrow. And I would actually reference something that I am quite familiar with. There's two industries that I am very, very proud to represent a pretty significant portion of that. And had we had the opportunity to debate the motion that I was so unfortunately shut down, and I would have talked at length about the impact that agriculture has in the close to 5,000 farms, most of which are family-owned, small operations, small businesses, not the big successful ones that the Prime Minister referenced in question period today. I'm not quite sure what metric he uses for that when they're paying the carbon tax, but certainly it's small operations. But we see how there is this demand for that infrastructure to be secure. Now, that includes the cyber element of that, because we've seen attacks that have shut down significant portions and that have left critical infrastructure in our country at risk. Now, I believe I was in junior high at the time, so this is going back a little while, but when there was a power outage that took place in the northwestern United States, and it was deemed to be an accident, but it shut down New York City in terms of the power, and it shut down a host of other jurisdictions, including some in Quebec and Ontario, and it spoke to some of the interconnectedness that existed in our infrastructure. When it came to more recently, there was a cyber attack that shut down a pipeline system on the eastern seaboard of the United States, and certainly I had mentioned agriculture before, but I also represent a significant portion, in fact, 87% of Canada's crude oil transits through Battle River Crowfoot, some of which is produced there, but 87% of Canada's crude transits through Battle River Crowfoot. So when my colleagues wonder why I'm so passionate about our energy industry, it's because I get it. Now, unfortunately, we seem to have what my father would suggest is city ignorance. I I won't venture too far down that path, Chair, but it's unfortunate sometimes that there's not a better understanding of how important some of this critical infrastructure is, not only to our economy and the billions of dollars. In fact, when I look at the community of Hardisty, and for those from Hardisty, who knows, they might be watching this right now, because I know that they're passionate about educating Canadians on the importance of energy infrastructure and how it is so unfortunate that
Could I kindly ask for relevance and what that has to do
Yeah,
with Section
sure.
124? I think you've gone a little bit off, and I'm just going to try and
for
pull
that,
you back to ensure that we're addressing 124, sir. Thank you.
Sure. Thanks, Chair. And you're right. I was getting a little bit off topic there, but I'll tell you, it's easy to be passionate about the billions of dollars in economic impact that my people have, the people that I am proud to represent. The billions, it's billions of dollars that they have. Yet, unfortunately, the Liberals seem to disregard that and would toss it away for some a dream that certainly is more of a dream than any reality, especially when we could be supplying our partners like Ukraine with clean, green Canadian natural resources. When it comes to Bill C-26 and its relevance here in the C-33 conversation, we have this connection that exists, and why I got down the path of talking about how proud I am of Canada's energy industry is we have this what I would suggest is it's not always recognized how closely connected physical infrastructure and the security associated with that is to the cyber elements of how that works. And I would provide an example, a local example, if I could, Chair. And it's there's a pipeline company that just opened up a new control center in Hardisty. And this is why I went down that path, because I wanted to ensure that this example, which is very, very relevant to both the physical infrastructure that C-33 represents and the reference that it has to cyber security, which is referenced in the yet-to-be-passed Bill C-26. There's this close connection that exists. We have, and we cannot dismiss that. And it also goes further when it comes to our rail systems. You know, it's not out of the realm of possibility to see how there's that close connection that exists between the cyber and physical security side of things. So, Chair, when it comes to how these things are connected, if we don't see Bill C-26 addressing those things appropriately, if it's not responsive to the economic needs, if it doesn't take into account the privacy concerns of Canadians, if it gives too much power to a few individuals in our nation's capital that may not be responsive, if likewise when it comes to C-33, if there's not this appropriate a delegation of authority that takes into account, and I often refer to the word as tension, because I think what could be referred to as the Aristotelian mean. We have to find that correct tension, or that mean place where we have that balance that is able to be had. And I'm fearful that we simply don't get it when it comes to both C-26 and then some of the elements that we have discussed at length. And although most of the clauses have in fact passed, and that's why we're of course referring to C-26 here. So I would share just in terms of the connections that have been made there. I think that hopefully emphasizes my point. I would, however, like to, and of course, there's been a change in who is in charge of the public safety file, and certainly I won't get into the host of criticisms that have been leveled by Conservatives against the ministers, plural, of public safety. They seem to come and go at an alarming rate. But I would, however, like to, from the Canadian Civil Liberties Association, when it comes to some of the concerns surrounding C26, and then I will be happy to cede the floor to my colleagues, which I know have a tremendous amount to add to this conversation as well. And I believe, Mr. Chair, that Dr. Lewis is next on the list. And if I am remembering correctly, it's Mr. Muse that follows her, and certainly look forward to hearing what they have to say on this important issue. But I would summarize that although this letter is dated September 28th of 2022, it bears particular relevance to what we're discussing here today. It's written to the minister and to the leaders of the different opposition parties, including Ms. May as leader of the Green, or parliamentary leader of the Green Party. I think she's now co-leader of the Green Party, I believe is her current title. It is titled a Joint Letter of Concern regarding Bill C-26, and I'll read this directly into the record, Mr. Chair. Dear Minister, we understand that we, the undersigned organizations, are writing to express our serious concern regarding Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. In your press release announcing this legislation, you were quoted as saying, quote, "In the 21st century, cybersecurity is national security." Unquote. We agree, and we share your goal of helping both the public and private sector better protect themselves against cyber attacks. Isn't this very, very agreeable up until this point? The Canadian Civil Liberties Association goes on to say, however, in its current form, Bill C-26 is deeply problematic and needs fixing. I would note, of course, because the stickers on my iPad triggered certain members of this committee, I won't show you, but it's actually bolded. Those previous words there are bolded because the CCLA wanted to make sure that they were emphasized in the context of this conversation. But it says, as drafted, it risks undermining our privacy rights and the principles of accountable governance and judicial due process, which are the fabric of Canadian democracy. The legislation needs to be substantively amended to ensure it delivers effective cybersecurity protections while safeguarding these essential democratic principles. As you know, Bill C-26 grants the government sweeping new powers over vast swaths of the Canadian economy. We believe these powers need to be strictly delimited and accompanied by meaningful safeguards and reporting requirements to ensure Canadians can hold their government and security agencies to account. And this is in bold again, Mr. Chair, and I reference that because it's obvious that the CCLA wanted to ensure that this was emphasized. Put simply, with great power must come great accountability. With a view to improving this legislation, we share with you the following specific areas of concern. 1, opens the door to new surveillance obligations. Bill C-26 empowers the government to secretly order telecom providers, quote, to do anything or refrain from doing anything, unquote. This opens the door to imposing surveillance obligations on private companies and to other risks such as weakened encryption standards, something the public has long rejected as inconsistent with our privacy rights. 2, termination of essential services. Under Bill C-26, the government can bar a person or company from being able to receive specific services and bar any company from offering these services to others by secret government order. This opens the door to Canadian companies or individuals being cut off from essential services without explanation. Bill C-26 fails to set out any explicit regime, such as an independent regulator with robust powers for dealing with the collateral impacts of government security orders. Goes on to mention that it undermines privacy. Bill C-26 empowers the government to collect broad categories of information from designated operators within any time and subject to any conditions. This may enable the government to obtain identifiable and de-identified personal information and subsequently distribute it to domestic and perhaps foreign organizations. And I would just note, Chair, when it comes to the de-identified side of things, that's often an excuse that gets used. And I know in my role on the Ethics Committee, we had a study that was undertaken when it was learned that the government had purchased a huge amount of data when it came to movements during the COVID-19 pandemic, which, although it was claimed to be de-identified, it was there were massive question marks associated with the amount of data that government received and certainly concern. And I know there was an overwhelming amount of concern that I certainly heard, and I would suggest, in fact, I know that's the case, because a number of people reached out to us when they did not hear back from Liberal members of the committee that echoed that didn't echo some of the concerns just about how much information was being gathered, and things like people knew the government could determine when people were going to the grocery store and liquor stores and other things that certainly in a free and democratic society there were concerns about, and it was unclear. And I think that's Canadians are pretty trusting, but they want to be respected. And I think that's when I talk about that tension or that Aristotelian mean that needs to be found, I fear that this government has pulled that tension totally out of whack. However, I digress and get back to what the CCLA has to say. It goes on to say there are no guardrails to constrain abuse. Bill C-26 lacks mandatory proportionality, privacy, or equity assessments or other guardrails to constrain abuse of its new powers. It grants the government powers accompanied by steep fines or even imprisonment for noncompliance. These orders apply both to telecommunications companies and to a wide range of other federally regulated companies and agencies designated under the Critical Cyber Systems Protection Act. Prosecutions can be launched in respect of alleged violations of security orders, which happened up to 3 years in the past. And I would just note, because in a late show that I was a part of yesterday, and I know my colleague actually was there too, I was shocked that the parliamentary secretary from Winnipeg North talked in support of a policy that actually sent farmers to prison. Now, I wouldn't want to go off topic here, so I won't get into the conversation around the wheat board, but my goodness, how concerning is it that the government would support policies that threw farmers into prison for wanting to sell their grain without the government controlling it? My goodness, it is unbelievable that that's the point that these Liberals would go to, and the fact that they still support, even after it was very, very clear that Canadians wanted and farmers wanted the ability to sell their grain without the government controlling them. And truly, it was an unbelievable level of control, which was specifically targeted at the West. And it's quite something to have heard and I'm sure my colleague here would agree with me that it was unbelievable to hear that be brought up in conversation in the House of Commons yesterday, that they would prefer to throw farmers in prison than to have a legitimate conversation around the impacts of, in that case, the carbon
I have
tax.
A point of order, Mr. Iaconu.
President?
Yes, Mr. Iaconu.
I find it very entertaining and very interesting what the opposite member is saying, but there's no relevance.
Thank you, Mr. Iaconu. I would have to agree with Mr. Iaconu. Mr. Kirk, I'm going to have to you once again to keep your comments directed at the issue at hand.
Sure.
Thank you.
Thank you, Chair. I think it was this Prime Minister that said that there was a whole of government approach needed to many subjects. So I find it interesting that these members would prefer to support policies that imprison farmers rather than
Mr. President.
However, I would get back to the C-26 station here and how it is it directly.
Mr. Iaconu again, Mr. Kirk.
Monsieur le Président, on vient de.
Mr. Chair, we just outlined something, and once again, he is resuming his speech. He is insulting us. He is lacking respect to this committee by resuming with the same topic. Could you please remind him that he must focus on the bill at hand? Thank you, Mr. Iaconu.
There's 25 minutes left in the evening. I would encourage you to stick to the matter at hand. Make sure that your remarks are directed at 124. The floor is yours.
Thank you very much, Mr. Chair. And I find it interesting the things that seem to trigger these Liberals when it's their policy that triggers them. But when it comes to the issue that we have here before us that speaks to the end. And now members from the other side are heckling, supporting maybe they should try running on bringing back the wheat board. That would be quite something. And, that's not what I'm here to talk about. I look forward to
Mr. Chair.
Conversation around C-33.
I give the floor to you for a point.
Monsieur le Président, je pense que.
Pour un rappel à l'ordre. I think I said this in English. Maybe he didn't understand, so I'm going to tell you in French. And I did not understand. I don't know which other language I should be using to say the exact same thing, but I do hope that you will be able to make him understand he must stick to the subject. Thank you, Mr. Iacono.
I'm going to ask you to please direct your comments to the matter at hand and perhaps to not take any shots at members of the committee or things that you know will get that kind of a reaction. I encourage you to do so. Thank you, Mr. Kirk.
Thank you, Chair. I do find it interesting that it seems like when I'm right about to get back into the subject, the real meat of the subject matter, that's when members seem to have these spurious interruptions. And I would just note for specifically that members' benefit, I have a great respect for both of Canada's official languages, so he is welcome to address me in whichever language, French or English, that he sees fit. I wouldn't want to deny him that ability, for I do, although didn't have the opportunity because I come from a... Okay.
Oui, Mr. Iacono.
Yes, Mr. Iacono. You know that the language that I choose to speak is not relevant here, and I certainly appreciate that he, unlike some of his colleagues, will be accepting whichever language I want to speak in this chamber and in this parliament. But I would like him to focus on Section 124 and nothing else. And I am going to continue interrupting him as long as he refuses to focus on this. I think we still have 30 minutes. It's not going to be 30 minutes. It will be 1 hour if he continues this way. Thank you, Mr. Iacono.
Floor over to you, and I'll encourage you once again to probably just get directly to the comments that you want to make relating to Section 124.
Thank you, Chair, and I appreciate how close that member is paying attention to my comments. When it comes to the...
Point d'ordre, Monsieur le Président.
Mr. Iacono.
Point of order, point of order. Yes, Mr. Iacono, point of order.
Just for the members concerned, I've been paying attention all night to how ridicule you are in making your comments and just circling and circling and circling around. Just like you have a right to make comments, I'm making my comments now. So please do not insult me, because I do love the challenge. So I'd like you to stick to the business of the committee so that we can complete this night on a friendly tone. If not, I will continue interrupting.
Merci, Monsieur Iacono.
Thank you, Mr. Iacono.
And I appreciate that, and certainly when it comes to the respect I have for all members that are duly elected, I find it very curious the tone that all of a sudden this conversation has taken. I would, however, when it comes to the very direct relevance, and I will quickly finish reading this because I did say, and I know my colleagues want to have an opportunity to intervene as well. There is, let me jump into back to where I was, Chair, and look forward to the relevance of this to the matter at hand. The CCLA goes on to say, secrecy undermines accountability and due process. Bill C-26 enables the government to shroud its orders in secrecy with no mandatory public reporting requirements. While there is an understandable need for some degree of confidentiality in the sphere, the public needs to have a sense of how these powers are being exercised and to what effect its decision makers are held to account. Individuals and services collaterally impacted by Bill C-26 must also be given an opportunity to challenge security orders. The next point is unknowable orders trump public regulation. Bill C-26 tilts the balance so far towards secrecy, its orders and regulations may take precedence over decisions previously issued by regulatory agencies, risking confusion where such regulatory decisions are public while the security orders are not. This threatens the integrity and accessibility of Canada's regulatory frameworks and renders the security-related rules currently in effect unknowable for members of the public. They go on to say, in the next point, secret evidence in court. Even if security orders are subjected to judicial review, Bill C-26 could restrict applicants' access to evidence. The legislation does not include any consideration of security-cleared advocates to be appointed on applicants' behalf, as happens in other national security cases. While such provisions are an imperfect solution for due process, they do provide at least a minimal level of protection for applicants' rights. C-26 even empowers judges to make rulings based on secret evidence that is not provided, even in summary form, to applicants or their legal team. It also places the onus on the target of security orders to bring legal proceedings and with the associated cost burden. Next is power without accountability for the CSE. The CCSPA would let the Communication Security Establishment, Canada's Signal Intelligence and Cybersecurity Agency, obtain and analyze security-related data from companies that Canadians entrust with their most sensitive personal information. This would include federally regulated banks and credit unions, telecommunications and energy providers, and even some transit agencies. The CSE's use of this information is not constrained to the cybersecurity aspect of its mandate, and any uses would be largely subject to after-the-fact review rather than real-time oversight, resulting in a significant deficit in democratic accountability. And their final point, Chair, states that there is a lack of justification. Although the government claims that such sweeping and secretive new powers are required, it has not published any sufficiently comprehensive data establishing the necessity and proportionality of the proposed powers. They conclude by saying, in sum, cybersecurity is important and we need to get it right. All residents of Canada can agree on the need for cybersecurity. However, civil liberties, privacy, and confidence in the rule of law and accountable governance are foundational for that sense of security. It is imperative that in its efforts to deliver strong cybersecurity for people in Canada, the government also ensures accountability and upholds basic rights. As Bill C-26 moves through the legislative process, we look forward to...
Mr. Badaway, point of order.
I'd just like to know what the speaker's list is.
Who's on the speaker's list? We have Dr. Lewis next, then we have Mr. Muse, followed by Mr. Backrack, followed by Mr. Patzer, and then once again Mr. Strahl.
Thank you.
You're welcome. Mr. Kirk.
Thank you very much, Chair, and I appreciate that very timely intervention, because I am just not only concluding this letter, but certainly am looking forward to, and I would just note that as I conclude, I would ask to be put back on the list, because I'm sure there will be further interventions that are required later. You know, I think that I, along with my colleague, Mr. Strahl, and I'm sure Dr. Lewis, forthcoming, will provide some this provides valuable insight into some of the connections that exist between the bill that we have here before us and another bill that is yet to be passed that is before the Public Safety Committee, and certainly finding that correct tension that exists to ensure that we can protect physical transportation infrastructure, the critical nature of that in our country, and to ensure that when it comes to this clause and the connection that it has with the cyber element of that, that it is very, very closely connected. So, Chair, I thank you, and I appreciate the committee's indulgence. And I know that sometimes debate can be heated, but I do just I would take this opportunity to wish all members a very Merry Christmas as we approach that time here in the coming days. But certainly I do appreciate the opportunity to engage on such an important issue, and just to reassure members of the committee that might question my engagement on this subject, I ensure that it is with the utmost respect that I take my role very, very seriously as a representative of that swath of East Central Alberta and about 110,000 people that I have the honor of representing in this place, of which many of which I would note put their confidence in me and the work that I do here, both in terms of the debate on this subject matter and so many other things. So, and I know there's a Christmas greeting coming their way shortly, but a very Merry Christmas to everyone else around this table, and a big thanks to the clerks and translators and everyone else who makes the work we do here on Parliament Hill, including those that sometimes aren't always recognized. A big thank you for helping make democracy work, and I look forward to hearing what Dr. Lewis has to say. And just again, Chair, to note, I'd like to be put back at the end of the speaking list. Thank you.
Thank you, Mr. Couric. Dr. Lewis, the floor is yours.
Thank you. Can you hear me?
We can hear you.
Oh, excellent. Thank you. And thank you, Mr. Kirk. You ended on the exact note that I'm going to start on. And I want to thank my colleagues for highlighting the interconnectedness between Bill C-33 and Bill 26. My colleagues covered the importance of parliamentary supremacy and checks and balances and the need to keep the executive branch in check. And Mr. Kirk ended on the note of the importance of upholding critical infrastructure and ensuring that bills are conducive to that. I'm quite concerned at this time about this particular bill and how it impacts on infrastructure and cybersecurity. And I read a very good article on infrastructure and cybersecurity. It was by Frank Lawrence and Eric Jensen, published in the Fortinet Journal. And when I read the article, what was concerning to me is that it revealed that the G7 nations, that among the G7 nations, and even one of the few G20 nations, that Canada is among those nations without a firm regulatory framework around cybersecurity. And Canada must act to protect the nation's critical infrastructural assets. And the only way to do that is what we're doing here today.
Point d'ordre, Monsieur le Président.
Oui, Monsieur Iacano.
Mr. Chairman, a point of order? Yes, I'm having some issues hearing the interpretation in French. I apologize for interrupting, but I'm having some trouble on understanding the interpreter, hearing the interpreter. Thank you, Mr. Iacano.
Dr. Lewis, are you wearing the government-issued headset?
I'm sorry?
Are you wearing the government-issued headset?
I am, yes.
Okay.
I am. Is it okay now? I did a test at the beginning, and
okay.
it turned out okay. And so
okay, we're getting the thumbs up from Mr. Iacano. My apologies,
okay.
Dr. Lewis. The floor is yours.
No problem. So as I was saying, what is very concerning is that Canada is among G7 nations and even one of the few G20 nations without a firm regulatory framework around cybersecurity. And it's essential at this point in time that when we're looking at Bill 33 and C-26 that we must keep in mind the need for Canada to act to protect the nation's critical infrastructures and the interconnectedness of these two bills. We also know that in 2016, member states of the European Union, the EU, for abbreviation, I just like to abbreviate names and actually state it firstly and then do the abbreviation, because sometimes people, when you use abbreviations, it gets very, very confusing. So the EU passed what was called the most comprehensive cybersecurity bill in the history of the EU. And the bill was called the NIS Directive. And the EU cybersecurity rules which was introduced in 2016, they were actually updated and later ratified in 2023. And they continue to modernize and create this legal framework, which I think is quite instructive in the Canadian context, because it keeps up and it increases the digitization and the evolving cybersecurity threat, which is something that we are actually attempting to grapple with in the present in the present bills that we are contemplating. And so expanding the scope of cybersecurity rules in the new sectors and the entities further improves the resilience. And we have dealt with resilience in this in the infrastructural context, in this committee, we've dealt with resilient infrastructure, and so this is also a very, very important part of what we're talking about in Bill 33. We have seen the problems that a huge infrastructure gap can cause, and one of the problems is the ongoing lack of transparency. And we have seen from, well, in our situation with the taxpayer-funded Canada Infrastructure Bank, we've seen just an unacceptable performance over the last 7 years, and so we want to make sure that built into Bill 33 are mechanisms to make sure that we're not falling into the same traps and shortcomings as we've had with other legislation. Moreover, we have provisions in Bill 33 that also raise concerns to cybersecurity and an incident response capabilities of the public and private sector entities, competent authorities, and in the case that I was discussing before, the EU as a whole, it can be used as an example of a model that Canada could adopt, and when we're contemplating this bill, we should look at, I think, enabling legislations from different jurisdictions. I think that's very, very important. We know that most G7 member states are under the umbrella of the EU. The US, the UK, Japan have separately implemented cybersecurity regulations to differing degrees that I think are also instructive in how we can fuse Bill 33 with 26. Those examples really are instructive in that regard. We also have to look at Canadian businesses and how they continue to be impacted by malicious cyber security and cyber activity. And this ranges from cyber attacks to ransomware and even things that we on an average everyday basis are exposed to. Now, many of these attacks include those on critical infrastructure that accounts for nearly half of the attacks, and many of those go unreported. So this is very, very concerning. The Canadian Centre for Cybersecurity has identified attacks on operations networks. They've also identified attacks on the physical safety, how it would impact on the physical safety of Canadians. And that was published in their biennial publication. I think that was called the National Cyber Threat Assessment. Now, in this context, when we look at the Ministry of Public Safety, we know that they acted to introduce new legislation, the Bill C-26, an act respecting cybersecurity. Now, when we look at Bill C-26, and it's been passed, I believe it's the first stage in Parliament, and that was sometime in November 2022, and went through the second reading in March, I think it was 27th, 2023. Now, Bill C-26 currently sits in committee, and I believe is going into legislation and going into law. If it hasn't done so already, but it's very, very. When we look at where it is and going through the committee stage, and we look at the fact that Bill 33 is contemplating sections of this bill, we know that it's very, very important for us to focus on it, because it may have the capacity of adding teeth to the governance and compliance structure of cybersecurity in Bill 33. So it's very, very important that we look at the interconnectedness of these two bills, especially in as much as needed operational technology area in that area where critical infrastructure lies. Although the bill has, although we don't know how the bill is going to necessarily impact on 33 between the absence and of similar legislation in Canada, so we don't know what the impact is going to be, because this is new, this is untested territory. But we know that there's a trend, there is an increasing trend towards increased cybersecurity regulation amongst our international peers. And, having practiced international law for a number of years, I can see the importance of Canadian businesses being prepared. And I think it would be very wise for Canadian businesses to be prepared. And so contemplation of this aspect of the bill and how it will be infused in Bill C-33 is very, very important at this time. Now, Canada does not have a overarching governing cybersecurity legislation, let alone requiring the reporting of vulnerabilities in critical infrastructure breaches, which is very, very problematic, extremely problematic. But Bill C-26 would empower some regulators to impose fines and or issue some summary convictions to ensure governance and compliance. And this is something that my colleague, Mr. Couric, spoke about, and it's critical to turn our minds to that, especially as we contemplate this bill. Now, back to Bill C-26, in its current form, it includes 4 critical infrastructure sections, which I think are related to the transportation aspect of Bill 33. Now, these are the same when we look at the transportation corridors that are contemplated in Bill 33, we'll see that Bill C-26 it's very important to look at these 4 critical infrastructural sectors, and that's telecommunications, finance, energy, and transportation. So the requirement for organizations in these sections are, they're threefold. First is to implement and maintain and report on the cybersecurity program, which will essentially address the risks across organizations. It'll address the risk in third-party services. It will address the risk in supply chains.
My sincere apologies. It looks like we've reached our limit for this evening. I want to take this moment on behalf of the committee to thank our witnesses, joined us in person and online, of course, for the extended hours they've provided to us, as well as our clerks, our support staff, and our interpreters who also stayed late and gave us 7 hours today. I also want to take a moment finally to thank all of members of this committee for some good work that I think that we did this fall session. And I look forward to the good work that awaits us in the new year. And with that, this meeting is adjourned.